Don't argue. ನೋಡೋಣ ವೆಕೆಟಿಂಗ್ ನೋಡೋಣ. Yes, solve. What's the urgency today? No. ಏನ್ ಮ್ಯಾಟ್ರು? ಏನ್ ಮ್ಯಾಟ್ರ್ ರೀ? ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? They're trying to evict you. Who are you? Anatra Jakupanta. Your application is pending. To consider, or will have it on Monday. Third Monday account. Ensure that it is listed on Monday. Yes. Monday. But a civil appeal is there. Monday will list. Either Monday Monday. Please see that it is listed. Monday. Preliminary. Already. What's the urgency? I told order. Or disabled. What do you want? You want it to be listed? No, date is assigned. Yesterday date is assigned. Audit the preliminary ನೋಡೋಣ.
Fresh matter tomorrow, day after tomorrow.
Order, please hand over memo. Why you're mentioning? Huh? Not reflected in the cause list. Third in order. Being spoke. Audit. Courage. No,
Petitioner lots is the purchaser lots of the land. Was bearing survey number 7 to an extent of 1 acre 30 guntas. Lots from lots 1 Bommegowda. Bommegowda was initially lots registered as a permanent tenant lots and in the year 1965. Lots annexure D lots is the endorsement to that extent lots wherein the subject land was lots granted was registered in his name as a permanent tenant. Lots the respondents 4 to 5 lots claim that they have purchased these lands plots from the Inamdar. Lordship, candidate base 13 lots is the lots the endorsement issued not
So
to.
you are registered as a occupant, huh?
Yes, lots.
Under Mysore Inam side.
Yes, lots. And
Whether occupancy rights Any further order is required once you are registered as an
Lots
occupant?
the endorsement is also issued lots to that extent, lots that now what has happened, lots the respondent 4 to 5.
Inamdar, whether there is a regrant order in favor of.
No, lots that has also been rejected, lots. I produced the copy, lots.
There's no regrant order. in
No,
favor.
lots that is rejected, lots. Annex
Private
L
respondent is tracing right through Inamdar.
through the Inamdar. Now
So there is
DC,
no regrant order.
yes, no, DC says you go to civil court and determine a title. It is the revenue authorities who has to decide, lots.
All right, based on that order,
Lot.
1965 order,
Lots.
your name is mutated to.
My
the-
name was mutated. Subsequent to their lots purchase, their names were mutated, lots. That is the respondent's name were mutated.
Yavaga.
I'm not in, not subsequent to their sale, lots, it was mutated.
What is the date?
I'm sorry, to that extent, I'm extremely sorry, lots. That information is not.
Who
In
filed an appeal?
the order of the assistant commissioner, lots, he endorsed. ನನ್ನ ಹೆಸರು ನನ್ನ grantee ಹೆಸರನ್ನ round off ಮಾಡಿದ್ದಾರೆ ಅಂತ it at page 49. The earlier the grantee's name was there.
First time ಯಾರು ಪ್ರಿಫರ್ ಮಾಡಿದ್ದು mutation ಅನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದ?
I preferred in 2004, not before the assistant commissioner, questioning the entries made in their favor. Not that, not the assistant commissioner holds. He holds it in my favor and remands it to the Tahsildar. Tahsildar again holds the same thing. He's saying that no, I am not entitled to. They are the owners of the land. Then, lots I challenge it in an appeal before the assistant commissioner. Then assistant commissioner also holds in against me. I was before the deputy commissioner. Deputy commissioner holds. You have to go to civil court.
He's such a, yes, such as assistant commissioner.
Yes, lots. They asked me, redirect me to go to the civil court. I say, lots, this dispute is to be decided by the revenue authorities, lots, that whether the grant is correct, whether the purchase of theirs is correct in view of the Inamdar, lots, is no more in, lots. His application was for occupant also rejected.
Or court.
It confirm the order of the assistant.
Huh?
It confirm the order of the assistant.
ಯಾರು?
This,
Yes, confirmed.
while confirming, he says you go to the civil court.
ಅಲ್ಲ, but what assistant commissioner, what is the order of the assistant commissioner?
Assistant commissioner also says that, lots, the revenue entries in favor of the, lots, purchaser from the Inamdars, that is respond 4 to 5 has to continue.
Continue.
Yes.
And what document you have produced to show that,
No, annexure D, lots, is the grant. And my application is also produced.
annexure D?
Annexure D, lots, at page 30, lots, is the endorsement. 7 acres, 4 acres, 32 guntas is granted. My application is also, lots, I have produced. In fact, lots, the application of the Inamdar, lots, for registering him as an occupant is rejected. Annexure L, lots.
Occupant and ಖಾತೆದಾರ ಅಂತ ಆರ್ಡರ್ ಆದ್ರೆ ಏನ್ರಿದು? This is enough. Is the endorsement annexure D is enough? Anything more is required to be done by the Tahsildar once there is a order registering him as an occupant under personal miscellaneous Mysore Personal and Miscellaneous Inams Act, Section 5 ಕೆಳಗಡೆ is registered as an occupant. Section 5.
Section.
Collect the revenue, it's land.
Land tribunal ಆದ್ರೆ ಮೊದಲು order ಆಗಿ then followed by form number 10.
Please,
Under this act, how it is done? Now he is ordered to be registered as an occupant. He is found to be tenant.
yes, we will get the
There is,
instruction.
there is an order. ಅಲ್ಲ,
I will check the
take
instruction.
instruction ಅಲ್ಲ, ಹರೀಶ್.
ಅಲ್ಲ ಅವ್ರ ಹತ್ರ ಏನಾದ್ರು will.
He is registered to be an ordered to be registered as an occupant under section 5.
Section.
Section 5 ತಗೊಳ್ರಿ.
Nam abolition.
Permanent tenant to be registered as occupants on certain conditions. Shall with effect on from the date of vesting be entitled as an occupant in respect of all lands of which he is a permanent. In addition to.
Clause 2, subclause 2. In addition to the annual land revenue payable in respect of the land, the permanent tenant is entitled to be registered
Premium
as an
for
occupant.
acquisition of. Premium ಕಟ್ಟಿದ್ದೆಲ್ಲಿದೆ ನೀವು?
Not- ಅದಿಲ್ಲ. Not having
Premium
that, not,
ಕಟ್ಟಿದ್ದೆಲ್ಲಿದೆ?
the assistant commissioner lots records the finding that the name of the lots occupant was registered. Page 49 lots he registered.
ಪ್ರೀಮಿಯಂ ಕಟ್ಟಬೇಕಲ್ರಿ, ಅದಕ್ಕೆ ಕೇಳಿದಿಲ್ಲ.
Lots, he records a finding lots at page 49 lots, the assistant commissioner on the basis of the documents he registered.
Registered deeds, my lord, sale deed and gift deed, my lord.
Huh?
There are two registered deeds, my lord.
That
Sale
is it.
deed, one sale deed and registered gift deed. That page number 17, while observing Deputy Commissioner order.
ಅದರಿ ಇನಾಮದಾರ ಹತ್ರ ತಗೊಂಡಿದ್ರು ಅವರು. ಇನಾಮದಾರ ಹೇಗೆ ಮಾಡಕ್ ಬರುತ್ತೆ? When there is a tenant and he has not sought re-grant, there is no re-grant order in favor of him. ಬರ್ಕೊಡ್ರಿ. Are the counsel for petitioner and learned AG appearing for respondents. Respondents 1 to 3. Petitioner. Counsel for petitioner has placed reliance on Annexure D, which is an endorsement. Endorsement issued by Special Deputy Commissioner for Inams. Citing the said endorsement, counsel appearing for petitioner contends that petitioner father
Petitioner's not vendor. Petitioner has purchased it from her.
or petitioner's vendor was registered as an occupant of the petition land under section 5 of Mysore, Pastor and bracketally P&M, bracket complete Inams Abolition Act 1954. Private respondents, petitioner hearing has purchased the land, petition land,
Small extent, 1 acre 30 guntas.
has purchased a portion of the land measuring
1 acre 30 guntas.
1 acre 30 guntas under registered sale deed dated 15/5/1970.
70.
Private respondents are asserting title through the Inamdar, through Inamdar. Perusal of the endorsement, it presupposes that the land being an Inam land, admittedly being, the petition land admittedly being an Inam land, stood vested with the state. And petitioner's vendor was entitled to get registered as an occupant. Rightly moved an application and there is an endorsement indicating that petitioner's vendor was registered as an occupant of the petition land. Assistant Commissioner and Deputy Commissioner have relegated petitioner to civil court. This court needs to examine whether the revenue authorities erred in relegating the petitioner when he is tracing title based on a registered sale deed, which is preceded by an order of a special deputy commissioner under Inams conferring / registering petitioner's vendor as an occupant of the petition land. Matter requires consideration. For the reasons stated supra, the execution and operation. Idin stay ಮಾಡಿದ್ರಿ ಏನ್ ಸಿಗ್ಬೇಕು ನಿಮ್ಗೆ?
Now they have got their names entered in the mutation.
Based on this order?
Yes, yes.
The input order dated 5/1/24 passed by first respondent as per Annexure A is stayed till next date of hearing. Issue emergent notice to respondents
4 and 5.
4 and 5.
Petitioner, my lord. The respondent have challenged the MR in which the petitioner legal heirs are in the possession of the property bearing survey number 17.
Huh?
Synopsis, my lord. Survey number 17 to the extent of 5 acre 25 guntas were originally belongs to Timmegowda, my lord. Thereafter, after the demise of Timmegowda, the Puttegowda and Javaregowda who possessed the property and the survey number 17 5 acre 25 guntas put in the joint name of the Puttegowda and Ramegowda. Simple synopsis, my lord. Sir. Sir. What of sir? And mutation entries are made in favor of the Puttegowda and Ramegowda as per MR 4/88 and 89. and said mutation entries has been challenged by the respondent belatedly after lapse of 21 years. After demise of Puttagowda, Javarayagowda with the father and grandfather of the Krishnagowda. Next year G may kindly prove.
ಇದು ಎಕ್ಸ್ಟೆಂಟ್ ಏನಿದು ಪಾರ್ಟಿಷನ್
ಇಲ್ಲ. It is for the family arrangement, they have separate mutate the revenue entries in their respective names. Annexure G may kindly peruse, my lordship, page number 28. In which Puttagowda owns the land to the extent of 2 acres and Ramegowda, who is the son of the Puttagowda,
No, now 1977 sold it.
1977 sale deed is the respondent claimed to be the owner of the property through the 1977 sale deed. Thereby they acquired the property to the extent of 2 acre 20 guntas. And the mutation entries was challenged after lapse of 21 years by the original vendor of the legal heirs of the original vendor. That is Ramegowda. And the assistant commissioner, which is reallocated the extent of land which is stands in the name of the petitioner herein. Kindly peruse on page number 34, my lords. As per the RTC extract, 1 acre 32 guntas, 1 acre 32 guntas was stands in the name of Puttagowda and Ramegowda, who are the sons of Javarayagowda. And
Private respondent is pressing title through Krishnagowda and Puttagowda.
Puttagowda.
Both together have executed sale.
Krishnagowda and Shivegowda.
Puttagowda.
Shivegowda, Ramegowda.
Krishnagowda, Shivegowda. The property originally stands in the name of Puttagowda and Ramegowda. And claims to be the owner of the property and the basis of the sale deed executed by Krishnagowda and Shivegowda. As on the date of execution.
There is a sale deed mutation has to be effected. Your remedy is to go and file a suit.
Krishnagowda, Shivegowda, they are not the, no property was stands in the name of the Krishnagowda and Shivegowda as on the execution of the sale deed, my lords. The entire property was stands in the name of the Puttagowda and Ramegowda. As per the RTC extract, may kindly peruse, my lordship, annexure G, my lordship. The no property was stands in the name of Krishnagowda and Shivegowda as on the date of execution of the sale deed.
What is the total extent? 5 acre 20.
5 acre 25 guntas, my lords.
They together have sold 2 acre 20 guntas.
2 acre 20 sold by the Krishnagowda and Shivegowda.
But how it matters if their name is not found in the revenue records?
My contention is,
Partition suit hakri.
I make one submission, my lords.
77 sale deed re.
Sale deed survives. I am not disputing that, my lordship. One Puttagowda is no more. To the extent of 2 acres is allotted in the name of the Puttagowda. It is retained by in the name of the Puttagowda as it is. But without allocating that property belongs to the Puttagowda, the property belongs to Ramegowda and Puttamma. Their property was adjusted towards the Ningegowda.
ಇದೆಲ್ಲ ಎಲ್ಲಿ ನೋಡಕ್ ಬರುತ್ತೆ ಇದು ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್ ಇದೆ they will enter the name.
As per the resale sale deed also,
ನಿಮ್ದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ it involves complex civil dispute that can't be examined under revenue proceedings. There is a registered sale deed, extent is reflected, they have entered.
if the extent is reflected, they have to enter
But you have
the
no
land
challenge.
belongs to the Puttagowda in favor of the purchaser. When the Puttagowda is no more and other remaining parties are the legal heirs of
Relations are not in dispute.
relations are not in dispute, my lords.
Whether they had a right to sell to that extent, you have to file a suit, which you have not done.
And they are creating the third party right on the my property, which is allotted stand in the name of the.
File appropriate suit. There is a threat to your title and possession.
Yes.
Can't work it on invitation proceedings.
And
Correct.
mutation entries are challenged belatedly after lapse of 21 years, my lordship.
ಅದು ಅವ್ರ ಡ್ಯೂಟಿ ಅದು
Sir,
mandatory
21
duty.
years, after
Day form.
21 years also, my lord,
ಡೇ ಫಾರ್ಮ್ ಹೋಗಿರುತ್ತಲ್ಲ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸ್ ಇಂದ
they have not
ಅವ್ರ
done it.
ಕೆಲಸ ಅದು ಮಾಡಿಲ್ಲ ಅವ್ರು.
ಮಾಡಿಲ್ಲ.
And this has led to litigation. And why kept quiet? You have not challenged the sale deed. You need not challenge also. You should have simply filed a suit.
ಅಲ್ಲ ಮೈ ಓನ್ಲಿ
ಅವಾಗ
ಎಂಡೇವರ್
ಗೊತ್ತಿಲ್ಲ, ಅವಾಗ ನಿಮ್ಮವರೆಲ್ಲ ಒಪ್ಕೊಂಡಿರ್ಬೇಕ್ರಿ, ಅವಾಗೆಲ್ಲ ಕನ್ಸೆಂಟ್ ಇರುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ. And in the
ಅದೇ
before the AC
ಜಮೀನ್
court also that Krishnagouda and Shivagouda not parties before the AC court and DC court. They are not.
ಮಾರಕ್ ಆಗಲ್ರಿ, ಹೊಲ್ದಾರೆ ಜಮೀನ್ ಮಾರಕ್ ಆಗಲ್ಲ. ಅವಾಗ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಇರ್ತೀರ. We don't know, you file a suit, no. Now what assistant commissioner has done?
Assistant Commissioner, page number 34, my lords,
ಹಾ,
last portion. ಮೇಲ್ಮನವಿನ ಪುರಸ್ಕೃತ ಹಾಸನ ತಾಲೂಕು ಕಟ್ಟಾಯ ಹೋಬಳಿ ಕುರದಲ್ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 17 1 ಪ್ರತಿವಾದಿ 32 ಅಂದರೆ ಒಟ್ಟು 3 ಎಕರೆ 25 ಗುಂಟೆ ಪೈಕಿ 2 ಎಕರೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ತಹಸೀಲ್ದಾರ್ ಹಾಸನ ತಾಲೂಕು ಮುಟೇಶನ್ ಆದೇಶ ದಿನಾಂಕ 6 ರದ್ದುಗೊಳಿಸಿದೆ. ಸದರಿ ಜಮೀನಿನ ಮೇಲ್ನಗರ ಕೆಳಗಂಟೆ ಕೋಷ್ಟದಲ್ಲಿ ವಿವರಿಸಿದ ಹಕ್ಕು ಬದಲು ದಾಖಲಿಸಲು ಆದೇಶಿಸಿದೆ. They reduce the extent which is allotted stands in the name of Ramegowda and Puttagowda, my lords. That has been reallocated to the Ningegowda. If they have done the property which is belongs to Puttagowda, then they have these petitions have no grievances, my lordship.
ಅಲ್ಲ ಸರ್ವೆ ನಂಬರ್ ವಿ ಡೋಂಟ್ ನೋ, ಚೆಕ್ ಬಂದಿನೂ ಹಾಕಕ್ ಬರಲ್ಲ. ಓನ್ಲಿ ಎಕ್ಸ್ಟೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ರಿಫ್ಲೆಕ್ಟೆಡ್.
ಅಲ್ಲ Puttagowda extent ಆಗಿದ್ರೆ we have no grievances, but they have now allotted the share of the Puttagowda to the purchaser.
ಅಲ್ಲ ನಿಮ್ಮಲ್ಲೇ ಇದು ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲಲ್ಲ,
ಇನ್ನು partition ಆಗಿಲ್ಲ.
ನೀವು ಸ್ಪೆಸಿಫಿಕ್
ಆಗ್ಲಿಲ್ಲ.
ಪೋರ್ಷನ್ ಕೇಳಕ್ಕೂ
ಮತ್ತೆ
ಬರಲ್ಲ.
ಪುಟ್ಟೇಗೌಡರ ಮಗ ಜವರೇಗೌಡನ ಮಕ್ಕಳು 4 ಜನ ಸೇರ್ ಮಾರಿದ್ದಾರೆ ಅಂತ ಇದೆ.
ಅಲ್ಲಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ Krishnagouda,
deed.
Shivagouda is the
ಓ ಪುಟ್ಟೇಗೌಡ
ಮಗ ಜವರೇಗೌಡ
ಜವರೇಗೌಡರಿಗೆ
4 ಜನ
there are
ಮಕ್ಕಳು,
four
4 ಜನ
sons.
ಮಕ್ಕಳು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ 1977 ಅಲ್ಲಿ. ದೇರ್ ಆರ್ ಆಲ್ಸೋ ಪಾರ್ಟಿ ಇನ್ ದಿ
ಇಲ್ಲ force and ಮಾಡಿಲ್ಲ. Krishnagouda and Shivagouda own the property.
ಮಲಡ್ 43 ಮಲಡ್ ಪೇಜ್ ನಂಬರ್ 43 ಮಲಡ್
ಐ ಪ್ರೊಡ್ಯೂಸ್ ದ ಸೇಲ್ ಡೀಡ್ ಬಲ್ದಾರೆ
ಪೇಜ್ ನಂಬರ್ 43
Yes,
ಮಲಡ್
sir.
43 ನಾ?
ಪ್ಲೀಸ್ ಮಲಡ್. DC has
Sale deed ಇದೆ ಸ್ವಾಮಿ.
gone through the entire thing ಮಲಡ್.
ಇಲ್ಲ.
ಎಲ್ಲಿದೆ?
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮಲಡ್. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ
Sale deed, sir. Sale deed ಇಲ್ಲ, sale deed.
ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ
ಅಲ್ಲಿ ಕೊಡಿ, ಅಲ್ಲಿ ಹರೀಶ್ ಕೊಡಿ. ಹರೀಶ್ ಗೊತ್ತು.
Only the Krishnagouda and Shivagouda are parties to the sale deed. Other remaining brothers are not parties to the sale deed.
ರಾಮ ಸರ್ವೆ ನಂಬರ್ 17 ರಲ್ಲಿ
ದಾಖಲೆ ಆಗಿರು. ಪುಟ್ಟೇಗೌಡ ಬಿನ್ ತಿಮ್ಮೇಗೌಡ ಅವ್ರ
ಪ್ಲೀಸ್ ಮಲಡ್.
ಜಮೀನು, ಪುಟ್ಟೇಗೌಡ ಅವರ ಮಗ ಜವರೇಗೌಡ,
ಸದರಿ ಜವಡೇಗೌಡರಿಗೆ 4 ಜನ ಮಕ್ಕಳು.
4 ಜನ ಮಕ್ಕಳು, ಕೃಷ್ಣೇಗೌಡ, ಪುಟ್ಟೇಗೌಡ, ಶಿವಗೌಡ, ರಾಮೇಗೌಡ.
ಪೈಕಿ
5 ಎಕರೆ ಪೈಕಿ ಮೇಲ್ಕಂಡೆ 1ನೇ ಕೃಷ್ಣೇಗೌಡ ಮತ್ತು 3ನೇ
ಶಿವೇಗೌಡ, they are all-
ಸೇರಿ
ಸೇರಿ
ಒಂದನೇ
ಮತ್ತೊಂದು
3
ಮೂರನೇ
ಪ್ರತಿವಾದಿಗಳಿಗೆ
ನಿಂಗೇಗೌಡರಿಗೆ.
They only the
ಇಬ್ರು
2 person,
ಪ್ಲೀಸ್.
ಇಬ್ರು ಬೇರೆ.
not other family members.
So they have directed to mutate their name in terms of sale deed.
Yes, ma'am.
Correct?
Yes,
Yes,
my
ma'am.
lords.
ಬರ್ಕೊಡ್ರಿ.
ಅಲ್ಲ my grievance is my lordship.
It will not affect, that sale deed will not bind you, but you should challenge it in the manner known to law.
Yes.
77 sale deed.
That observation could be made, my lords.
All
Because the major extent of the share is allotted to Puttagowda, that is not disturbed by the revenue authorities. It is retained as it is.
Assistant Commissioner allowed the appeal.
Allowed to cancel the mutation entries
Tell them
and
to-
retain the Puttagowda property as it is. And the property which is allotted in the name of the Ramegowda and Puttama has reduced to some extent, and same land is allotted to the
No.
Ningegowda, who is the purchaser of the
Done it that
property.
way. Now the purchaser's name is mutated to the extent of 2 acre 20 gunta.
2
based
acre,
on some.
by reducing the extent of land which is stands in my name,
All right, ಬರ್ಕೊಡಿ.
but not the Puttagowda has continued to the extent as it is.
Petitioners who are the lineal descendants of one late Javaregowda are aggrieved by the orders passed by third respondent assistant commissioner and second respondent deputy commissioner, wherein the revenue authorities taking cognizance of the sale deed executed by one Puttagowda and Shivagowda,
ಅಲ್ಲ Krishnagouda and Shivagowda ಮೇಲೆ.
one Krishnagowda and Shivagowda. Shivagowda has ordered to mutate the name of private respondents to an extent of 2 acre 20 guntas based on a registered sale deed dated 24/2/1977. These 2 concurrent orders are under challenge by the present petitioner's hearing. Next, the counsel for petitioner, learned AG is directed to accept notice as order sheet al barli 1 to 4. Peruse the records. Before I delve upon the orders passed by the Third respondent assistant commissioner in a mutation proceedings, this court deems it fit to refer to the family tree which is placed on record by the council appearing for petitioner. Family tree is extracted, same is as under. Next. One Javare Gowda had four sons, namely Krishna Gowda, Putte Gowda, Rame Gowda, and Shive Gowda. The private respondents ಯಾರು ಪರ್ಚೇಸ್ ಮಾಡಿದವರು 5 to 7
ಹಿಂಗೇಗೌಡ, their father.
are the children of one Ningegowda. The said Ningegowda has purchased 2 acre 20 guntas in survey number
Survey number
17. 17
70 to the extent.
totally measuring 5 acre 25 guntas. Under registered sale deed dated 24/2/1977. Petitioner contends that the impugned orders has virtually led to reduction in extent held by the petitioners herein. Feeling aggrieved by the orders passed by assistant commissioner and deputy commissioner, this caption petition is filed. Next, on examining the records, it is clearly evident that the two sons of Javare Gowda, namely Krishna Gowda and Shive Gowda, have sold 2 acre 20 guntas under registered sale date dated 24/2/1977 to one Ningegowda, who is the ancestor of respondents 5 to 7. The revenue authorities under section 128 of Karnataka Land Revenue Act are under mandatory duty to effect changes in the RTC, land revenue, in the RTC, wherever acquisition of right is reported to the revenue authorities. Respondents are seeking mutation in their favor based on a registered sale deed obtained by their father. Assistant Commissioner, by taking cognizance of the registered sale deed obtained by the private respondent's ancestor, namely Ningegowda, has accordingly set aside the mutation in favor of petitioners, and a fresh mutation is certified, reflecting the alienation made by two sons of Javare Gowda, namely Krishna Gowda and Shiv Gowda. The present petitioners are legal heirs of Putte Gowda.
Yes, my lord.
Putte Gowda Matrana, Rame Gowda,
Puttegowda and Ramegowda, my lord.
and Rame Gowda, who are not party to this
Sale deed.
Sale deed. Under section 127 and 129, the power and jurisdiction of revenue authorities is quite limited and restricted. The revenue official authority are under obligation to effect changes whenever acquisition of right is reported, more particularly when rights are acquired under a registered sale deed. Next paragraph. These significant details are taken into consideration. Third respondent assistant commissioner was justified in effecting change in khata by taking cognizance of the sale deed executed by Krishna Gowda and Shiva Gowda. The petitioner's contention that in view of effecting a fresh mutation has virtually reduced their legitimate share in the property, which is admittedly ancestral property, cannot be examined in mutation proceedings. Such a recourse is not permissible. If petitioners are aggrieved by the alienation made by Krishna Gowda and Shiva Gowda way back in 1977, they ought to have challenged. They ought to have filed a suit seeking appropriate reliefs in a manner known to law. The reduction of share of petitioners cannot be subjected to adjudication in mutation proceedings. Assistant Commissioner, the order of Assistant Commissioner and the order passed by first respondent Deputy Commissioner does not warrant any interference. However, these mutation will not take away the legitimate rights of petitioner. If petitioners are aggrieved by the alienation made by Krishna Gowda and Shiva Gowda, they are at liberty to file appropriate suit and seek appropriate reliefs. With these observations, repetition stands disposed of. Next. Yes, sir.
For the petitioner, my lords. The petitioner's application for regularization was rejected by the regularization committee in 2012. Thereafter, the same is affirmed by the deputy commissioner. Therefore, this writ petition is being filed.
Appeal
My lord,
Bharata,
Appealable. 50B.
Vinayak, appeal to appellate tribunal.
my lords,
50B.
I have one more submission.
Ah.
Kindly have annexure G.
ಯಾವ್ದು ಸೆಕ್ಷನ್ ಯಾವ್ದು
50B, my lord.
50
B.
1B na bare B.
B.
Annexure,
Annexure G, my lords.
page.
Page 51. This is on equities that have also filed this writ petition. They reject mine in 2012. This is in 2018, my lords. Right side. ಮೂಲ ಸರ್ಕಾರಿ ಆದೇಶ ಬದಲಾವಣೆ ರೀತಿ ಸರ್ಕಾರಿ ಆದೇಶ ಸ್ವಾಧೀನತೆ ರೀತಿ ಮಂಜೂರು ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 15/6/2018.
ಏನದು?
They have, in the very same survey number, they have granted lands to other persons.
No, all right, now we have an appeal.
Lords, I agree, but then
Consistently, we are relegating all the parties. Remedy of an appeal, why you want to come under 227?
my lords, it is only on the ground that I've been there for over 4 decades. My application is
No, no,
dated
you have to-
1998.
ಬರ್ಕೊಡ್ರಿ.
It may,
51B, man. Sorry.
Ah?
51B,
Can.
please. Sorry.
Petitioner is assailing the order of the deputy commissioner passed under 49
But 50, ಇಲ್ಲಿ 50 ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. 50ನೇ ಹಾಕಿದ್ದಾರೆ.
of the deputy
ಪ್ಲೀಸ್
commissioner,
ಮಾಡಿ 50 ಹಾಕಿದ್ದಾರೆ. ಬರೀ 50 ಹಾಕಿದ್ದಾರೆ, ಆದ್ರೆ 50A ಹಾಕ್ಬೇಕಾಯ್ತು ಅಲ್ಲಿ.
50 of the Karnataka Land Revenue Act against the impugned order passed by first respondent deputy commissioner. Petitioner has the remedy of an appeal under section 51B
1B.
of the Karnataka Appellate Tribunal, reserving liberty to challenge the impugned order in the manner known to law. The captioned writ petition is disposed of. The period spent before this court shall be excluded and benefit under section 14 shall be extended to petitioner. If an appeal is filed within a period of 4 weeks from the date of receipt of order copy, registry to forthwith return all original documents after securing photocopies. Yes.
much of it.
Next. Yes, Alva.
Reservoir project.
Huh?
Hemoti
HRP
reservoir
ಇಲ್ಲ.
project.
ಏನಿದು ಮರನಾ ಏನು?
ಇದು
Fraudulent
ಮರ
conduct.
ಮಾಲ್ಕಿ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ.
ಮರ ಮಾಲ್ಕಿ.
ಮರ ಮಾತ್ರನಾ?
Yes, ma'am.
ಎಲ್ಲಿಗೆ? ಹರೀಶ್ ಕೊಡ್ರಿ.
It's covered by the
Alright, ಕೊಡಿ. ಬರೀತಿದ. Caption petition ಬರ್ಕೊಡ್ರಿ. Caption petition is filed assailing
annexure A.
the order passed by third respondent / special land acquisition officer in cancelling the grant made in favor of petitioner in respect of scheduled property on the premises that petitioner, being a grantee, has failed to deposit the value of the
Not
trees.
fixed.
Not
ಅವ್ರು ಮಾಡಿದ್ರಿ. Order says that you have failed to deposit, correct?
ಅಲ್ಲ, ಅವರು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ ವ್ಯಾಲ್ಯೂ ಫಿಕ್ಸ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂತ.
ಯಾರು?
SLO ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋದು ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಇರುವಂತ ಮರಗಳಿಗೆ ವ್ಯಾಲ್ಯೂ ಫಿಕ್ಸ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂತ.
ಅವ್ರು ಮಾಡಿಲ್ಲ, ಅವ್ರು ತಪ್ಪು.
ಹೌದು, it is their fault.
But it is your grant is cancelled on what ground?
On that ground only.
That you have not deposited the value of the tree. ಅವ್ರು ಮಾಡಿ ಅಲ್ಲ.
ಮಾಡಿಲ್ಲ ಡೆಪಾಸಿಟ್.
Your argument is
ಸರಿ.
that is your argument alva. What is this? But had the Leonard counsel appear for petitioner and Leonard AG appearing for respondents 1 to 8. Petitioner is a displaced person who lost fertile agricultural land bearing survey number 53/1. In view of rehabilitation scheme introduced by the state, petitioner was allotted the present petition land in terms of section 71 of the Karnataka Land Revenue Act, in addition to payment of compensation for the lands so acquired. Next, the short point that falls for consideration is as to whether third respondent was justified in unilaterally cancelling the grant without notifying the petitioner. The issue is squarely covered and answered by the coordinate bench in identical set of facts. Para 7 and 8. Next, in the present case on hand, the third respondent has passed the impugned order, which is not preceded by an inquiry. Impugned order, therefore, being in violation of the principles of natural justice, is not sustainable. The relief granted to an identical, a similarly placed grantee by the coordinate bench has to be extended to the petitioner on parity. For the foregoing reasons, this court passes the following order. Writ petition is allowed in part. Impugned order dated so and so is hereby Roman 3 to 6 says.
Next matter also.
Adu same.
Same.
Adu but same. All right, next. Adರಲ್ಲಿ Leonard AGA is directed to accept.
For the petition. The
Yes.
show cause notice is issued under section 94 not by this respondent number 4 special.
Now it was adjourned. Why it was adjourned, Mr. Arba?
But your lordships suggested that I should place photographs that I have left out more broader pathway, my lord,
Ah,
to this
correct.
place. But may I just pass on? not the
Apart from
photo-
existing the 3 feet pathway.
Yes, my lord. More than that, not is what I have given.
Yes, madam, what are your instructions?
Instructions are that, my lord. As per the village map, the road passes through the petitioner's property. If he wants to make use of that property, he has to seek permission from the DC under section 71 to make use of that property and make other alternate road. Without doing so, he cannot make use of the Nakashe Rasta, he cannot make use.
That may I just take notes to the
Ah.
photographs. The
Yes.
first two photographs, my lord, your lordship will see.
ಈಗ
This is
they can use this portion.
It is being used, my lord. He blued across. Now the next page, your lordship will see this red line. I have drawn this red line.
They
both are-
want to cut through your property now.
Yes, my lord, cuts through the property. That's all that I'm.
So
See.
they cover it.
Not,
They can seek permission from the DC under section 71, my lord. Our property madhya hogide andre, they can ask for deviation of the road.
ಇದು ಮಧ್ಯೆ ಹೋಗಿರೋದು private property ತಾನೆ.
ಹೌದು.
Road Nakashe Rasta ಇದೆ.
ಅದೇ ರೀ through private property.
ಅದನ್ನ they can ask for change over, my lord. 71 ಕೆಳಗೆ change over ಮಾಡ್ಕೊಂಡು ಪಥ ಬದಲಾವಣೆ ಮಾಡ್ಕೊಂಡು they could have leave the space.
Well, then we'll dispose of directing him to examine it because they're already structured.
Sir, ಇದೆ small without
ಅದನ್ನ
taking
demolish
any
ಮಾಡಬಹುದು.
deviation from the DC.
And if if he's ready to give up a portion of his property
Yes, madam.
to give access to the surrounding owners, there is the matter, let him examine, but he can't pull down the structure.
He has to make an application.
He will make an application, till then he will not take any administrative action.
Let
Let us
him make
see.
application.
Section 71 ನಾ?
Yes, madam.
ಇಲ್ಲಿ ಯಾರು private parties ಇದ್ದಾರಾ?
Yes, my lord. Private parties are there, my lord. I also came to know about the Tahsildar passing this order only after notice was issued by the honorable court in another writ petition filed by the landowner, my lord.
Similarly owned,
60
adjoining owner,
Similar alla,
adjoining owner.
adjoining owner who says his access is limited.
ಅಕ್ಕಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ ಗಳಿಗೆ ಹೋಗ್ ದಾರಿ ಇಲ್ಲ, ಅದೊಂದೇ ಇದ್ದಿದ್ದು, ಇವರು ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಮೇಡಮ್ ಈಗ
They have to seek permission ಅಷ್ಟೇ,
ಒಂದ್
permission
ನಿಮಿಷ,
ತಗೊಳ್ಳದೆ
ಒಂದ್ ನಿಮಿಷ.
ಬಿಟ್ಟಿದೀವಿ ಅಂತಾರೆ.
ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ ಫ್ರೀ ಎಕ್ಸೆಸ್ ಕೊಡ್ಬೇಕು.
Yes,
ನೀವು ಪಾತ್ವೇನ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಅವ್ರು ಆಕ್ಚುಲಿ ಈಗ ಈಸ್ ರೆಡಿ ಟು ಈಸ್ ವಿಲ್ಲಿಂಗ್ ಟು ಗಿವ್ ಅಪ್ ಲಾರ್ಜರ್ ಪೋರ್ಷನ್.
yes.
ಇಫ್ ಈಸ್ ರೆಡಿ ಟು ಗಿವ್ ಅನ್ ಎಕ್ಸೆಸ್,
Public access ಇದೆಯಾ
ಅದನ್ನ
ಇಲ್ವಾ ಅನ್ನೋದು
notify
verify
ಮಾಡಿ-
ಮಾಡ್ಬೇಕು.
ಹಾ ಅಷ್ಟೇ. ನೀವು ಸ್ಪಾಟ್ ಇನ್
Public access ಇದೆಯಾ ಇಲ್ವಾ ಅನ್ನೋದು ನೋಡಿ.
ಅದನ್ನ ನೀವು ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್.
ಆಯ್ತು. I will accept that.
Counsel for petitioner has filed a memo and has placed on record photographs indicating that petitioner has already left sufficient vacant portion to enable the adjoining owners to have access through this passage, which is in fact owned by petitioner.
Petitioner
Correct,
and
huh?
existing since 1998. This path.
However, as per the village map, the road which runs through petitioner's land, if accepted, virtually cuts the existing structure. Therefore, this court is of the view that to preserve petitioner's property and at the same time, the adjoining owners are given a free access. Learned AGA is required to secure instructions through Tahsildar to examine this open space, whether this open space is feasible and can be utilized by the adjoining owners to have ingress and outgress. To secure a report in that regard, matter is adjourned and ordered to be relisted on the 15 days bit code. Till then, respondent authorities are directed not to take any precipitative actions. Yes.
And also-
please examine and then we'll pass on.
And also, my lord, your lordship could also tag this along with the other writ petition.
We'll
Tag
tag it. All right. Registry is directed to tag this writ petition along with WP number so and so.
I'll just furnish.
ಆಮೇಲೆ ಅರಬಟ್ಟಿ, I want a digital sketch. ಅಷ್ಟೇ ನೀವು ಬಿಲ್ಡಿಂಗ್ ಪಕ್ಕದಲ್ಲಿ ಓಪನ್ ಸ್ಪೇಸ್ ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ, ಹಾಗಲ್ಲ.
ಮೇಲಿಂದ.
ಮೇಲಿಂದ
Bird eye.
I want a digital sketch and we want to see that how that access leads to and where it goes.
I will.
ಅವ್ರನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ annexure H2
ಇನ್ನೊಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿ, ಅವ್ರು ಇನ್ನೊಂದು ಮಾಡಿ, ತಾವು ಮಾಡಿ ಒಂದು ಸ್ಕೆಚ್
ಆಯ್ತು.
ಮಾಡಿ. All right.
That WP number 20366 of 2023.
7.
Grateful.
Yes.
That's survey number 67 of Kannalli village, Yeshwantpur, Hubli, Bangalore North Taluk, my lords, totally measures 9 acres and 18 guntas. OD work, my lords, was done in the year 2014. Then, my lords, this land was assigned survey number 67/5. I purchased, my lords, 2 acres 7.5 guntas.
Converted.
It was converted land. Conversion took place in the year 2015. My lords, certain people, my lords, aggrieved by the PODI, filed an appeal. Appeal, my lords, came to be allowed. The order passed in the appeal, my lords, is challenged before this honorable court. There's an interim order passed staying the operation of that order. Now, my lords, the deputy commissioner, my lords, has issued a notice as to why, based on the order passed in the appeal, why the conversion order should not be recalled.
That is stayed by this.
That is stayed by this honorable court.
Then you could have brought.
I have brought it to the notice of the authorities.
You could have-
Still, they issued a final notice.
ಇನ್ನೊಂದು writ ಹಾಕಿದ್ದೀರಾ?
My
You
lords,
could have moved it same writ. Why you not moved it in the same writ petition? ಇನ್ನೊಂದು writ
this, my lords, is the conversion order by a different authority.
All right,
No.
you said there is already interim order.
Please, my lords, the order is at page 45, annexure D,
Page 45.
page 45 at page 49.
This petition is filed by you.
This petition by the very same petitioner. Here, the deputy commissioner is not a party in this petition.
Now that survey done is stayed.
The PODI, the order for re-PODI and Durast work, my lords, has been stayed by this.
Stayed. And now deputy commissioner wants to
On the
implement.
basis of the very same order, wants to recall the conversion order. The notice, my lords, may kindly see annexure E, page 51.
No. That Duristan Ford is done in terms of conversion order.
Please, my lords. No. PODI and Durasti was done in 2014.
14.
Conversion is in the year 2015. The allegation made by the appellants there are that the PODI and Durasti work was done based on their forged signatures and they have not signed it.
Not signed.
So the deputy commissioner says the conversion order was given subsequent to the PODI and Durasti work. Since that order has now been directed to be redone, the conversion order has to be withdrawn. My lords may kindly see the operative
So he
portion
wants to proceed based on the fresh 40 done,
order to be done.
which was ordered to be.
Order to be done, which is not done so far.
That is already.
That
stayed
is
by-
already stayed by this court.
Work order. Petitioner contains.
But here, my lord.
Ah.
Here is a provision, my lord. It has to be, it is a notice. Let them go before the DC and give a reply. We'll
We have
decide it. my
given
lord.
a reply.
If there is a fraud,
Harish, order stay ಆಗಿದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಅದು stay ಆಗಿದೆ, my lord, but
ಮತ್ತೆ ಆದ್ರೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮತ್ತೆ ಹೇಗೆ ಆರ್ಡರ್ ಮಾಡಿ?
but they are,
First you have to answer. Don't dig it further.
Please.
Your officer has violated the
My lord, it
order
is
and that has
stayed.
led to one more writ petition.
it is stayed, my lord, but here what happened, my lord?
Then how we can act on it? Based on the fresh durasti, which is challenged by him,
Please, my lord.
that is already stayed by this court, and how we can implement that order which is already stayed by this.
Until disposal of.
There
that
are
by
order
Commissioner-
dated 28/8/2023, na?
That my lords is stayed, my lords.
Huh?
That order is stayed, my lords.
Where there is an order to redo the.
Redo the Podi and Durasti work.
For quadri. That order was passed by whom? Assistant Commissioner?
That order, my lords, was passed by the joint direct,
I'll respond number 3.
DDLR, my lord.
For quadri. Petitioner is agreed by the notice issued by second respondent deputy commissioner. As per annexure,
E and
G.
G, my lords.
E and G. Petitioner contains that deputy commissioner lacks jurisdiction to implement the fresh Podian Durasti done, carried out by technical assistant to deputy commissioner and deputy director of land records. Full stop. He would bring to the notice of this court that the order which now deputy commissioner intends to implement is stayed by this court in WP number 28304 of 2023. Peruse the order passed by this court. Peruse the interim order granted by this court. Prima facie, the impugned show cause notice. Show cause notice or a notice?
The
Notice.
impugned notice
Notices.
and final notice.
Impugned
Final
notice is indicating that
Within 7 days.
order dated 28/8/2023, passed in appeal number 315 and 67, will be implemented. Appears to be in contravention of interim order granted by this court. If the orders are stayed, appears to be contrary to the orders interim order granted by this court, therefore matter requires consideration. For the reason stated supra, what has to be stayed now?
The notice and the notices at annexure E and G have. to
E
be
and
stayed.
G.
These notices, the impugned notices issued by second respondent as per annexure E and G are stayed till next date of hearing. Learned AG is directed to accept notice to respondents
1 and 2 months.
1 and 2.
That-
Registry to tag this writ petition along with WP number.
It has to be.
One
Tag
second,
with
just hold on. Along with WP number so and so. Yes, Satish?
Therefore, the petitioner, Lord, the petitioner is the owner of land, Lord, measuring 8 acres, 10 guntas. Lord, mutated in the name of my Lord, my father, Venkatram Dikshit, my Lord, which is at page 38. Lord, the grant order is also at, my Lord, page annexure C, my Lord, page 40.
Yes.
Lord, thereafter, my Lord,
Yes, 10 guntas is granted to your father.
yes, 8 acres, my Lord, 4 acres plus 4 acres, 10 guntas.
Ah.
Lord, I approached the Lord Assistant Commissioner. Lord, Assistant Commissioner passes an order on 25/11/2022, page 73,
Approach under what provision?
at 136(2), my Lord. Yes,
Ah.
Lord,
Why Tahsildar refused to mutate your name.
yes. Lord, in the Lord manual RTC, my Lord, my father's name appears. Therefore, in this subsequent year, where computerized Lord RTC has come, my Lord, my father's name was not shown. With those facts, my Lord, page 73, order is passed, allowed my appeal,
Lord.
and directed that, my Lord, to mutate the name of the petitioner. Petitioner is the sole daughter. My Lord, against that, Lord, an appeal is preferred before the deputy commissioner by the private respondents. Lord, in the entire order, deputy commissioner gives finding in my favor. However, my Lord, has set aside the order, and matter is remitted back to the assistant commissioner for fresh consideration without assigning any reasons. But in the entire order, Lord,
And what is their right in the property?
Lord, the civil suit is pending, which
So
is,
who are they? Who are they? Are they
But-
related to you?
no, they are not related to me.
We are grantees, my lord.
You are also grantees.
Yes,
They claim that, my Lord, they are also grant.
Same survey number.
same property. My lord, survey number 30, my lord, measures totally 150 acres. We are grantees in the year 94, 95.
Auru?
He claims from near 1964.
Correct.
It was not at all acted upon, but we are not disputing it. There are several litigation before this honorable court. My lord, this honorable court directed Deputy Commissioner to consider as there is a cloud in the claim of all the grantees. Therefore, my lord, I have pointed out, my lord, that there are, what had happened, my lord, we are based on that alleged manual entry, but our contention is there was no grant. If at all there was a grant, it should have been acted upon. It was not acted upon.
What do you mean acted upon? How it is to be acted?
My lord, if it was 1964, my lord, it should have been mutated in the revenue record.
It is,
It was
My lord, I will point out, my lord, in the year 1964, they claimed that it was granted. In the year 1982, my lord, before Saguvadi chit issued, MR has been entered as per the own records, my lord, as per Annexure C.
No, your grant is in 1994.
1964, they claimed that it was
Your grant is when? Nim grant yavaga?
Nam grant 93, 94, my lord.
The subsequent grant.
No, my lord, according to us, there was no grant.
No, it is for the authorities to decide.
Therefore, my lord, the Deputy Commissioner directed Assistant Commissioner, my lord, in the annexure, this honorable court.
Mr. Counsel, under mutation proceedings, this cannot be examined.
Correct, my lord. Now, the Deputy Commissioner, my lord, has directed Assistant
And
Commissioner.
what is the suit you have filed for? What relief you have sought?
Lord, I have filed suit. I'm
What
sorry.
is it?
Lord, I have filed.
Our suit is also pending. His suit is also pending. Lord, in that suit, he sought a declaration. Lord, he failed to obtain a temporary injunction. The trial court refused.
We are not examining possessory.
Right, my lord. But we are in possession. We are constructed the house. That is what, my lord, I would like to bring to your lordship notice. But we are grantees. We have been in possession with having a residential house. My lord, for this honorable court, my lord, as per annexure,
Lord, on,
in page 92, my lord. In page 92.
Although, my lord, before AC is not a party, therefore it has been remanded back to AC, my lord. We revisited the matter. Therefore, it has.
My lord,
been
apart
remanded.
from that,
He is not a party. Therefore, it has been remanded back to AC.
What's your father's name, Satish?
Venkatram Dikshit, my lord.
Huh?
Venkatram Dikshit.
Venkatram.
Yes. Lord, may I request my lords to kindly come to my lord page 38.
92, my lord, in page 90.
Just a minute, I'll hear you.
Please.
Lord,
In page?
page 38. Lord, mutation is made, my lord, in the year 1964.
80, sir.
Page 39.
Yes, 38.
Venkatram Dikshit.
Venkatram Dikshit. Thereafter, my lord, page 40 is the grant certificate. 31/12/1980. Then, my lord, my learned friend's contention that it is not acted upon may not be correct. But if Annexure C, page 40 is the grant certificate. Thereafter, my lord, kindly come to Lord RTC at page 53. Right from 82 till date, my lord, my father's name is shown. Admittedly, my lord, my father's name is shown.
We are not admitting.
No. You can't. You have no locus.
Lord,
It is
one
much prior, sir.
Lord, if he has, Lord, if he wants to differ with my submission, Lord,
What is the suit? Suit is for what?
Lord, suit for a declaration that, Lord, page 94. My lords may kindly come to, Lord, page 97.
Allah, from this annexure G,
Yes.
your father's name was shown based on the grant.
Lord, page 53. Lord, column 9, my father's name is shown. Right from, my lord, 82 onwards till date, even till today, my lord, it is shown Venkatram Dikshit. He is no more, my lord. 82, my lord, he died.
Then why you filed an appeal?
In the computerized, my lord, RTC, my name is to be shown. My father's name is shown, my lord, which is at, my lord, kindly come to, my lord, page 73. Order passed by the Assistant Commissioner. Assistant Commissioner says that I have perused the grant certificate, but page 73, my lord. Order is passed on 25/11/2022.
Page 73.
Yes, my lord. Kadat, para 4. ಕಡತದಲ್ಲಿರುವ ಲಭ್ಯ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಈ ಕೆಳಕಂಡ ಅಂಶಗಳು ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಚನ್ನರಾಯ ಪಟ್ಟಣ ತಾಲೂಕು ನುಗ್ಗೇಹಳ್ಳಿ ಹೋಬಳಿ ಕೆ ಚೌಡೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ ಜಮೀನು ವೆಂಕಟರಾಮ್ ದೀಕ್ಷಿತ್ ಬಿನ್ ಕೃಷ್ಣಪ್ಪರವರಿಗೆ ವಿಶೇಷ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ದರ್ಖಾಸ್ತ್ ಜಮೀನುಗಳ ವಿಲೇವಾರಿ ಹಾಸನ್ರವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ರಂತೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. Then, my lord, he assigns, my lord, I am not saying that, my lord, he has passed a detailed order. Some reasons are assigned. Lord, ಮೇಲ್ಮನವಿಯನ್ನ ಪುರಸ್ಕರಿಸಿದೆ. ಚನ್ನರಾಯಪಟ್ಟಣ ತಾಲೂಕು ನುಗ್ಗೇಹಳ್ಳಿ ಸೋನ್ಸೋ ವೆಂಕಟರಾಮ್ ದೀಕ್ಷಿತ್ ಬಿನ್ ಕೃಷ್ಣಪ್ಪ ಹೆಸರಿಗೆ ಹಕ್ಕು ದಾಖಲಿಸಲು ಆದೇಶಿಸಿದೆ. In the computerized, page 75, order of the assistant commissioner is carried out, implemented. My father's name in the computerized RTC is shown. Not thereafter, not page 81, RTC also indicates not 8 acres 10 guntas, not Venkatram Dikshit.
ಎಲ್ಲಿದೆ ಅದು?
81 ಸ್ವಾಮಿ.
ಇದು ಕಂಪ್ಯೂಟರೈಸ್ಡ್ ಇದರಲ್ಲಿ.
Yes,
81.
81. Last entry. Lord, it is not, Lord, for a moment, my lord, it is not a stray entry. Right from 83 to till date, my lord, my name is shown.
Yes.
Lord, I can understand in between stray entries are made. Lord, thereafter, my lord, there was no interim order granted, my lord, against the order of the assistant commissioner, annexure M. Lord, the private respondents preferred an appeal. In the appeal, my lord, there was no interim order granted by the deputy commissioner. Against non-grant of interim order, Lord, private respondents approached this honorable court. Lord, I had also filed a writ petition for expediting the Lord proceedings. Annexure Q, page 83.
Both were connected.
Yes, my lord. This honorable court said, since appeal is pending, I cannot pass any orders on the orders. Appeal is pending before the deputy commissioner. My writ petition is disposed of, and in the writ petition filed by them, direction is issued to conclude the proceedings within a period of 6 months, my lord. Lord, page 92 is the order.
Yes.
Thereafter, my lord, my lords asked the pendency of suit. Annexure R, my lord, page 94 is the plain. Lord, para 3, Lord, I have specifically pleaded, para 2, my lord, I am sorry. I have specifically pleaded that I am in.
Your suit. This is your suit.
Yes, it is my suit.
For declaration and injunction.
Declaration and injunction.
ಅವರು ಒಂದು ಸೂಟ್ ಹಾಕಿದಾರ?
Yes, ma'am. We all filed a suit.
My lord, what I am,
Injunction is
today,
granted
my
in
lord,
our
what I am saying. Lord, I forgot to, my lord, bring it to your lordship's notice. The impugned order passed by the deputy commissioner. Lord, I would say, Lord, finding is in my favor. Lord, kindly come to the impugned order, page 36.
Now he has remanded back, huh?
Yes,
my
ma'am.
lord. Lord, page 36, my lord, last but one paragraph. Till then, my lord, it is narration of facts. 1ರಿಂದ 8ನೇ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಲಾಸ್ಟ್ ಬಟ್ ಒನ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಪ್ರಸ್ತಾವಿತ ಸೋನ್ಸೋ 2 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದು ಮಂಜೂರಿ ದಾಖಲೆಗಳು ಕಡತದಲ್ಲಿ ಲಗತ್ತಿರುವುದಿಲ್ಲ. ಕೈಂಡ್ಲಿ ನೋಟ್, my lord. Lord, that is, my lord, his grant. I am the respondent, my lord. I am the respondent before the deputy commissioner. ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಕಡತದಲ್ಲಿ ಲಗತ್ತಿರುವುದಿಲ್ಲ. ಪೈಕಿ RTCಗಳು ಲಗತ್ತಿರುತ್ತವೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಾಖಲಿಸಿರುತ್ತಾರೆ. ಮುಂದಿನ ವಿಚಾರಣೆ ದಿನಾಂಕದವರೆಗೂ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಳ್ಳದಂತೆ ವಿಭಾಗಾಧಿಕಾರಿಗಳು ನಿರ್ದೇಶಿಸುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ಕೂಡ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಾಖಲಿಸಿದ್ದು, ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸೋನ್ಸೋ ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದು ಇತ್ಯರ್ಥವಾಗಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಸದರಿ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೂ ಪರಿಗಣಿಸುವುದು ಸೂಕ್ತವಿಲ್ಲ ಎಂದು ನಿರ್ದೇಶಿಸುತ್ತಾರೆ. ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಹಾಸನ್ರವರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಚನ್ನರಾಯಪಟ್ಟಣರವರಿಂದ ಸೋನ್ಸೋ 29/8/22 ವರದಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ವರದಿಯನ್ವಯ ಸೋನ್ಸೋ ದುರಸ್ತಿಗೊಳಿಸಿ ಪಹಣಿ ಇಂಡೀಕರಣಗೊಂಡು ಮೂಲ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋ 124 ಎಕರೆ 24 ಗುಂಟೆ ಎಕರೆ ಲಭ್ಯವಿರುತ್ತದೆಂದು RTC ತಿದ್ದುಪಡಿ ಬಗ್ಗೆ ವರದಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ವರದಿಯನ್ವಯ RTCಯ ದಾಖಲಾತಿಗಳ ಆಧಾರದ ಮೇಲೆ ಕೆಲವು ಖಾತೆದಾರರ ಹೆಸರನ್ನು ಕೈಬಿಟ್ಟು 8 ಎಕರೆ 37 ಗುಂಟೆ ಎಕರೆ ಜಮೀನನ್ನ ಸರ್ಕಾರಿ ಗೋಮಾಳ ಎಂದು ನಮೂದಿಸಿ ಸದರಿ ವಿಸ್ತೀರ್ಣವನ್ನ ಮೂರನೇ ಪ್ರತಿವಾದಿ ತಂದೆ ವೆಂಕಟರಾಮ್ ದೀಕ್ಷಿತ್ ಅವರಿಗೆ ದಾಖಲಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ 1964 ಕಲಂ 136 3ರ ರೀತಿ ಪ್ರದತ್ತವಾಗಿರುವ ಅಧಿಕಾರದಂತೆ ಈ ಕೆಳಕಂಡ ಆದೇಶ. The finding is in my favor. Lord, the Deputy Commissioner says that grant is not available. Grant record is not available in respect of private respondent herein. That he is the appellant before the Deputy Commissioner. And order is passed in Lord against me, remitting the matter, Lord.
Harish, seek instruction. 64 grant, how we could have made one more grant in 1999?
Based on the respondents were not heard before the AC,
They need
therefore
not
it
be
has been
heard.
remanded.
No, please understand, insofar as petitioners are concerned,
Yes, ma'am.
there is no need to hear this gentleman.
I'll get the, I'll get,
This is an independent grant.
I'll secure the
Grant is
records and
paid.
I'll,
Grant is made in a father's name in 1964.
please, ma'am. Please.
Mutations are effected. They are in
Yes.
existence since 1982.
Yes, ma'am. Yes, ma'am.
My lord.
He has set up a conflicting grant.
Please.
No, my lord.
And how he has acquired a right under the grant,
Yes, ma'am.
second grant, in respect to very same land.
Yes, ma'am.
He has to.
I'll secure the records and I'll assist to the court, my lord.
May I cordially invite your lordship attention. But what had happened from 1964, they have claimed that there was a grant. Lord, there was no records. There was no grant at all, according to us, my lordship.
Revenue
Lord,
record-
I will point
No,
out.
no, please answer. Revenue records reflect, the grant is reflected in other rights column.
Lord,
Her father name is
I-
appearing since.
Lord,
1982.
for a little minute, I
Yes.
cordially, lordship,
Yes.
kindly
Yes,
permit
sir.
me. Lord, 1980, they have approached the authorities, Lord, as per the record. According to us, one, at the influence of police officer, they have been created. Lord, in the year 2021, my lord, they have approached the assistant commissioner, my lord, filing an appeal. My lord, my lord, I cordially invite your lordship attention in page 68. But it is very relevant, my lord.
116.
68, my lord. Writ petition.
Yes, sir.
Lord, they have filed an appeal before the assistant commissioner as 151 for 2021 in the year 21, my lord, saying that RTCs were computerized, my lord, in the year 2000. After lapse of 11 years, my name was not reflected in the RTC. It was there in 83 in the handmade RTC. Therefore, the Tahsildar may be directed to effect the computerization RTC. Lord, when this appeal is pending, my lord, the assistant commissioner sought for a report from the Tahsildar. Lord, that I have produced the report along with my objection statement, my lord. Tahsildar has reported, my lord, deleting our name, which was effected based on the grant. Lord, we have challenged that report of Tahsildar before this honorable court, my lord, in the writ petition which he already pointed out. Lord, during pendency of this regular appeal 157, Lord, the same petitioner, Lord, filed another appeal. Lord, that is in page 70, Lord, 73, he has pointed out. Lord, when we implemented in 150 earlier appeal, Lord, we implemented as a party. After implement, Lord, he didn't pursue it. He filed another appeal before the assistant commissioner. That is appeal number 694/2022. But in that appeal, without hearing anything, my lord, straight away, well, on the very same day, my lord, that appeal came to be allowed. And Puraskarisalagide, directed to effect entry in the name of the petitioner. My lord, that there is no basis at all. When the earlier appeal was not disposed of, when we were not parties, without hearing us, my lord, straight away entertained the fresh appeal and passed an order. But this order was challenged by us before the deputy commissioner.
Mr. Counsel, she is requesting the authorities to mutate her name by way of inheritance. inter alia contending that a father was granted in 1964. Now you have no locus to question their grant. Or if you want to question, you question it before the appropriate authority. Yours is a subsequent grant, 1994 grant.
My lord, there is a used land is there, my lord. Now, we have granted each 2 acres of land. We have constructed the house and we have been enjoying. Not based on our grant, my lord, revenue records have been mutated. Our name is reflected from 1995, my lord. My lord, he claims that.
We'll accept your version. You say that the survey number is a larger extent.
Yes, my
according
lord.
to you.
Yes, my lord.
If it's a larger extent, then there can't be overlapping.
My lord, that in the same contention, my lord, in the original suit, they have pleaded. Then the origin, in the trial court, my lord,
Yes,
we.
yes, Mr. Harish,
Please,
secure instruction.
please. I'll get the records also.
Huh?
I'll secure the records.
My lord, even, my lord, the deputy commissioner,
I think it's of no consequence. You two, both filing suit is of no consequence.
Please,
Unless we examine whose is the genuine grant.
please, please,
And you file a statement of objection.
please.
Work order. Petitioner is agreed by,
my lord, one submission, my lord, your lordship may kindly.
no, sir, I'm granting stay, sir.
Allow, my lord, kindly.
No.
Allow, my lord, because the assistant commissioner is directed, your lordship, my lord, let there be placed, my lord, all the material, so that you will
I'll tell
decide.
you, your good name, ನಿಮ್ಮ ಹೆಸರು
Nagaraj, my lord.
ನಾಗರಾಜ್ ಅವರೇ ಸೂಟ್ ಹಾಕಿದ್ದೀರಾ
ಹೌದು ಸ್ವಾಮಿ.
ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಏನಾದ್ರು ಥ್ರೆಟ್ ಇದ್ರೆ ಅದು you work out.
Possession ಬಗ್ಗೆ
We are
threat
only
ಇಲ್ಲ sir,
concerned-
ನಮಗೆ injunction ಇದೆ.
Based on grant, she is entitled to retain her name in the ownership column. Now whether your grant
ಅಲ್ಲ, my lord, her name, my lord,
overlaps,
her name, my lord, pursuance of the order of the, my lord, deputy commissioner has been entered. But from the beginning, my lord, his name was not at all reflected. Our contention, my lord, reflected in
no,
the
we'll
sense-
ask, we'll ask the state. Notary, revenue records notary as of now. Please examine. ಯಾರು ಇವರು ಏನ್ ಹೆಸರು ಅವ್ರದ್ದು ವೆಂಕಟರಾಮನ್ ದೀಕ್ಷಿತ್. His name is appearing since 1982.
Hello, my lord, that is, my lord, that is, and my lord, that is created, that is our contention, my lord. From 90, your lordship, you see, my lord,
Nagraj, if
Well,
your grant was 1962, I would have examined. all,
94 and 95, my lord.
And not 1963, prior to their grant.
No, my lord, if it is 1963, your honor, but the, as per the MR, my lord, if 81, my lord, if the MR, please kindly, my lord, if they are recognized, my lord, what they have claimed, survey number 109, 110, new number has been given, but is not reflected in the RTC, my lord, with the very same number. Your lordship, by survey number 30, my lord, that name is reflected.
Secure original records. Learned AGA is directed to accept notice to respondents 1 to 4. The parties to the caption petition are basing their right and title based on independent grant orders. Petitioner is asserting right over the petition land based on a grant made in favor of her father in 1962, while private respondents are asserting that this very land is granted to them in 1992. If there is a grant in favor of petitioners in 1962, the authorities had no jurisdiction. Just
Not
wait.
very land, my lord. We are claiming that we have been granted, not the very same land.
Then why your, theirs is the prior grant? You can't challenge it.
My lord, we have been affected by this entry, my lord.
Nagraj,
Therefore, we are aggrieved.
Nagraj, you say that it is a larger extent.
Yes, my lord.
You establish in your suit that what is the portion that is allotted to you in a larger.
So far as
You
regarding.
can't
RTC,
directly lay a claim over their.
my lord, regarding RTC
You
entry,
have no locus to challenge their grants, sir. If there is a larger extent, how you can challenge
but
their grant?
according to, my lord, there was no grant at all. My
That
lord,
they
we
will-
demonstrate, my lord.
That government order.
My lord, available records show, my lord, it is not a granted, it was not granted.
Nimdu grant illa. That is what deputy commissioner says. There is a finding, you have not challenged that.
That is only narration, my lord.
No, you can't say narration. ಬರ್ಕೊಡಿ, ಏನ್ ಬರ್ದ್ರಿ? Had no authority to grant, pass a subsequent grant in favor of private respondents. Second respondent, deputy commissioner, in the course of his order, has observed that there are no documents relating to grant.
Subject to result.
ಅದನ್ನೇ ಮಾಡೋದು, ನಾಗರಾಜ್ ಬಿಡ್ತಾ ಇಲ್ಲ.
Also, civil court will decide ಮಾಡಿದ್ರೆ.
ನಾಗರಾಜ್ ಅವ್ರು ಬಿಡ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಆ ತರ ಇಲ್ಲ ಸರ್. Civil court decide ಮಾಡಿ ಅಲ್ಲಿಂದ ತನಕ let them not be any item, my lord, that would be.
No, that will be written in the name of Venkatramana Dikshit. ಯಾರು ವೆಂಕಟರಾಮನ್ ದೀಕ್ಷಿತ? ಈಗ ಅವ್ರದ್ದು ಡಿಲೀಟ್ ಆಗಿ ನಿಮ್ದು ಆಗಿದೆ ಪೂರ್ತಿ
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
ಲೆಟ್ ಇಟ್ ಬಿ ಇನ್ ದ ನೇಮ್ ಆಫ್ ಯುವರ್ ಫಾದರ್.
ಅಲ್ಲ ಅಂದ್ರೆ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ನಮ್ದು ರೆಕಾರ್ಡ್
ಬರಲ್ಲ, ನಿಮ್ದು ಬರಲ್ಲ.
ನೋಡಿ,
ಅಲ್ಲ ನಮ್ದು ಇದೆ ಸ್ವಾಮಿ, 2 acre ಈಚ್ ನಮ್ದು ಇದೆ. ಅದು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಆಗ್ಲಿ ಸ್ವಾಮಿ, ನಮ್ದೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ. ಬಟ್ ಈಗ ರೆವಿನ್ಯೂ ಎಂಟ್ರಿ ಮೇಲೆ ಮತ್ತೆ ಇದಾಗೋದು ಬೇಡ ಅಂತ ಅಷ್ಟೇ.
but all that I am saying is,
One
we
minute.
will be bound by the, Lord,
ನೀವು ಸೆಕ್ಯೂರ್ ರೆಕಾರ್ಡ್ಸ್ ದೆನ್ ಅಲ್ಲಿ ಪಾಸ್ ಆಗುತ್ತೆ. ಏನ್ ಬದ್ರಿ? In the course of his order has also observed that there are no documents relating to grant made in favor of private respondents. London AGA needs to secure original records and assist this court to ascertain whether there can be two conflicting grants, one in 1962 and one in 1992. London AGA shall secure 64.
ಅವ್ರದ್ದು 64, ನಮ್ದು 94.
1992. Learned AGA shall secure the records and make a submission in the next date of hearing. Till then, the execution and operation of the order, include order passed by first respondent deputy commissioner, while the RA is stayed.
second
Read this matter in preliminary.
second respondent.
Second respondent. As per annexure A, is stayed till next date of hearing. Read this matter in preliminary on the 10 days admin body. Yes, Nagaraj sir will examine it on that. Next. Yes, 9.
Nine for the petition blood. Blood, petitioners' lands have been declared as Pada Mallards. Blood,
Revenue ಕಟ್ಟಿಲ್ಲ ಅಂತ.
revenue ಕಟ್ಟಿಲ್ಲ ಅಂತ.
ಫೀಚರ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ನಾವೇ ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಇದೀವಿ.
ನೀವೇ
ಅಪ್ಲಿಕೇಶನ್ ಇಸ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ that is processed by the Tahsildar.
Yes, madam.
The year 2007 itself, that said lands have been acquired by the KIDB.
There is acquisition,
KIDB are acquired ಆಗಿದೆ. That is the information, first hand information.
audit to seek in section. Learned AGA is directed to accept notice to respondents 1 to 4. Release this matter in preliminary.
Issue is covered by division bench.
ಅದು ನೋಡೋಣ next year. If there is no acquisition, then we'll pass orders.
Even acquisition is there, blood. Pada is to be restored. Of course, we will be
Restored,
entitled for
correct,
comment.
correct.
That is challenged by the petitioner, blood, before this also.
ಕೊಡಿ.
Para 5 minutes.
ಆಯ್ತು, ಮಂಡೇ ಮಾಡೋಣ. Let us see. We'll pass orders on Monday.
ಹೌದು.
Yes, release this matter preliminary on. Yes, next.
Petitioner is another occupation of measuring 1 acre 37 guntas of land. Thereafter, 2003, the committee constituted regularized another occupation of third respondent, granted claim of the petitioner. 1 acre 37 guntas and 6 respondents granted 30 guntas, their claim. After the lordship, the Tahsildar, 5th respondent, conducted a spot measure and spot inspection as per sketch annexure. Lordship. Kindly see the sketch. Grant order annexure A, your lordship. Kindly see the sketch, your lordship. As per annexure D, page number 34.
Who is sixth respondent?
6th respondent is my brother's wife. He's claiming 30 guntas. I am claiming 1 acre 37 guntas. Kindly
What-
see the sketch, annexure D.
How she is claiming 30 guntas?
30 guntas, as per possession of the enjoyment of the property. This
No, whether her 30 guntas was regularized,
regularized, yes, your lord. Regularized.
she is entitled for 30 guntas.
Yes, your lord. Kindly see the annexure, annexure D, page number 34, sketch, your lordship. 6th respondent is column number 3, Mangalamma, 30 guntas. 5th is column serial number 5th.
And why she is challenging this Durusti?
She's equal party, she equal ಬರ್ಬೇಕು ಅಂತ.
Equal ಯಾಕೆ?
That is their contention. They kindly see.
ಅಲ್ಲ, whether she had moved a independent application?
Yes, independent. Yes,
Regularization?
yes, your lord.
Is it a composite order granting, regularizing both
Yes,
or a
your lord.
separate orders ಇದೆಯಾ ನಿಮ್ಮಿಬ್ರಿಗೂ?
ಇಲ್ಲ ಒಂದೇ ಆಡ್.
Huh?
ಒಂದೇ ಆಡ್. Kindly
ಒಂದೇ
see.
order ಅಲ್ಲಿ ನಿಮಗೆ ಎಷ್ಟು ಕೊಟ್ಟರು? 1 acre 37.
1 acre 37 guntas. Kindly see annexure B, page number 26, your lordship.
ಪಾಂಡುರಂಗ 1 ಎಕರೆ 37 ಗುಂಟಾಸ್, ದೇವರಾಜು ಹೆಂಡತಿ ಮಂಗಳಮ್ಮ ಅವರಿಗೆ 30 ಗುಂಟ ಸಕ್ರಮಗೊಳಿಸಿದೆ.
26.
ಪೇಜ್ ನಂಬರ್ 26, ಪೇಜ್ ನಂಬರ್ 20, annexure B.
Correct.
Yes, Your Honor.
And in terms of this grant.
In terms of the grant, they are,
which is
yes, Your Honor.
survey is done.
Yes, sir.
And 4D is effective.
4 is affected.
Now you are agreed by what?
Agreed by annexure D, page number, annexure M, Your Honor.
By whom?
By whom? Passed by the deputy commissioner. Passed by
ಮಾಡಿದ್ದಾರೆ ಅವರು.
Both J and M.
J, annexure J and M.
This Durasti is set aside.
Those is set aside and my artist was cancelled by the Tashildar.
ಯಾಕೆ? Yes, madam. What is this?
My lord, the AC's order says that, my lord, at page 43, annexure J, my lord, end of the page, my lord, ದೇವರಾಜು ಮತ್ತು ಪಾಂಡುರಂಗ ಇವರಿಗೆ ಜಂಟಿಯಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಅರ್ಜಿ ಸಲ್ಲಿಸದೇ ಇರುವ ಇನ್ನಿತರಿಗೆ ಪ್ರತ್ಯೇಕ ಸ್ವಾಧೀನ ಹೊಂದಿರುವವರಿಗೆ ಜಂಟಿಯಾಗಿ ಮಂಜೂರಿಯಾಗಿ ತಹಸೀಲ್ದಾರ್ ಸಕ್ರಮ ಸಮಿತಿ ಮುಂದೆ ಮಂಜೂರತೆ ಮಂಡಿಸಲು ಆದೇಶಿಸುವುದು ಭೂ ಮಂಜೂರತೆ ನಿಯಮಕ್ಕೆ ವಿರುದ್ಧವಾಗಿರುತ್ತೆ. There is no application filed by the concerned person for grant of land. ಇದಾರೆ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದಾರೆ ಅಂತ ಮಾತ್ರಕ್ಕೆ ಸ್ಕೆಚ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಈ ಸರ್ವೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ನೀವು ಅದು ಗ್ರಾಂಟ್ ಬಗ್ಗೆ ಮತ್ತೆ ಇದರಲ್ಲೂ ಗ್ರಾಂಟ್ ಬಗ್ಗೆ ಜೆನ್ಯೂನ್ನೆಸ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ನೇ ಇಲ್ಲ. ಮಿಯರ್ಲಿ ಬಿಕಾಸ್ ದೇ ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪಾಸ್ಡ್.
ಅಲ್ಲ, ಬಟ್ ಇದಿದೆಯಾ ಸಗಳು ಚೀಟಿ ಇಶ್ಯೂ?
Tagoli chiti issue, OM kindly issue,
ಇದಾನೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
issue ಇದೆ. Kindly see the OM.
I think high time you hold inquiry. What is happening?
In the year 2010 itself, this
ಬಂದಲ್ಲ
order
ಇದು.
came to be passed.
Annexure
That is the recent order.
page number 38,
Get hold of that officer who has issued that sagolu chit.
page number
It is
30.
long back, my lord.
Now this Durasti is set aside on the premises that your grant is doubtful.
Yes, Your Honor. That is
Doubtful means they have not at all filed the application.
page
itself.
number 38.
Directly based on the possession.
ಅವ್ರು ಕೊಟ್ಟಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಈಗ ನಿಮ್ ಹತ್ರ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ you want to punish them.
ಅಲ್ಲ,
ಆಯ್ತು,
ಅವ್ರೇ
then you have to hear him out.
land grant
Oh,
committee ಮುಂದೆ.
Madam,
Yes,
madam, hold an inquiry.
yes, ma'am.
Call upon him to furnish all documents. Hear him out, then pass an order ಅಲ್ಲ. ಇದು behind the back ಇದು collateral proceedings ಅಲ್ಲಿ ನೀವು granted doubtful ಇದೆ ಅಂತ
That's why it
ಹೇಳ್ತೀರಿ.
has been remanded to Tahsildar to hold an inquiry. That's why.
No,
the
you will
case
not do in these proceedings. You will have to do it. You have to do it under independent proceeding.
Annexure F, page number 38, OM also issued by the Tashildar. Other 1 acre 37 guntas was issued, grant, OM also
is
issued.
not wrongly while placing the.
In the year
recommendation before
2003,
the land grant
thereafter we
committee,
pay kimmat and fine.
wrongly while placing the recommendation before the committee, without there being
Committee ಏನ್
any
ಮಾಡ್ತಾ ಇತ್ತು?
application.
Committee ಏನ್ ಮಾಡ್ತಾ ಇತ್ತು?
Committee ಮಂಜೂರ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ.
ಹೇಗ್ ಮಾಡಿದ್ರು ಅವರು?
Based on possession,
Possession.
sketch has been prepared.
Yes.
There being no application for grant of land.
ಈಗ what is the date of regularization? Recommend ಆಗಿದ್ದು ಯಾವಾಗ committee?
2003,
ಹಾ?
2003,
2003.
20,
ಇವಾಗ
22.
ಬಂದು ನಿಮ್ದು
3,
application ಇಲ್ಲ ಅಂತ
2003.
ಹೇಳಿದ್ರೆ. Very absurd ರೀ.
Yes,
Very absurd.
2003.
Very hard to digest.
They have regularized on 24/3/2003.
ಅವರೆಲ್ಲ ಏನಾಗುತ್ತೆ
how-
ಸ್ವಾಮಿ, ಗ್ರಾಂಟ್ ತಗೊಂಡ್ ಸುಮ್ನೆ ಇದ್ಬಿಡ್ತಾರೆ. ದುರಸ್ತಿಗೆ ಬಂದಾಗ ಇದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ಗಳು ಬರುತ್ತೆ.
Alright, then you initiate independent inquiry.
This is,
ಈಗ whether grant is genuine or not, who can examine it? Assistant Commissioner?
yes,
Assistant Commissioner?
assistant commissioner has already
ಯಾವ್ದು
passed.
108 K ಕೆಳಗಡೆನ?
180K.
You do
Assistant
that.
commissioner
calendar.
passed an order way back in the year 2010 itself, my lord.
ಏನಂತ?
ಅದನ್ನೇ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ದೇನೆ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಸರಿ ಇಲ್ಲ ಅದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಅಲ್ಲ, whether they were heard? ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಮಾಡಿದೀರಾ ಇದು?
ಎಸ್ ಮೇಡಮ್, ಪಾಂಡುರಂಗ ಅವ್ರಿಗೆ
ನಿಮ್ದು
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಂಟರ್ನಲ್ ಕಮ್ಯುನಿಕೇಶನ್ ಅದು
No, 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 order ಮೇಡಮ್. Annexure J is an order.
ಎಲ್ಲಿದೆ?
Annexure J at
Annexure J is
page
page number
42, madam.
ಇದನ್ನ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
Challenge the
ಮಾಡಿದ್ರು,
deputy commissioner was
Parties before the
rejected.
AC.
Thereafter, we went to the Karnataka Appellate Tribunal. Karnataka Appellate remanded matter to the deputy commissioner. Thereafter, remanded to the Tashildar. Deputy commissioner ends before this court, Your Lordship.
ಅರ್ಜಿ ಇಲ್ದೆ ಕೊಟ್ಟಿರೋದು ತಪ್ಪಾಗಿದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ ಅದು ರಿಮ್ಯಾಂಡ್. DC has passed an order saying that if they files
Now, you
application.
tell me, if an application in form number 53 or 57 is tendered
Yes,
by an unauthorized occupant and your official does not reflect in the register on receipt of an application,
it can't be, my
and-
lord,
and-
acknowledgement.
and that goes missing, but the committee,
Acknowledgement ಇದೆ. ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಇರುತ್ತೆ ಅವ್ರ.
ಅವ್ರು ಎಲ್ಲಿ ಇಟ್ಕೋಬೇಕೀಗ? ಯಾರು
ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ ಅದನ್ನ.
ಗ್ರಾಂಟ್ ಆದ್ಮೇಲೆ ಎಲ್ಲಿ ಇಟ್ಕೋತಾರ ಅವ್ರು?
ಗ್ರಾಂಟ್ ಆದ್ಮೇಲೆ 53, 57 ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಮೇಲೆ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ.
ಗ್ರಾಂಟ್ ಆದ್ಮೇಲೆ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಇಟ್ಕೋಬೇಕು ಅವ್ರು.
ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಾಗ್ಲೇ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ.
Grant order ಹಾಕಿ annexure B is my grant order.
Ah?
Annexure B, A.
Where is your application?
Application is not available. Annexure A is my grant order, annexure B is
I don't think,
unauthorized.
Anyone will retain an application submitted in form number 50.
ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ. ಗ್ರಾಂಟ್ಗಳು ಅಂದ್ಮೇಲೆ ಅವ್ರು ಇಟ್ಕೊಳ್ಳೇಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲ, ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಮರ್ಜ್ ಆಗತ್ತೆ ಅದು. There's a
Why?
merger.
Thereafter subsequently-
Merged with the order, recommendation.
That is
Tahsildar was-
wrongly, my lord, with the report placed before the land grant committee wrongly
ನಿಮಿಷ.
because there being no application.
Where are the recommendations by the land grant committee? Recommendation ಎಲ್ಲಿದೆ?
They are not yet produced.
You
I'll
can
check your
check your
record.
original records. Check your records. Learned AG is directed to accept notice to respond 1 to 5. Issue a major notice to respond number 6.
Kathas was made in May favor, annexure
Petitioner-
G, your lordship.
Like even today they are in possession, let them make fresh application and can seek for grant.
Annexure G is
Possession.
page number 35. Pani,
Only
Amma
error.
also mutated in my name.
procedure
Pani
errors.
also reflected in my name, your lordship.
Petitioner
Thereof-
contends that the land grant committee under rule 108D has recommended to regularize petitioners unauthorized occupancy or land measuring 1 acre 37 guntas. Accordingly, official
Official
memorandum
memorandum
is
issue, they are issued, your lordship.
Is
Thereafter,
issued by whom? Is issued by
issued
whom?
by Tahsildar, annexure D, your lordship.
Yes.
Annexure.
Official memorandum is issued, thereby
Issued by
regularizing
Tahsildar.
petitioners unauthorized occupancy as evidenced at
Your lordship, annexure,
produced.
annexure, your lordship.
Notes ಮಾಡ್ಬೇಕ್ರಿ.
In the annexure, your lordship, annexure D, your lordship.
Huh?
Annexure
He sketch.
D. So,
As per annexure so and so.
annexure F, your lordship, page number 38.
Annexure F.
F,
Petitioner is agreed by
annexure F.
the,
OM.
the order passed by fourth respondent assistant commissioner
And 29/7/2003.
in cancelling the grant on the premises that the recommendation is made by third respondent committee in absence of application tendered by petitioner seeking regularization. The said order is confirmed by second respondent deputy commissioner.
Yes, sir.
KT ಹೋಗ್ಲಿಲ್ವಾ ಈ ಸರಿ?
KT ಹೋಗಿದೆ, KT remitted to the, back to the deputy commissioner. Deputy commissioner again remitted to the back to the Tahsildar.
The procedure ನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿ ಅಂತಿದ್ದಾರೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಏನ್ ಯಾರ್ದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಲ್ಲ, ಏನು ಇಲ್ಲ. The order says at page 58, my lord. ಅಪೀಲುದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿ ಅವರವರ ಸ್ವಾಧೀನಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
As
ಪ್ರತ್ಯೇಕವಾಗಿ
per position.
ನಿಯಮಾನುಸಾರ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಅದರಂತೆ ಕಡತ ತಯಾರಿಸಿ ಕಮಿಟಿ ಮುಂದೆ ಮಂಡಿಸಿ ಸೂಕ್ತ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳಲು ಅಷ್ಟೇ ದಿ ವಾಂಟ್ ಟು ರೆಗ್ಯುಲರೈಸ್ ದಿ ಪ್ರೊಸೀಜರ್, ದಟ್ಸ್ ಆಲ್, ಬಿಕಾಸ್ ದೇ ಆರ್ ನಾಟ್ ಫೈಂಡ್ ದಿ ಎನಿ ಅಪ್ಲಿಕೇಶನ್ ಬಿಫೋರ್ ದಿ ಕಮಿಟಿ. ವಿತೌಟ್ ದೇರ್ ಬೀಂಗ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್, ಕಮಿಟಿ ಕೆನಾಟ್ ಗ್ರಾಂಟ್ ದಿ ಲ್ಯಾಂಡ್.
Annexure G is by,
ವಾಂಟ್ ಟು ರೆಕ್ಟಿಫೈ ದಿ ಪ್ರೊಸೀಜರಲ್ ಎರರ್.
ನಮ್ಗೆ ಅದು ನೀವು ಅದು ರಿಕಮೆಂಡೇಶನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಅದ್ರ ಮೇಲೆ ನೋಡೋಣ.
ಆಯ್ತು.
The learned AGA shall place on record, shall furnish original records pertaining to recommendation made by third respondent committee in respect of petition land by next date of hearing. Till then, respondents are hereby directed not to take any precipitative action against petitioners insofar as petition land measuring 1 acre
1 acre 37 guntas,
guntas is
survey number 18, new number 18/2.
in survey number 18/2, bracket ಅಲ್ಲಿ old number 18.
Annexure G and G1 is, artist was reflected in my name up to 2011. Thereafter was,
All right, I have
yes.
perfected the possession.
yes.
ಏನ್ರಿ ಇದು? Yes, sir.
Justice Krishna Kumar was disabled, so that's why my learned friend. This is a matter where some sort of a settlement, because I have not even filed any objection in this
Not
case.
filed.
I've been paid money. Totally around 13.5 lakhs has been paid. Some 10 lakhs has to be paid. I have taken sufficient time. I do agree. Last on the 4 weeks time, Kotra, some next installment of money can go.
Affordable. It was my last payment, my lord, was about 3 years back. That's why I requested my
You
friend.
both were sitting together ಅಲ್ಲ?
Hours.
Huh?
We studied together also.
All right. Then settlement possibility is high. All right, at the request of, at the
In
request,
fact, if the company is wound up, my learned friend will not get anything.
at the request of counsel for respondent, release this matter on so and so date. Please.
4 weeks time may be granted in,
And you pick up a date when you want.
it may be taken up in the first September last week.
All right. Oblige, one, next. Next.
Appearing for appellant, my lord, kindly seeking an adjournment, my lord. Because it's a genuine reason, my lord, because the land council has been hospitalized.
Refused.
My lord, he is diabetic. Today morning, he has been hospitalized.
Yaru.
Land council, Mr. Gopinathan.
ಯಾವ ಕೇಸಲ್ಲಿ?
But this is the matter which your lordships heard on the other day.
Yes, my lord.
Mr. Gopinath addressed the arguments on that day, madam. I appeared for the respondent through video conference. Your
He's
lordship.
not keeping well.
Yes, my lord, he is diabetic, my lord. He has been hospitalized, my lord.
Let me make one request, because anyway, the matter is getting adjourned. I may have to mention one aspect. In respect of 13 guntas of land, which is the subject matter of these proceedings. Out of that, 2 guntas of land. In respect of 2 guntas of these 13 guntas, there is a separate suit and a separate appeal is pending before this court, which is not connected to this. I don't know whether that matter can be heard along with these appeals.
He is diabetic, my lord.
If your lordship permits me, I'll give the number also.
Sugar level is fluctuating, my lord.
Because I don't want inconsistent judgments to be passed.
So they are.
ಯಾವ್ದು appeal?
Adu appeal number 892 of 2017.
Arising out of the same suit?
Not same suit. A
Between
different
same
suit
parties.
in respect of 2 guntas of land between the same parties. If your lordship-
ಆಯ್ತೀಗ I will fix a date, but let me hear them in their appeal. ನಿಮ್ದು appeal ಇದೆಯಲ್ಲ?
ನಂದು appeal ಇವತ್ತು ಬಂದಿರೋದ್ರಲ್ಲಿ.
ನಿಮ್ದು appeal ಅಲ್ಲಿ argument ಮಾಡಿ.
407.
I'll fix a date. You make a notes ಮಾಡಿ.
You know, I am appearing for the respondents in their appeal also.
ನಿಮ್ದೊಂದು appeal ಇದೆ ಕರೆಕ್ಟಾ?
ಹೌದು. ಅದರಲ್ಲಿ ನಾನು what happens is
ಅದನ್ನ
it's a common
argument
judgment.
ಮಾಡಿ. ಅದನ್ನ argument ಮಾಡಿ.
I am here to ready to argue. You know, your lordship may kindly say the subject matter of the suits is survey number 47/3B.
ಏನಾದ್ರು ಸಿನಾಪ್ಸಿಸ್ ಬಂತ ಒಂದು effective synopsis.
Preparing, madam, I will be able to.
Synopsis
I have.
as to
prepared.
who is the owner, original owner, Muniyamma is the owner.
ಅದು ಇಲ್ಲಿ. This synopsis may be of some help. madam. It's not complete, your lordship may have to pardon me. It is not completely prepared. But I have made some basic things have been always.
ಇವತ್ತು ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
Adu, there are so many facts, madam, which are arising out of all the 3 appeals. Anyway, this should be sufficient for the purpose of considering the case. The land is survey number 47/3B. madam. There are 3 appeals here. RFA 1276 and 1277 are filed by the plaintiffs in OS number 2426 and 2427 of 2000. These 2 suits are for declaration and injunction, filed by one Harish and Abdul Salam.
ಅದೇ ಒಂದು ಚಾರ್ಟ್ ಬೇಕಾಗಿತ್ತು, ಇವತ್ತು ಮಾಡಿಲ್ಲ ನೀವು.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಾನು ಹೇಳಿದ್ದೀನಿ, I have mentioned the facts later.
ಚಾರ್ಟ್ ಇದ್ರೆ 2 ನಿಮಿಷದಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ.
I can explain. The lordship permits me, I'll not.
I will make a chart. You can go and explain.
I'll explain.
Yes.
What has happened is this.
Muniyamma is the owner, correct?
Muniyamma is the owner of 2 acres, 10 guntas of land.
1 ನಿಮಿಷ. 2 acres, 10 guntas.
Yes. He gets this property under a registered gift deed executed by the.
Allah, that is not in dispute.
That is not, but that may be relevant for one aspect. Your lordship may kindly bear it. She gets it under a registered gift deed. from her mother, Venkatamma.
She got it from her
From her mother,
mother.
under the registered gift deed.
What's her name?
Her name is Venkatamma.
What's the date of gift deed?
Gift deed is in 1958, Milord, I'll give it. It is not marked in the course of the evidence,
Not marked.
not marked. But it is referred to in the.
It's a part of record?
Yes, Milord.
Is it part of record? I mean, it was placed on,
No,
produced
gift
and not
deed is
marked?
not placed on record.
All right,
But
not produced.
in the registered sale deed executed by this lady on 4/10/1962.
Yes, sir. Now Muniamma sells along with the sons, correct? In favor
Muniamma,
of Tukaram Y. Revankar. Exhibit
ಅದೇ
P4.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Huh?
Muniamma executes a gift deed, executes a sale deed in respect of 13 guntas of land
13 guntas.
in favor of Revankar, Tukaram Revankar.
There are two alienations by Muniamma, correct?
There are, Milord, there are two alienations, three alienations total.
Aitu.
One is 62,
6/12/1962, exhibit P4.
P4.
Ah,
Exhibit P4/10 to 1962. Milord.
one ನಿಮಿಷ. Tukaram Y. Revankar.
Four ten 1962.
One ನಿಮಿಷ.
Exhibit P4. This was in favor of Tukaram Revankar. Tukaram Yashwant Revankar.
Ah.
Executed by Muniamma along with her sons and also on behalf of a minor son. Another important aspect about this sale deed, sale deed is the survey number of the land mentioned as survey number 45/6, not 47/3B. That was the earlier number. Subsequent, this particular sale deed, survey number is described as 45/6.
ಯಾವ್ದು ಯಾವ ಸೇಲ್ ಡಿಡ್?
1962 sale deed in favor of Tukaram Yashwant Revankar. Exhibit P4.
That refers as survey number
45/6,
and not 47.
not 47/3B. Subsequently, what has happened, a Tahsildar says it is 47/3B in an order. And they
Whether
mostly,
Muniamma owned any other land other than this?
as per the records, no, we have no information. But apart from that, what happened is this. One other aspect about the sale deed is the extent is 13 guntas. Your lordship may kindly see the schedule, Milord, that has been referred to in the
No,
Commissioner's-
first you reflect all alienations and then you can argue.
13 guntas on either side of the road.
Second.
Next
Next,
sale deed is 1972. That is the sale deed executed by
Muniamma.
Muniamma.
And her son.
Reference please. What?
In favor of Jairamappa, correct?
In favor of Jairam.
15/11/1972.
Yes. That is in respect of 1 acre 5 guntas of land on the western side of the property.
In 11/72. Exhibit D1.
Exhibit, yes, ma'am, D1.
Exhibit
D1,
D1.
yes.
Extent is 1 acre 5 guntas.
1 acre 5 guntas.
Yes.
1 acre 5 acres. Now subsequently, now going what important, the most important aspect which is relevant from our particular point of view is that admittedly in this, out of 2 acres, 10 guntas of land, 2 acres, total 2 acres, 10 guntas of land. As per the revenue records existing at that time, there was a 5 guntas of kharab. As per the commissioner's report, which is filed before this court, during the pendence of the appeal, there is a kharab of 9 guntas.
Kharab of
9 guntas. Apart from that, admittedly, there is a road which is running in between the property. North to south.
Ah,
That road measures about 10 guntas approximately, as per the commissioner's report.
now you have filed a suit for declaration. What is the extent claimed by you?
I am claiming.
1 acre 38 guntas.
No. In my suit filed by me, the suit filed by 2 defendants in the first 2 cases, Krishnamurthy and Veerabhadrappa. They are claiming rights in respect of 2 guntas each out of these 13 guntas.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈ 87/407 ನಲ್ಲಿ.
ಅಲ್ಲ 407 ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲ?
ಯಾವುದು?
ನಿಮ್ಮ ಅಪೀಲ್ ಯಾವುದು?
ನಮ್ಮ ಅಪೀಲೇ ಇದೆ 407.
That is arising out of which suit?
8745 of 2002.
8745. ಈಗ you tell me all the 3 suits.
Yes, ma'am. Now, before going there, let me complete this particular extent part. That is very relevant. 10 guntas was road, 9 guntas of kharab is there. In 1972, 1 acre 5 guntas was sold. In 1962, 13 guntas was sold. If all these things are taken into account, in 1984, Muniyamma executes another sale deed in favor of one Nanjappa, seeking to sell 32 guntas of land, which was not available at all at that particular point of time. This is a restricted submission. Because if your lordship totals this entire extent, 13 guntas Revankar, 1 acre 5 guntas to Jairamappa, another 9 guntas of kharab or even 5 guntas of kharab, and 10 guntas of road. So question of selling 32 guntas did not arise in favor of Nanjappa in 94.
Date?
1984, I'll give the date.
1984.
Yes, ma'am. After all these alienations have taken. That is on 21/3/1984.
Whether Manjappa and his Ellas are party to this?
Nanjappa is a party in this suit, madam. In the suit filed by us, Nanjappa is a party.
Manjappa.
Nanjappa.
What is the date of sale deed?
Minute dies 21/3/84 minute.
21/3.
1984.
1984.
Yes, ma'am.
Nanjappa is defendant in OS number?
OS number 8745 of 2002.
OS number 4?
8745, 8745
Ah,
for 2002, which is out of which minute 407 arises.
ಇದ್ರ ಮೇಲೆ RFA 407.
Yes, ma'am. Plaintiffs are Krishnamurthy and Govindaraj. That is respondent 7 and 6.
Yes, sir.
Minute, this is the subject matter. Now, question is, our contention is they could not have any alienation of 32 guntas. Now, Minute, so far as the suits filed by Harish and Abdul Salam are concerned, out of which were argued by my learned friend on the other day before your lordships. They claim, what Harish claims is, he has purchased 13 guntas of land from the legal heirs of Tukaram Yeshwantharayankar.
ಯಾರು?
This appellant in first appeal.
ಅಲ್ಲಲ್ಲ ಹಾಗೆ ಹೇಳ್ಬೇಡಿ. ಪ್ಲೇಂಟಿಫ್ಸ್ ಅಂತ ಹೇಳಿ.
Plaintiffs in OS number 2426 of 2000, out of which 1276 arrears.
ಅದು ಕೊಡ್ರಿ ಅದು. ಪೇಪರ್ ಬುಕ್ ಇನ್ ಕನೆಕ್ಟೆಡ್.
ಅದು ಪೇಪರ್ ಬುಕ್ ಅವ್ರು ಹಾಕಿದಾರೆ, ನಮ್ಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ. ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ದೀರಾ 1276 ಅಲ್ಲಿ? ಈ ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದ್ದೀರಾ?
All right, you have the particulars?
Which particulars?
The first two suits.
Yes, ma'am.
ಅದು ಯಾರು ಹಾಕಿದ್ದಾರು?
First two suits, Harish is filed, is the plaintiff in OS 2426 of 2000.
ಒಂದ್ ನಿಮಿಷ. OS number?
2426 of 2000.
2426.
Against this, 1276 is the appeal.
This is by Harish.
Harish.
And RFA is?
1276 of 2006.
176 of?
2006.
All right. Are you party to this suit?
Yes,
You are
we are
party.
part.
Next suit is?
Next suit is OS 2427 of 2000. This is filed by one Abdul Salim.
Who has purchased from Harish?
Yes, 7.5 guntas. Harish purchases totally 13 guntas. Out of that, 7.5 guntas is sold by Harish in favor of Abdul.
All right.
Salim.
ಇದು RFA ಯಾವುದು?
ಇದು RFA 1277.
1277.
Bought 2006.
All right. ಈಗ ತುಕಾರಾಮ್ ರೇವಣ್ಕರ್ ಇಂಟರ್ನ್ ಯಾರಿಗೆ ಮಾರಿದ್ರು? ಹರೀಶ್ಗೆ.
Tukaram Revankar, Tukaram Revankar does not sell his children and with his legal heirs.
They sell it to plaintiff in OS
Along
242.
with, that's what I'm, apart from the legal heirs of Tukaram Revankar, wife and son of Jairamappa, they join in the execution of a sale deed in favor of Harish.
Legal heirs of Jairamappa also joined.
Not all the legal heirs, only wife and son.
And what is the extent sold to Harish?
13 guntas. That 13 guntas is supposed to be the property which Revankar had acquired under the sale deed of 1962.
Correct.
But what has happened is the description of the boundaries, even in the sale deed, in favor of Harish, do not exactly tally with the description of the boundaries found in the sale deed in favor of Revankar. That is one aspect of the matter.
ಅಲ್ಲ ಫಸ್ಟ್ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಮೇಲೆ ಮಾಡೋಂತೀರಾ?
ಅದು ಹೇಳ್ತಾ
ಮಧುಸೂದನ್
ಇದ್ದೀನಿ.
ಅವ್ರೆ.
Facts.
ನನಗೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿ
I-
ನೀವು ಅದನ್ನ will allow you to argue.
Yes, I know, I understand. I
Now
thought I
ತುಕಾರಾಮ್
clarified.
ರೇವಣ್ಕರ್
Yes, ma'am.
sold 13 guntas.
13 guntas along with the wife and son of Jairama,
Not Tukaram, his LRs. Or along with,
his LRs.
not by Tukaram.
No, he was dead by then.
All right, his LRs sold. What is the date of sale deed?
1997, 29/3/97. But before that,
Ah.
one of the important relevant fact is, there was an agreement of sale,
By Jairamappa.
not Jairam.
Munyam.
Tukaram Revankar.
Huh?
Tukaram Revankar himself, in the year 1978, in favor of Jairam.
ಅದಕ್ಕೆ ಅವ್ರು ಜಾಯ್ನ್ ಆಗಿದ್ದು.
But
ಅವ್ರು ratify ಮಾಡ್ತಾರೆ
there is
sale.
one more aspect. There is
Ah.
another aspect also which has to be brought to your
All
notice.
right.
There was an agreement of sale in the year 1978, which is admittedly executed by Tukaram Revankar in favor of Jairamappa, and admittedly pursuant to that said agreement, the property's possession was given to Jairamappa. Why I am saying admittedly repeatedly is, in the sale deed in favor of this Harish, there is a specific reference to that aspect. And in addition to that, Harish himself admits in the course of the cross-examination these aspects. This is one aspect of it. But what has happened is this,
ಅವ್ರು ಸೆಲ್ಡಿಡ್ ಹೇಳಿ ಅಲ್ಲ, ಹರೀಶ್ ಅವ್ರು ಸೆಲ್ಡಿಡ್ ಹೇಳಿ.
29,397,
29,
397, exhibit P1.
1997.
Yes, madam. During this period, one more development had taken place that I wanted to submit.
Yes, sir.
You know, in the meanwhile, one more development had taken place, which had to be brought to your lordship. OS 3726 of 1983.
ಅದ್ಯಾವ್ದು ವಯಸ್ಸು?
It was OS 3726 of 1983 was a suit filed by Krishnamurthy, one of the brothers of Jairamappa, for partition and separate possession of all the properties, family properties. Jairamappa also was a party in this suit. Our main contention of these defendants is that, you know, the properties are all joint family properties, including the properties purchased in the name of Mr. Jairamappa. In that suit, Milad, even this particular extent of 13 guntas also, because by then there was already an agreement to sell in favor of Jairamappa, and he was in possession of the property in part performance of the agreement. That property also was included.
OS number?
3726 of 1983.
3726
26.
of 2000?
1983.
1983.
Yes, ma'am. That is even prior to the sale deed in favor of Nanjappa.
Yes, sir.
You know, this suit came to, during the pendency of the suit, Jairamappa died. And his legal heirs, including the wife and son who sold the property in 97, were brought on. All the legal heirs were brought on. And that suit came to be decreed by a compromise in the year 1999.
Widow
Yes, Mira?
and how many children? Jairamappa had how many children? ಮಕ್ಕಳು ಎಷ್ಟಿದ್ರು ಜಯರಾಮಪ್ಪಗೆ? ಜಯರಾಮಪ್ಪಗೆ ಮಕ್ಕಳು?
One wife is Nanjamma.
ಹಾ.
And one, two, three, two daughters. And 3, 4, 5, 6. Totally about 10 legal heirs were there, including the son. Vijayalakshmi, Bhagyalakshmi, Anuradha, next Muniratna, I think she is Muniratna and Indrakala, Ketana Kumari, and these are all the legal heirs of this man, Jairama.
This suit is compromised.
Compromise.
13
That
ಗುಂಟಾಸ್
was in 1999.
13 ಗುಂಟಾಸ್ ಯಾರಿಗೆ ಅಲಾಟ್ ಆಯ್ತು ಕಾಂಪ್ರಮೈಸ್ ದಲ್ಲಿ?
Yes, madam.
13
This 13
ಗುಂಟಾಸ್
guntas was divided. That is on either side of the property. Madam. That was divided among the members of the family, including the legal heirs of dependent, that is Jairamappa.
how you could have included you could have included the 13 guntas based on an agreement when legal heirs of Jairamappa had joined the legal heirs of
That sale
Tukaram.
happened. That's what I'm saying. That sale has happened in 97 after the death of Jairamappa.
Very
And that's what I'm saying. Your lordship, I'm trying to answer your lordship.
Yes.
But what has happened is this. This sale takes place during the pendency of this compromise, this partition suit.
how it
Sale has taken place during the pendency of the partition suit.
and no list pendants apply ಆಗಲ್ಲ ಇದಕ್ಕೆ.
ಆಗುತ್ತೆ ಅಂತ ಒಂದು full bench judgment ಇದೆ ಒರಿಸ್ಸಾ ಹೈ
All right, you signed the
pass
judgment.
on
All right.
later. But here is a case where
Yes.
admittedly we are put in physical possession of the property. That is Jairamappa was put in physical possession of the property.
Yes.
There is no material to indicate that he was dispossessed in a manner known to law. Mirror, there is judgment of the Honorable Supreme
What
Court.
is the date of compromise?
Compromise is in 1999, mirror date I will right now. 19/7/1999. No, I'm sorry. 10/3/1999.
10/3.
Yes.
Exhibit
Exhibit P8, mirror.
yes.
Subsequently, there was an amendment to the decree that the small variations were there. But what has happened is this. So far as the 13 guntas of land is concerned, which is transferred by only 2 of the legal heirs of Jairamappa. Does it bind the other legal heirs and other members of the joint family, because it is the specific case of the appellants in the connected appeal that the property is the joint family property. Jairamappa was only not the exclusive owner of the property. As such, and in fact, 1 acre 5 guntas, which is subsequently purchased in 1972, I mean, under a registered sale, it also has been divided among the members of the family. But question would be whether these people, on the basis of the sale deed in favor of this person, can they interfere with our position in respect of the property which we have divided? Is the question.
Yes.
But there is a judgment of the Honorable Supreme Court which says that once, even assuming that there is an agreement of sale and specific performance is not sought, even then, the position of the agreement holder who under section 53A cannot be disturbed. I will pass on. 2002, volume 3, Supreme Court cases, 7.
ಇದೆಲ್ಲ ಕಂಟೆನ್ಷನ್ ಇದೆಯಾ ನಿಮ್ ಸೂಟ್ ಅಲ್ಲಿ? ಇಶ್ಯೂ ಇದೆಯಾ?
The agreement to sell is referred to.
No, no, no. I want to know whether these buildings are there or you are arguing for the first time.
No, 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 yes.
There are to be pleading, Madhusudan sir.
Yes, my lord.
Ah,
There is
yes.
a reference to the agreement to
All
sell
right.
in the.
No, no, I'll pen down and then we'll refer to the pleadings. You'll
I will
take it
read
to the
right now,
pleadings.
right now, my lord. I don't want any confusion in this regard.
All right.
We have produced the documents also, except that unfortunately 78 agreement could not be produced because we did not have the original.
You are asserting that Tukaram executed an agreement.
Yes. That is not in dispute also. That is what I am submitting. May pass, if your lordship permits me,
One
I
ನಿಮಿಷ.
will read exhibit P1.
One ನಿಮಿಷ. ಹಿಂಗ್ ಹಾಕಿ ಹೋಗಿ. ಇಲ್ಲೇ ಒಂದು ಇಟ್ಬಿಡಿ. ಇದೆಯಾ? Yes, sir. Show the pleadings.
Yes, madam. Kindly go
In
to
your suit.
judgment, madam.
Okay. You want to cite judgment first? All right.
Yes, madam.
You want to cite a judgment
No,
first?
not judgment. I am reading the trial court judgment where there is a reference to the pleading.
No, no, I want to see your pleadings.
Yes, madam.
Your
Kindly
suit.
see the paper book which I have filed.
407.
407.
Yes, sir.
Intake.
You can read only a relevant paragraph.
Yes, madam, that's all. Para 7,
Para 7.
yes, of the plain. The plaintiff's joint family, Kata, late Jairamappa, Katta, late Jairamappa under an agreement to sell in their 1978 purchased the said land from Tukaram Pravation, the Revankar for a valuable consideration. Since 1978, the plaintiff's joint family was in continuous possession and enjoyment of the said property as absolute owners openly to the knowledge of the original owner and late Tukaram Revankar and also the neighbors and have perfected their title by adverse position. Then we learned it is submitted that defendant number 1 in their 1984 made some illegal attempts to interfere with the plaintiff's joint family possession of the land on the eastern side. Late Jairamappa then Karta of the joint family filed suit in OS numbers 2520. This is another suit, which was subsequently withdrawn by the LRs. That is the
All
defendant.
right. Para 7 is relevant.
Yes. Then may I kindly go to further down. It is submitted in such suit, the original owner, Srimati Muniyamma and her son Narayan Swami have filed a statement and admit the ownership of plaintiff joint family to the extent of 1 acre 5 guntas and 13 guntas of land in survey number 47 by 3B. Further in the said suit, Tukaram Revankar also had filed a statement by admitting their plaintiff's family ownership over the land pertaining to the agreement of sale and stated that what has been conveyed in said agreement should stand and plaintiff is not entitled to excess of land. The said suit was pending up to the death of Jairamappa. And given thereafter plaintiff joint family on verification of sale deed of Tukaram Revankar decided to restrict their right of ownership in the question over 13 guntas and 1 acre 5 guntas only. It is submitted that defendant number 1 is in possession enjoyment of the remaining northern portion, etc. Then coming down further, the plaintiff submit that in the year 1983, plaintiff number 1 filed OS number 3726 of 1983 for partition separate portion of 1/6 share. In the year 1999, the said suit was decreed and the entire western portion of the land, 1 acre 5 guntas, acquired under 1972 sale deed, and 5 guntas out of 13 guntas of land has fallen to the share of Veerabhadrappa Narayan Swami. The remaining 8 guntas as the B schedule properties fallen to the share of plaintiffs 1 and 2, defendants 4 to 6. And defendants 4 and 5 are the wife and son of Jairamappa. As this was the state of affairs in the year 1999-2000, the defendant number 2 along with the official.
No, that is not relevant. That is not.
There is a reference to these.
Only
things.
para 7. Para 7 is enough.
Enough.
All right, now you have cited a judgment.
Yes, that citation, your lordship may kindly see. Person obtaining possession of the property, your lordship may no, in part performance an agreement of sale, held can defend in possession in a suit for recovery of possession filed by the transferor or by the subsequent transfer of the property claiming under him, even if a suit for specific performance of the agreement of sale has become barred by limitation. Law of limitation does not apply to a plea taken in defense by defendant, even though that defense as a claim made by him may not be enforced in a court being barred by limitation. I may not be able to file a suit for specific performance, but I can definitely protect my rights of possession under section 53.
Yaru, you andre who?
I means Jairamappa, I am the Jairamappa was the person who had taken this property under agreement of sale. He is
No,
the
no.
karta of the family.
But when the sale was done by legal heirs of
Not
Tukaram,
all the legal cases may respect to
that is
submission.
enough.
That is another aspect. Apart from that, it's a pendent sale.
Parallel.
Even otherwise also.
It is not pendent.
Yes, Mr. One judgment of Orissa High Court. There are other judgments also. I will pass on. No, only because of that.
If you had filed a suit for specific performance, then section 52
No,
is
not-
applicable.
Not like that.
Not in your partition suits.
No, not that. What I'm submitting. is-
Madhusudan sir,
I don't think I've made myself clear.
not expecting from you.
He did
but-
that.
No. I'm not expecting
No,
it from you.
your lordship may have to kindly.
Very sorry.
Permit me to clarify my.
Extremely sorry.
No,
To
no.
your stature, you should
No,
not make.
Kindly let me make my submission. Mirror, your
Yes,
lordship may agree or disagree with me.
Yes,
That's the different thing.
Yes,
My submission is only this thing. Your lordship may kindly see. Admittedly, there is an agreement of sale of 1978. Admittedly, Jairamappa was put in possession of the property. Admittedly, this particular property was.
where is that issue? List pendants ಅದೆಲ್ಲ ಎಲ್ಲಿದೆ? Adverse possession ಎಲ್ಲಿದೆ? Pleading ಅಲ್ಲಿ ಬಂತು. List pendants
ಅಲ್ಲ,
ಎಲ್ಲಿದೆ?
ಡಿಸ್ಪೆಂಡೆನ್ಸ್ ಅಂತ ಅವ್ರು legal ಆಗಿ ತಗೊಂಡಿಲ್ಲ. But
And that ended in a compromise.
You know, I understand. That's what again coming back to that. Even if it has ended in a compromise also.
You are in a dominant position. What you have done to your sister-in-law and the legal heirs. You get it compromised. It's not, partition suit is not decided on merits. Kodi.
The effect of section head not game.
And but you are very careful. ಬರೆಯಲ್ಲ ಇದು. ಹೇಳಿದ್ದಲ್ಲ, ಮೊನ್ನೆ ಹೇಳಿದ್ದು, ಇವೆಲ್ಲ ತೆಗೆದ್ಬಿಡಿ. So,
And one more thing is, there is no material to indicate that during the pendency of the suit, there was any knowledge of the sale deed to the members of the persons who are parties to the suit. Sale deed happens in 97. Suit is compromised in 1999. No, 97 not that happens, not in 99. Now what I'm saying is, correct, but But as on. Not all, that's, it's a joint family property. Apart from that, our other contention is this, our main case is that because the fact that your lordship may also kindly bear in mind one circumstance. Suit is of the year 1983. How do? That's otherwise we could not have divided the property. Because what happened is this, in 1983, when the suit is filed, Jairam Appa was alive. This property was also subject matter of the partition suit, right from 1983. It is not as if, my lord, subsequently this 13 guntas is included. 13 guntas is the proper subject matter of the suit right from 1983, along with 1 acre 5 guntas of land. But my submission is, coming back to what I'm trying to clarify to your lordship, my submission is only this. 13 guntas is in physical possession of Jairam Appa's family, that is including our clients. There is nothing to indicate that possession of 13 guntas is handed over by Jairam Appa's wife and son alone, along with Revankar, because Revankar also admits, that is Revankar's family also admit that the property was in possession of Jairam Appa's branch. This Revankar's family. No. At the time of executing the sale deed, I am submitting. Even the Harish, that is the appellant in the first case, in his evidence he has admitted, I may be permitted to read the relevant portion of the evidence also. And also recitals in Exhibit P1. The fact that the document is in existence cannot be disputed by the appellants in the other cases. May I read that particular Exhibit P1 for a moment? That I may be permitted to draw your lordship's attention to recitals of Exhibit P1. Sale deed in favor of Harish in respect of 13 guntas of it. Kindly go to Exhibit P1. How? Sale deed. Club common evidence. Relevant portion is in internal page 3 of the sale deed. Yes. ಮೇಲ್ಕಂಡ ತುಕಾರಾಮ್ ಯಶವಂತ ರೇವಂಕರ್ ಅವರ ಜೀವಿತ ಕಾಲದಲ್ಲಿ ಮೇಲ್ಕಂಡ 4ನೇ ಮಾರಾಟಗಾರರ ಯಜಮಾನರು ಅಂದ್ರೆ ಜಯರಾಮಪ್ಪ, 5ನೇ ಮಾರಾಟಗಾರರ ತಂದೆಯೂ ಆಗಿದ್ದ ಜಯರಾಮಪ್ಪನವರಿಗೆ ಸ್ವತ್ತನ್ನು ಕ್ರಯಕ್ಕೆ ಕೊಡಲು ಒಪ್ಪಿ ಜಮೀನಿನ ಸ್ವಾಧೀನತೆಯನ್ನು ಅವರಲ್ಲಿಯೇ ಬಿಟ್ಟಿದ್ದ ಕಾರಣ ಸದರಿ ಜಮೀನಿನ ಸ್ವಾಧೀನತೆಯು ಮೇಲ್ಕಂಡ ಜಯರಾಮಪ್ಪನವರ ವಶದಲ್ಲಿಯೇ ಇದ್ದು ಅವರ ದಿನಾಂಕ 3/2/96 ಮೃತಪಟ್ಟ ನಂತರ ಮೇಲ್ಕಂಡ 4ನೇ ಮತ್ತು 5ನೇ ಮಾರಾಟಗಾರರ ವಶಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಆದ ಕಾರಣ ಇದು. So here in the sale deed itself, there is a categorical admission relating to two aspects. Number one, execution of the agreement of sale in favor of Jairam. Second, Jairamappa being put in possession of the property. That's why I'm trying to again go back to the filing of the suit in 1983. In that time itself, this property was included. And after the death of Jairamappa, these people, only two of the legal heirs, without the knowledge of the other parties to the family, if they have executed a sale deed in favor of the other members of the, in favor of the Revankar, Harish, does it in any way bind is one aspect of the matter, and they could not have handed over possession to him. ಅಲ್ಲ ಅವರಿಬ್ರು ಹೇಳ್ಕೊಳ್ಳೋದು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 in this case Channakeshwa and Jairamappa's wife Nanjamma. These are the two persons who have executed the document during the pendency of the suit. And our main contention is this is the family is in possession of the property under the Channakeshwa. ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ಕೊಳ್ತಾರೆ ಆ ತರ. ಅವನು ಹೇಳ್ಕೊಳ್ತಾನೆ. In the sale deed, he refers to it like that. He is one of the vendors. One son. He claims other people are not parties to the sale deed. No other members of the family are parties to the sale deed. Wait a minute. Correct. Who are not parties here? Yes, they are legal. They are also parties here. No, they are not plaintiffs. But what is happening? They are dependents. Mirror what? Jairamappa's legal case were not even brought on record here. What has happened is subsequently in the compromise decree, this property also is divided by among the members of the among the branch of Jairamappa also. All the legal cases also have taken a portion of the property, including these dependents 1 and 2. When possession is with the joint family, whether two of the legal heirs of one of the members of the family could have alienated the property and could have transferred possession without the consent of the other members of the family is one aspect of the matter. That too during the pendency of a partition suit, to which they are parties. We were not aware of it. It is not that nothing is on record to indicate that in the suit, when the suit was pending, other members of the plaintiff in the said suit or other members of the family were in the know-how of the particular sale deed. No document is there. So in that context, what these people are contending is, there was a partition even in respect of 13 guntas also, and the plaintiffs in the connected suit or connected appeal, they are claiming their rights on the basis of this and on the contention that there is an agreement to sell which has been admitted. And even PW1, that is Harish, in his cross-examination, he admits that there was an agreement with Jairamappa and he was in possession of the property. So this particular factum of there being an agreement, Harish admits that under the agreement to sell, he was taken, this Jairamappa was put in possession. But this is so far as my case is concerned. Getting back to their appeals, Now, I may be permitted to make my submissions regarding the appeals filed by them. Their appeals. The appeals filed by the other side. 24 to have been. In this background, my respectful submission is, there was a registered partition decree. And admittedly, there was an agreement to sell. And admittedly, subsequent to the agreement sale, in 1983, a suit for partition is filed, including this property. And Jairamappa was a party. What I'm submitting is, at any point of time, during the lifetime of Jairamappa, there is no material to indicate that Jairamappa had claimed this particular property to be his exclusive property. Neither this 13 guntas nor 1 acre 5 guntas, which is purchased in the name of Jairamappa, was claimed by Jairamappa as his self-acquired property. It was a joint family property. That is how it was described in the suit. There was no claim by anybody, including Jairamappa, disputing this particular claim. But suit is in the year 1983. Why I am repeatedly saying is, that has happened at an undisputed point of time, much earlier to execution of sale deed in favor of Harish. It is not something we are trying to grab the property which is sold to Harish and including divide the property clandestinely. There is no such motive can be attributed to the members of the family, because this property was the subject matter of the suit right from 1983. And there is no material to show that 1997 sale deed in favor of Harish was within the knowledge of the parties to this. And it was divided. So in that background, there is a valid partition decree passed by the court. Sale deed in favor of Harish is only during the pendency of that. And we could not have included him as one of the parties in the suit, partition suit, because we were not aware of it in 1999. For the first time, we come to know about the sale deed in favor of Harish only in 2000, when he files a suit. So in this background, he is not a bona fide purchaser, number one. The sale in his favor is also not a bona fide sale, because it is not executed by all the members of the family. So under these circumstances, the contention of the appellants in the connected appeal 407 is that they have acquired valid rights in respect of the property. The possession of Jairamappa and the family in respect of 13 guntas was not taken away in a manner known to law. Admittedly, he was in possession of the property under section 53A of the Transfer of Property Act. So no question of claim. And there is a valid partition decree under which they are claiming their rights. And they are seeking rights in the intention in respect of 4 guntas of land, which is the suit schedule C property in the suit filed by them. Now, I may be permitted to make my submissions in respect of the other cases, other 2 cases. The first 2 appeals, which they have filed, wherein we are also parties. And now, our money maduduru, I thought I can clarify. Substantially I'd argue, if your lordship permits me, I will make my submissions, and if there is anything else is there, I will be able to. I'll just take the water. Your lordship may kindly see. Kindly see the suit schedule in OS number 2426 of Bantu, Commissioner report Bandak. What has happened is this, Miller. Kindly see the situation. I'll just try to clarify, because your lordships have had it in detail on the other. I may not take much time on that. Apart from all the commissioner sketch and other things, I wanted to bring to your lordship's notice what is the conduct of the plaintiff in the appeal in OS RFA 1276 of 2000. That is very important. Now, your lordship may kindly see, in the agreement to, the sale deed in favor of Revankar, boundaries are specific. In fact, in my notes which I have prepared, I have referred to the boundaries. which today just now I passed on. My lord, the eastern boundary is Halla, 13 guntas. Western boundary remaining land of the vendor, Muniyama's land. Sketch ಇದೆ, but ಇದರಲ್ಲಿ ಯಾವುದು schedule in the sale deed I am referring to first. Sale deed in favor of Revanka. First sale deed, exhibit P4. Exhibit P4 ಒಂದು ನಿಮಿಷ.
P4.
P4. Lordship got it. Lordship got it.
Yes, sir.
P4 ಅಲ್ಲಿ third page, first page, second page bottom number.
Third page.
Third page ಅಲ್ಲಿ boundaries ಇದೆ. Check in the second page land is listed as 40/6. Of course, I don't want to make much of it. Boundaries ಪೂರ್ವಕ್ಕೆ ಹಳ್ಳ. You will have to get it. ಮೇಲ್ಗಡೆ ಟಾಪ್ ಅಲ್ಲಿ. In the third page.
Third page.
Yes. ಇದು.
ಚೆಕ್ ಬಂದಿ. ಪೂರ್ವಕ್ಕೆ
ಹಳ್ಳ. Lordship got it.
Yes, sir.
ಪಶ್ಚಿಮಕ್ಕೆ.
ಅದೇ ರಿಮೈನಿಂಗ್ ಪೋರ್ಷನ್ ಆಫ್ ದಿ
ಕರೆಕ್ಟ್. ಉತ್ತರಕ್ಕೆ ಇದೇ ನಂಬರ್ ಪೈಕಿ ನಾವು ಉಳಿಸ್ಕೊಂಡಿರೋ ಜಮೀನು. ದಕ್ಷಿಣಕ್ಕೆ ಹಳ್ಳ.
ಅಲ್ಲ, ಪಶ್ಚಿಮಕ್ಕೆ ಏನ್ ಬಂತದು?
ಪಶ್ಚಿಮಕ್ಕೆ ನಾವು ಸ್ವಂತಕ್ಕೆ ಉಳಿಸ್ಕೊಂಡಿರುವ ಜಮೀನು. ಉತ್ತರಕ್ಕೆ ಇದೇ ನಂಬರ್ ಪೈಕಿ ನಾವು ಉಳಿಸ್ಕೊಂಡಿರುವ ಜಮೀನು. ದಕ್ಷಿಣಕ್ಕೆ ಹಳ್ಳ. ಅದಲ್ಲದೆ ನೆಕ್ಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್, ಈ ಮಧ್ಯೆ ಇರುವ ಜಮೀನಿನಲ್ಲಿ ರೋಡ್ ಹೊಸದಾಗಿ ರೋಡ್ ಬಂದಿರುತ್ತೆಯಾಗಿ ಈ ರೋಡಿನ ಎರಡು ಕಡೆಗಳಲ್ಲೂ ಇರತಕ್ಕ 13 ಗುಂಟೆ ಜಮೀನಿಗೆ ನಿಮಗೆ ಶುದ್ಧ ಕ್ರಯ ಮಾಡಿದೆ ಎರಡು ಕಡೆ. ದಿಸ್ ಇಸ್ ದಿ ಸ್ಪೆಸಿಫಿಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ನಾವು ಕೈಂಡ್ಲಿ ಗೋ ಟು ಎಕ್ಸಿಬಿಟ್ P1.
Exhibit P1 ಏನು?
Is a sale deed in favor of appellant in the first appeal. That is 24-26.
ಅಲ್ಲ, ಹರೀಶ್ ಅಂತ ಹೇಳಿ.
Harish, I'm sorry, Harish. In favor of Harish.
ಇದು P4 ಯಾರ ಪರವಾಗಿ ಆಗಿದೆ?
P4 Muniyamma in favor of Revanka.
Revant.
Tukaram. I am linking those documents. Exhibit P1.
ಒಂದು ನಿಮಿಷ ಸರ್, ಒಂದು ನಿಮಿಷ. Exhibit P1.
P1 is the sale deed in favor of Harish.
Yes.
Other boundaries ತಗೊಂಡ. I will read the boundaries.
Yes, boundaries.
Boundaries are mirror east by Kodigehalli LA. There is a difference here.
ಏನಿದು ಕೊಡಿಗಳ್ಳಿ?
Kodigehalli LA, boundary of Kodigehalli. LA ಅಂದ್ರೆ boundary, limits.
Yes.
West by the property of this Jairam Appa's wife and son, that is how it described us. ನಾಲ್ಕನೇ ಮತ್ತು ಐದನೇ ಮಾರಾಟಗಾರರ ಜಮೀನು 1 acre 5 gunters, which is divided among all the people.
Yes.
North by ಬೈಯಮ್ಮನ ಜಮೀನು. South by ಕೊಡಿಗೆಹಳ್ಳಿ ಎಲ್ಲೆ.
North by
land of ಬೈಯಮ್ಮ.
ಬೈಯಮ್ಮ.
ಅದು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, but in the earlier sale deed, it is referred to as the remaining land retained by the vendor or something like that.
Yes.
South by ಕೊಡಿಗೆಹಳ್ಳಿ ಎಲ್ಲೆ.
ಕೊಡಿಗಳ್ಳಿ
ಎಲ್ಲೆ.
ಮತ್ತೆ same.
South ಕೂಡ same. So eastern boundary was Halla in the first sale deed. Southern boundary also was Halla. And apart from that, the other description is, ಈ ಮಧ್ಯೆ ಇರುವ ಜಮೀನಿನಲ್ಲಿ ಕೊಡಿಗೆಹಳ್ಳಿಯಿಂದ ತಿಂಗ್ಳು ಗ್ರಾಮಕ್ಕೆ ಹೋಗತಕ್ಕ ರಸ್ತೆ ಜಾತ. ಈ ರಸ್ತೆ ಎರಡೂ ಬದಿಗೆ ಇರತಕ್ಕ 13 ಗುಂಟೆ ಜಮೀನು ಈ ಕ್ರಯಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. This 13 guntas of land which is on the either side of the road, excluding the road, is sold.
Such a complicated description I have not come across.
I am trying to make it as simple as possible. They want to, what is sought to be sold is either the land 13 guntas on the either side of the road.
Either side of them.
Either side of the road.
Actually ಅದಕ್ಕೆ ಎರಡು separated, two boundaries ಬರಬೇಕಾಗಿ.
ಕೊಡಬೇಕಾಗಿ ಕೊಟ್ಟಿದ್ರೆ
ಎರಡು ಪೋರ್ಷನ್ಗೆ 4 ದಿಕ್ಕ ತೋರಿಸಬೇಕಾಗಿತ್ತು.
ಹೌದು.
ಸೊ ಎರಡು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಬರ್ಬೇಕಾದ್ರೆ
ಬರ್ಬೇಕಾಗಿ ಈ ಕಡೆ ಇಷ್ಟು ಈ ಕಡೆ ಇಷ್ಟು ಮಾಡಿ 2 items ಅಂತ ಮಾಡಬೇಕಾಗಿತ್ತು, ಮಾಡಿ. ಬಟ್ ದಿಸ್ ಇಸ್ ದ ಸೇಲ್ ಡೀಡ್ ಇನ್ ಫೇವರ್ ಆಫ್
ಈಗ ದಕ್ಷಿಣಗಿರೋ ಕೊಡಿಗಳ್ಳಿ ಹತ್ರ ಈ ರೋಡಿಗೆ ಅಕ್ಕಪಕ್ಕ ಎರಡು ಕಡೆ ಅಂತ ಬಂತು.
ದಕ್ಷಿಣಕ್ಕೆ ಕೊಡಿಗೆಹಳ್ಳಿ ಎಲ್ಲೇ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದ್ರ ಹತ್ರ ಇರೋ ರೋಡಕ್ಕೆ ಎರಡು.
Whether this boundary is again correct or not is doubtful, because as per the earlier sale deed, southern boundary is Halla.
Correct. He is owner, but he has failed to substantiate which portion.
Not only this, in the suit which he files, kindly see the suit, why that I am submitting the suit schedule. This is not an inadvertent mistake. In the suit schedule, how he describes the property is, all piece and parcel of so and so, measuring 5.5 guntas ಅಂತ ಇವ್ರು ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ, 7.5 guntas ಅವ್ರು ಮೇಂಟ್ ಮಾಡ್ತಾರೆ. ನಾರ್ದರ್ನ್ ಬೌಂಡ್ರಿ ಏನ್ ತೋರಿಸ್ತಾರೆ ಅಂದ್ರೆ ಕೊಡಿಗೆಹಳ್ಳಿ ತಿಂಗ್ಳಿ.
ಎದರಲ್ಲಿ?
ಇವ್ರ ಸೂಟ್ ಶೆಡ್ಯೂಲ್. This road is supposed to be passing in between the land, in the middle of the land. He shifts that land, whatever he claims to have purchased, to the south of the road.
Plain schedule in OS 2426, correct?
And the same schedule, your lordship gets it in respect of 7.5 guntas while describing the northern boundary to be the road. He purchases 13.5 guntas.
ಅಲ್ಲ, ಈಗ ಅದಕ್ಕೆ ಬಂದಿದೆಯಲ್ಲ ಬೈ ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್.
ಅದರಲ್ಲೂ ಕೂಡ ಕಮಿಷನರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ, the boundaries shown in the sale deeds and boundaries shown in the suit schedule do not tally there ಅಂತ. He has given a categorical finding by the court commission. What I am submitting is, why they have done like this is, while shifting the land to the south of the road, they want to indirectly make a claim in respect of 1 acre 5 guntas of land belonging to Jairam. This is not an inadvertent mistake. Nobody can say it is an inadvertent mistake. Virtually, they are making a claim in respect of a property which do not belong to them, both the appellants.
Already ನಿಮ್ ಬೌಂಡ್ರೀಸ್ ಏನಿದೆ?
ನಮ್ಮ boundaries ನಲ್ಲಿ ನಾವು kindly see the boundaries in my suit, madam. We have referred, we are claiming part of this 13 guntas only on either side of the road. ಅದರಲ್ಲಿ 4 ಗುಂಟೆ. Thirdly, may show this rough sketch which was filed along with the suit.
Yes, sir.
This is the sketch that was filed along with the plane, showing the description of the property,
ಇದು ನಿಮ್ ಸ್ಕೆಚ್?
plain sketch. ನಾವು ದಾವಾ ಹಾಕಿದಾಗ ನಮ್ಮ ಸೂಟಲ್ಲಿ I think it must be part of my record, but otherwise also I can show you. Oh, yes.
ನೋಡ್ರಿ ಅದು.
8,745 of 2000.
Where's the 8745 ರೆಕಾರ್ಡ್ಸ್ ತಗೊಳ್ಳಿದ್ರು? ಇದೆಯಾ?
Five.
Where the sketch?
Yes, madam.
ಎಲ್ಲಿದೆ ಸ್ಕೆಚ್?
Plain jete the sketch will along with the plane, rough sketch along with the plane.
8745.
I don't know whether it must be there in the record.
ಕೊಡ್ರಿ ತೋರ್ಸಿ.
ಕೆಲವು ಸಲ ಅದನ್ನ ತೆಗೆದು ಬೇರೆ ಇದೆಲ್ಲ ಹಾಕ್ಬಿಡ್ತಾರೆ. ನಿಮಿಷ ಇದಲ್ಲೇ ನಾವು ತೋರಿಸೋಣ ಅಂತ. Let me pass on. It is there. ಕೆಳಗಡೆ ಮಧ್ಯದಲ್ಲಿ ಅದು ಏನ್ ಮಾಡ್ತಾರೆ ಇವರು, they separate the files, marked, unmarked documents and all that. ಅಲ್ಲಿ
Yes, sir.
ಸಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ರು ಸೂಟ್ ಅಲ್ಲಿ. ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ದ ಸೂಟ್ ಇನ್ 8745 ಅಲ್ಲಿ. ಸಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಈಸ್ ದ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ ಕ್ಲೈಮ್ಡ್ ಬೈ ದಿ ಪ್ಲೇಂಟಿಫ್ಸ್ ಇನ್ ದಟ್ ಸೂಟ್. Krishnamurthy and Govindaraj. This is on the eastern side of the road. Road is shown to be running between north to south. On the western side, another 5 guntas is there. Eastern side, there is 8 guntas. That is divided among the brothers. D4 and D5 are the family of Jairamappa.
ಸರ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ಸರ್ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ ತೋರಿಸಿದೀರಾ ಸ್ಕೆಚ್ ಅಲ್ಲಿ?
ಸಿ ಶೆಡ್ಯೂಲ್ ಅಂತ ತೋರಿಸಿದೆ ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ.
ಹಾ,
ಅದು 2 ಗುಂಟೆ 4 ಗುಂಟೆ.
ಯಾವ್ದದು 2 ಗುಂಟೆ ಏನದು?
ಈ ಪಾರ್ಟಿಷನ್ ಡಿಗ್ರಿ ಪ್ರಕಾರ ಅಲಾಟ್ ಆಗಿರುವಂತ ಭಾಗ. In 13 guntas, your lordship may kindly see, the road is running north to south.
You are directly laying a claim over Lentis property, overlapping.
We are claiming that that is our property because we are.
No, you show that, show your sale deed.
Yes, ma'am.
Jairamappa, sale deed tors. Jairamappa's sale deed.
Agreement to sell. This is not the sale deed property alla idu. Idu agreement to sell 13 guntas idella.
That you have to go by Tukaram's boundary only. You can't change it.
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. ಇವಾಗ ಏನಾಗ್ತಿದೆ, that's what I'm trying to make. Lordship may kindly go back to sketch once again for a moment. Lordship may kindly see the sketch mirror.
ಅದು sketch ಅಲ್ಲಿ ನೋಡಿ.
ಅದೇ ಇನ್ನೊಂದ್ಸಲ ನೋಡಿದ್ರೆ kindly see this 13 guntas is on the either side of the road. 5 guntas is the portion which is allotted to Veerabhadrappa and Narayan Swami. And on the eastern side, 8 guntas is there. So this 8 guntas and this 5 guntas is the property which has been subject matter of the agreement of sale in favor of Jairamappa is our case. And he has been in possession. That has been one of the properties divided in the partition suit. And as per the partition compromise decree, this C schedule property, each measuring 2 guntas on the eastern side of the property was allotted to the share.
Yes.
That is the case. That's how we have described the boundaries. So far as the description of the boundaries in our suit schedule are concerned, it is in consonance with the compromise decree passed in OS 3726 of 1983. There is no variation. We have not tried to make a claim in respect of a property which we are not claiming. Because ultimately, your lordship may not say that, may or may not agree with me that we have got the property divided under the partition deed, compromise decree. But this property is the property which was allotted to our share in the compromise. There is no dispute about it. And this is the property which Jairamappa's wife and son have sold in favor of Revan. In favor of Harish. That is where the dispute lies. Because we are making a claim, what Harish has done is, he has shifted his boundaries to the south of the road. In respect of 1 acre 5 guntas belonging to us. Now plainly we have referred to the partition decree and everything has been stated. We have not said, referred to agreement to sell, all that. There is no attempt on the part of the plaintiffs in this case either to misrepresent the facts or to make any false claim.
ಅದು ನಮಗ್ ಬಿಡಿ.
ಅಲ್ಲ ನಮ್ಮ ಸಬ್ಮಿಷನ್ ಅದು.
ಬಿಡಿ.
That is my submission because that is, according to me, that is based on the facts pleaded before the court. So far as the plaintiff in this case is, these 2 appeals are concerned,
Yes, sir.
They have deliberately made a wrong claim in respect of a property which is not purchased by them. But finally, before I conclude my arguments, Commissioner's sketch, Your Lordship, may kindly, report to Your Lordship, may kindly.
Commissioner sketch. Commissioner sketch. ಇದ್ರ ಪ್ರಕಾರ ನಿಮ್ದು 1 acre 5 ಗುಂಟಾಸ್ ಎಲ್ಲಿ ಬರುತ್ತೆ?
ಯಾವ್ದು?
ಈ ಹೈಕೋರ್ಟ್ ಕಮಿಷನರ್
Report ಅಲ್ಲ.
ಸ್ಕೆಚ್ ಪ್ರಕಾರ
Yes. As per the report. ADEF.
ಎ
ADEF. 3B1.
ಇದು ನಿಮ್ದಾ?
ಅದು 1 acre 5 gunters which is purchased.
3B1 ನಿಮ್ದಾ? ನಿಮ್ದು 3B1.
3B1. ಅದು 1 acre 5 gunters. Purchased by Jairamappa.
3B2 is Harish.
3B2, 13 gunters or EFGH ಅಂತ ಏನ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೋ, that is the disputed property. Which we are also claiming under the agreement to sell and we are in possession ಅಂತ, we have divided ಅಂತ.
ಅಲ್ಲ ಅದು 3B2 ಪ್ಲೇಟಿವ್ ಅದು ಹರೀಶ್ ಅವ್ರದ್ದು ತೋರಿಸ್ತಾ ಇದಾರಲ್ಲ.
ಅಲ್ಲ, correct, that's what my submission is.
ಅಲ್ಲ, ನಿಮ್ ಸಬ್ಮಿಷನ್
ಅಲ್ಲ, correct. That is what is shown to be the property, 13 gunters ಅಂತ ತೋರಿಸ್ತಾರೆ. ಅದು as per the sale deed ಇದು ಮಾಡಿದ್ದು ಹೇಳೋದಷ್ಟೇ ಅವರು. 13 gunters of property ಆ ತರ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಮಾಡ್ತಾರೆ. EFGH is the district property which is claimed by both the parties. But of course, Harish is not claiming that property in the suit. Harish is claiming a property which is to the south of this road.
ಅದು ಆ ಸ್ಕೆಚ್ ತೋರಿ. Yes, sir.
But this 13 gunters, what is shown?
Now the project, Rao sir, the project suit is only in respect of this 13 guntas. Your suit is subject matter. What is
My
the subject?
suit is only in respect of
4
4
gunters.
gunters out of 13 gunters. And their suit is in respect of 13 gunters, which is not the property purchased by them. That's what I would like your lordship to kindly consider. It is not that they are making a claim in respect of the property purchased by them under the sale deed. They are trying to make a claim on the basis of that sale deed in respect of a different property altogether, which is to the south of the court. That is why your lordship may kindly see the report of the commissioner. He has categorically stated after referring to the boundaries in all the cases. In internal page 7 of the commissioner's report, he says, the property bearing old survey number 47/3B 4D conducted so and so, situated at Tinlu Kondigal, the 4D boundaries are not in tallying with the boundaries in the sale deed dated 4/10/62, 25/10/72, 21/3/84, 29/3/97, 31/8/99. Then kindly come down here. The available land in survey number 47/3B is measuring 2 acres 10 guntas, out of which 9 guntas is Port Karal. The remaining land is 2 acres 10 guntas, in which existing Tindlu Kodigavile road is 10 guntas. After deducting the same for the available land, what is available is 1 acre 31 guntas. Out of that, admittedly, 1 acre 5 guntas is purchased by us. There is no dispute about that by Jairamappa in 1972. Another 13 guntas is again transferred, that again subject matter. How can Nanjappa get 32 guntas in 1984?
No, you didn't tell me what are the boundaries of your 1 acre 5 guntas.
But 1 acre 5 guntas boundary, that's on the western side. There's no dispute about it.
Torsi.
There's 72 sale deed, your lordship may kind.
Oh. Exhibit, the exhibit ado?
There is some confusion here in my records, Mr. That document I am not able to. That same deed, I will draw you lordship.
That is not produced?
It is produced, what is happening in the exhibits which I have, I am not able to lay my hands immediately. But there is no dispute about 1 acre 5 guntas.
No, I want to know where it is located.
I will, in the commissioner's report,
You are finding fault with the description in Harish's sale deed, no?
Yes.
Let us see.
1 acre 5 guntas ke ನಾವು ದಾವಾನೆ ಹಾಕಿಲ್ಲ.
Let us see what is sold to you, how she has.
1 acre 5 guntas ಗೆ ನಾವು ಸೂಟೆ ಹಾಕಿಲ್ಲ.
ಅದು ನೋಡೋಣ, ಅದು ಮುನಿಯಮ್ಮ ನಿಮ್ಗೆ ಮಾಡಿ ಕೊಟ್ಟಿರೋದು ಜಯರಾಮ ಅದಕ್ಕೂ ನೋಡೋಣ, ಅದಕ್ಕೂ ಬೌಂಡ್ರಿ
ಕಮಿಷನರ್ಸ್ ರಿಪೋರ್ಟ್ ತಾವು ನೋಡಿದ್ರೆ
ಅದಕ್ಕೂ ಬೌಂಡ್ರಿ ನೋಡೋಣ.
Just now. Right now, I am not able to lay my hands on the document. Commissioner's report only. He has given the description of all the sale deeds. Kindly go to page 5 minutes, Commissioner's report.
ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ?
And ಸೇಲ್ ಡೀಡ್ ಅದರಲ್ಲಿರೋ ಬೌಂಡ್ರೀಸ್ ಅಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ ಕಮಿಷನರ್.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ.
No, I want to see how.
I will give the sale deed. Your lordship may kindly bear with me.
Yes.
Next set of hearing. Because right now I am not able to lay my hands on that.
Anything else?
Subject to further.
ಯಾವ್ದು?
If anything else is there, I will make.
It's not.
Ugly argument. But according to me, the suits, as long as they have not made a claim in respect of 13 guntas of land, which is the subject matter of a partition decree in the suits filed by them, their suits will have to be dismissed and my suit will have to be decreed, because they are not making a claim in respect of 13 guntas, which we are claiming.
Allah, you all come under same umbrella.
Correct too, but ಈ suit ಅಲ್ಲಿ ಅವರು
all are tracing through Revankar.
Correct.
So they can't be conflicting boundaries.
But what I am
There
submitting.
can't be conflicting boundaries.
What I am submitting is,
Yeah.
if they had made a claim in the suit for 13 guntas purchased by them under the sale deed, showing the same boundaries, that is different. They have not made a claim in respect of that property, in which event, their suit has to be dismissed. If that suit is to be dismissed, my partition decree should stand, and my suit will have to be decreed, made respect to submit.
Yes,
Because
sir.
they have not made a claim in respect of 13 guntas purchased by them.
No, same portion is the subject.
ಇಲ್ಲ ಇಲ್ಲ ಸೂಟಲ್ಲಿ ನಾ ಹೇಳ್ತೆ ದಾವಾದಲ್ಲಿ ಅವ್ರು ಕೇಳ್ಬೇಕಲ್ವಾ
Ah, correct. You are right.
ಅದು ಹೇಳ್ತಾ ಇರೋದು.
You are,
ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಮೇಕ್ ಓನ್ಲಿ ದಟ್ ಪಾಯಿಂಟ್.
though, that's why trial court was dot on. It said that you are owner of 13 guntas, but not the descriptive boundaries given.
That's
Not
why
in
suit
terms
is
of-
rightly dismissed. Suit is dismissed already.
Yes, we'll examine whether it requires reconsideration insofar as those two plaintiffs are concerned.
Milord, my
And
submission.
your
would be-
rights has to
No,
be
my
examined
submission would be this, Milord.
in the light of
No, my submission is.
agreement and your
any-
compromise.
Any reconsideration, Milord,
Ah.
will have to be considered in respect of all the suits.
You know,
Any reconsideration if it requires.
I like that.
It requires in, because they are all clubbed together.
Yes,
There cannot be a partial remand of only one or two suits.
let us see, let us see.
Yes, Milord.
If I were to remand, I will assign reasons.
You will-
I'll assign reasons. I'll deal
No,
with it.
I'm sure your lordships will assign the
I'll
reasons.
deal
Don't dispute it. But I'm only making a submission because common evidence was recorded. Common pleadings were there. So many connected aspects are there. In that way, I'm
Yes.
making a request.
Yes. Yavagni?
My lord, maybe on 8th or 10th. Because his health is
All right,
Yes,
date
ma'am.
ಕೊಡು. ಯಾವತ್ತು?
8th or 10th.
ಇವ್ರದ್ದು RFA 407 reserved.
Milord, 407 Milord, your lordship may hear it along with other.
ಅಲ್ಲ ಆ ದಿವಸ ನಿಮ್ ಮತ್ತೆ ನಿಮ್ದು ಆಗಿದೆ.
ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗೋಗುತ್ತೆ.
ಅಲ್ಲ
ಅಂದ್ರೆ there is a-
ಆಲ್ ರೈಟ್ ಅದನ್ನು ಅದು ಇರ್ಲಿ.
Kindly
ಹಾಗೆ
decide all the cases
ಹಾಗೆ
together.
ಬಟ್ ನೋ ಬಟ್ ಯು ಕನ್ಕ್ಲೂಡೆಡ್ ಬರ್ಕೊಡಿ.
What I am saying
Council appearing for appellant in RFA 407 has concluded his arguments.
I may be given
Good.
liberty if anything else is there.
ಅದ್ ಮಾಡಿ ಅಷ್ಟು ಕೊಡ್ತೀನಿ ಸರ್.
ಯಾಕಂದ್ರೆ ನನಗೆ ಇವಾಗ ವಾಟ್ ಎವರ್ ಐ ಕುಡ್ ಇಮಿಡಿಯೇಟ್ಲಿ ರಿಕಲೆಕ್ಟ್ ಐ ಹ್ಯಾವ್ ಮೇಡ್.
ಹಳೆ ಕೇಸ್ ನಾವು ಮುಗಿಸ್ಬೇಕಾದ್ರೆ ಬಹಳ ಕಷ್ಟ ಇದೆ. ಮೌಂಟೇನಸ್ ಟಾಸ್ಕ್.
ಐ ಆಮ್ ಇನ್ ಫ್ಯಾಕ್ಟ್
ಇವೆಲ್ಲ ನಮಗೆ ಬರೆಯಕ್ ಬಿಡಿ. Allow us to write a judgment ಅಷ್ಟೇ.
I don't want to come
Please
in the way of
cooperate.
the court deciding.
ಪ್ಲೀಸ್ ಕೋಆಪರೇಟ್. ಇಲ್ಲ ಯಾವ ಕಾಲಕ್ಕೂ ಮುಗಿಯಲ್ಲ ಇವು.
Yes, Milord.
ಈ ಹಳೆ ಕೇಸ್ ಯಾವ ಕಾಲಕ್ಕೂ ಮುಗಿಯಲ್ಲ.
ಈಗ ನಾನು ತುಂಬಾ ಕಷ್ಟಪಟ್ಟು ಒಂದು 2007 ಸೂಟ್ appeals. We got them last year.
559 ಆಗತ್ತಾ?
Oh, my lord. His health conditions are critical. So
ಹೌದಾ?
he need time for recovery. His blood
ಇಲ್ಲ,
sugars are
ಅದ್-
fluctuating drastically.
ಚೆನ್ನಾಗಿ-
Blood sugar,
ಅದಕ್ಕೆ ಅವರಿಗೆ ಒಂದು ಅಲ್ಟರ್ನೇಟ್ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ ನಾನು ಟೈಮ್ ಕೊಡ್ತೀನಿ. 10 days ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಆಫ್ಟರ್ 10 days.
much obliged, my lord.
ಚೆನ್ನಾಗಿದೆ ಏನಾಗಿದೆ?
ಆಕ್ಚುಲಿ
ಚೆನ್ನಾಗಿದೆ sir ಅದು ನಿನ್ನೆ night.
ಇವ್ರೆ ವಾಟ್ಸ್ ಅ ಗುಡ್ ನೇಮ್. ಹಿ ಹಸ್ ಆರ್ಗ್ಯೂಡ್ ರೀ.
Yes,
It was urgent only for him to argue. He has to give a reply now.
yes, my lord.
He has argued.
Yes, my lord, but his conditions are
In section. All
serious.
right.
So that's the only reason we are taking the
Aye.
treatment.
12-9.
Much obliged, my lord.
Much obliged.
Serial number 14, the reporting settlement serial number 14. Parties are present, we are filing the joint memo.
ಹೌದಾ? ಎರಡೂವರೆ ಮಾಡ್ಬೋದಾ?
Withdraw ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ವಿಡ್ರಾನೇ ಮಾಡ್ತಾರೆ.
13 also.
Complaint
there
number
is
1 and 2
nothing-
are present.
13 also, there's nothing to it. Only it may not be said that I have conceded.
13, my lord, serial number 13.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಅದು ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ.
I'm sorry.
ಅಭಿನವ್ ಅವ್ರೆ.
Sorry, I'm
ಅಲ್ಲ.
sorry.
ಬಿಡಿ ಒಂದ್ ನಿಮಿಷ. All right.
Both the appellants present.
Now, they are present before the court.
Present, please,
Both are present.
please.
Settle out of court, settle out of court. In fact, other
ಇನ್ನೊಂದು
RFS
appeal ಅಲ್ಲಿ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಹಂಗಾಗಿ ಇದನ್ನು 7 ಅದನ್ನ ಬರ್ದಿದೀವಿ.
ಬರ್ದಿದೆ. Both the appellants.
ಈಗ ಬರು. ಬೇಕಾ ಬೇಡ? ಈಗ ಶಬ್ದ ಬರುತ್ತೆ.
Please.
Oblige.
Serial number 32, my lord.
But our commissioner report, our objection, I have made objection. Our only commissioner report objection ಅಂತ ಒಂದು ಕೊಟ್ಬಿಟ್ರೆ let them not say further that no opportunity was. Any date, next week, any date, I am ready. In fact.
My lord, in serial number 13, both of us are here.
32. ಯಾವತ್ತು?
My lord, we are both here in 13. There is
serial
nothing
number-
much to the case.
1-3. Lord, suit for ejectment, tenant's appeal, possession is already delivered. Only mean profits, my lord, is without conducting inquiry 50,000 ಅಂತ ಮಾಡಿದ್ದಾರೆ. Admitted rent was 40,000. 40,000 ಮಾಡ್ಬಿಟ್ರೆ ಕ್ಲೋಸ್ ಆಗೋಗುತ್ತೆ. ಅಷ್ಟೇ.
It may not be,
Last day, my lord, my colleague had appeared. Sorry. Sorry. That is all that is there in this appeal.
I am equally guilty, my lord, of not being present on the last. I am equally guilty of not being present.
ಅದು damages mean profits 50,000 ಮಾಡಿದ್ದಾರೆ. There is no enquiry. But admitted rent is 40,000. 40,000 ಅಂತ ತಾವು ಮಾಡಿ ಮುಗಿಸ್ಬಿಡೋದು. Possession is already delivered way back in the year 2012. There is no difficulty about that. ಅಲ್ಲ ಅದೇ 40,000 ಅಂತ ತಾವು ಮಾಡೇ ಮುಗಿಸ್ಬಿಡಿ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. That is the admitted rent. Admitted rent is 40,000. My lords may modified. Partly allow ಮಾಡಿ. Yes, because possession is already delivered.
My only request is it may not be said that I conceded in last.
That he has not considered. ಅಲ್ಲ 80,000 for 2 months, 40,000 and then 50,000 as handing over. So 40, which is the admitted rate of rent. ಅಷ್ಟ ಅದಕ್ಕೆ ನೋ ಡಿಫಿಕಲ್ಟಿ ಬಿಕಾಸ್ ಏನು ಎನ್ಕ್ವೈರಿ ಮಾಡಿಲ್ಲ.
ಹೇಳ್ತಾರೆ ಇವ್ರು ನೋಡು. ಎಷ್ಟಾಯ್ತು? 14 ಅಂತ ಎಷ್ಟಾಯ್ತು? 13 ಮುಗಿಸ್ಕೊಂಡ್ರು.
Serial number 15, my lord.
Grateful.
Serial number 15, my lord. ಅದರಲ್ಲಿ LRSಗೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 24 and 25 ತೀರೋಗಿದ್ದಾರ. ಅವರಿಗೆ ನಾನು ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದೀನಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಲ್ಲ. ಇಲ್ಲ ಅಂದ್ರೆ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ತಪ್ಪಾಗಿ. ಅದು ಕಂಪ್ಲೈ ಮಾಡ್ತೇನೆ ಸ್ವಾಮಿ ನಾನು. ಅದನ್ನ ನಂಬರ್ ಆಫ್ ಡೇಸ್ ತಪ್ಪಾಗಿದೆ. ಕನೆಕ್ಟೆಡ್ 3 ಇದೆ.
ನಮ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ
15 492. That is the original main appeal. ಸ್ವಾಮಿ ಕಟ್ಟಿದ್ದೇನೆ, ಇವತ್ತು ಕಟ್ಟಿದ್ದೇನೆ. ಕಟ್ಟಾಯ್ತು. 15.1 ಕಟ್ಟಿದ್ದೀನಿ. 14 and 15.
My lord, in connected matter, in connected cross objection, my lord, on the last date of hearing, my lord, and by way of hand summons, it has been directed to serve the copy and the summons, my lord. we have served on some of the respondents and some of the, we'll file it in the countable.
Issue notice ಆಗ್ಬೇಕಾಯ್ತದು ಎಲ್ಲರೂ. ಆಯ್ತು sir.
Date, date may be fixed, sir.
ಹೋಗ್ಬೇಕು, ನಾನೇ ಹೇಳ್ಬೇಕು ಅಂತಿದ್ದೀನಿ. ಆದ್ರೆ ನಂಗೆ ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್, ನಿಂತ್ಕೊಳ್ಳೋದು ಕಷ್ಟ ಆಗ್ತದೆ ನನಗೆ. ಆಕ್ಚುಲಿ ರೆಡಿ, ಬಟ್ ನಾವು ನಂದು 16 ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ 2 times 3 times ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದಿದ್ದಾರೆ. ಆದ್ರೂ ಮತ್ತೆ ತಮ್ಮ ಮುಂದಿದೆ ಅದೀಗ ಅಪೀಲು 3 times. ನಂಗೆ ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕು. ನನಗೆ ಒಂದು ಹೈ ಶುಗರ್, ಅನ್ಕಂಟ್ರೋಲ್ಡ್, ಆಮೇಲೆ ಹಾರ್ಟ್ ಆಪರೇಷನ್ 2 ಆಗಿದೆ ನನಗೆ. ಸ್ವಲ್ಪ ಒಬ್ಲೈಜ್ ಮಲ್ಲ. ಸಿದ್ಧಿವಿನಾಯಕಾಯ ನಮಃ. ಸಿದ್ಧಿವಿನಾಯಕ. ನಿಮ್ದು 59 15
ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಇದೆಯಾ?
ನಿಮ್ದು? ನಂದು 59.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಇದೆಯಾ? ಹಲೋ,
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಇದೆಯಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಸರ್ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಸು ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು. ಊಟ ಮಾಡಿ ಸರ್. ಥ್ಯಾಂಕ್ ಯು. ಇದರಲ್ಲಿ ಇದು ಮಾಡೇ ಇಲ್ಲ ನಾವು ಹೈಕೋರ್ಟ್ದು. ಇಲ್ಲ ಮಾಡದ, ಇದು ಸರಿ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೆ. ಆಮೇಲೆ ಹೈಕೋರ್ಟ್ ಮಾಡಿಲ್ಲ, ಇದ್ರಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಇಲ್ಲ. ಹೆಂಗೋ ಮಾಡಿದ್ಯಲ್ಲ ಅವತ್ತು.
ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ, ಇದೆಲ್ಲ ಮಾಡಕ್ಕಿಲ್ಲ.
ಇದ್ರಲ್ಲಿ ಆಗುತ್ತೆ, ಅದ್ರಲ್ಲಿ ಇತ್ತಲ್ಲ ಇನ್ನೊಂದ್ರಲ್ಲಿ, ಅದು ಹಂಗೆ ಇದಾಗಲ್ವಾ?
ಏನಪ್ಪ ಜಾಯಿನ್ ಮೀಟಿಂಗ್
ಅಲ್ಲಿ ಏನೇನೋ ಬಂದ್ಬಿಡುತ್ತೆ. ಆಮೇಲೆ ಏನೋ ಬಂದ್ಬಿಡುತ್ತೆ ನೋಡು.
ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ವ, ಆಗಲ್ವ?
ಯಾಕಾಗಲ್ಲ?
ಬಟ್ ಅಲ್ಲಿ ಕನೆಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ.
Defendant.
Yes.
Lordship, C. Narayan Swami,
First suit ಯಾರ್ದು?
first suit that is filed by the defendant.
Then we'll refer Shivan as plaintiff.
Yes, yes, sir.
We'll refer you as,
In the same manner it is referred.
what's your name? You are defendant number one.
Defendant number one,
See Venkat Swami, you are the
Venkat
defendant.
Swami.
All right. That's how it's referred.
Yes.
All right. All right, plaintiff sale deed.
Plaintiff sale deed is dated 3/3/1982. That was in favor of one Lakshmamma.
Lakshmamma.
Not Lakshmamma sold the site to
Present
plaintiff.
All right.
And his sale deed is 2/12/1991.
One ನಿಮಿಷ. Narayan Swami sold to Lakshmamma.
Lakshmamma, 3/3/1982.
3/3/1982. Lakshmamma in turn sold it to plaintiff, correct?
Plaintiff, 2/12/1991.
2/12.
12/1991.
Yes.
Defendant sale deed,
You purchased from Lakshmamma,
no, I purchased from C. Narayan Swami.
Narayan Swami.
Yes. 29/8/1986.
29/8.
1986.
All right, in the sale deed of Lakshmamma, what was the schedule?
Schedule, your lordship,
Whether it was referred as 65/2 or 65
65,
in Lakshmamma sale deed?
Lakshmamma sale deed.
Yes. Then who has executed this rectification deed now?
Rectification deed executed by C. Narayan Swami in favor of Lakshmamma
He,
at on 18/12/1990.
18.
18/12/1990.
Please date
18/12/1990.
18/12/1990. 1990.
1990.
So Lakshmamma sale deed is based on rectification deed in favor of plaintiff.
Yes, he confers her
Favor of
the,
plaintiff.
yes.
Now whether Narayan Swami owned only this property, had other properties.
He,
What?
he had stated that he had entered into an agreement with one person and he had formed the layout. As he referred to him to sign the sale deeds, he has signed. That is his contention.
All right, in Lakshmamma sale deed, property is referred as survey number 65
65,
and site number 18.
site number 18.
Yes.
Now, till 18/12/1990, Lakshmama had no rights or there were no rights conferred over the subject matter of the property. Only by executing the rectification deed, subsequent to the executing sale deed in my favor, the second defendant wants to confer a right on her,
All right.
which
now-
is illegal.
All right. Now, can you give a schedule of Lakshmama and your sale deed? Lakshmama sale deed is marked as what? 1982 sale deed, alva?
Also,
It's marked, it's produced and marked,
a produce and mark,
exhibit
P1,
exhibit P1.
yes.
Name sale deed,
Exhibit D1,
named exhibit D1.
D1.
All right, give me this schedule now. Lakshmamadu ಆಮೇಲೆ ನಿಮ್ದು ಎರಡು.
Yes, sir. East by site number 17,
ಒಂದು ನಿಮಿಷ. East, site number
17,
17, all right. West,
uh,
West.
next to site number 17, Khata number 212:4-17.
ತಗೋಬೇಕಾ relevant ಅದು?
Better. West by site 30 feet road, north by 25 feet road, south by site number 26.
South,
Site number 26.
all right. ನಿಮ್ sale deed?
East by site number 17,
Same
same.
Whether encumbrance is produced by both the
Yes.
parties?
Yes, encumbrance are produced, your lordship.
ಯಾರು produce
No.
ಮಾಡಿದ್ದಾರೆ? Who has produced?
He has produced, the plaintiff has produced plaintiff's encumbrance. I have produced my encumbrance. I have verified the title. When I obtained the encumbrance, there was no entry so far. The sale of this property is concerned, referred in exhibit P1.
Ah,
My encumbrance at exhibit D5.
yes, sir.
So in Lakshmama's encumbrance, my sale deed wouldn't have referred,
This property falls within jurisdiction of BBMP or which?
BBMP.
Khata is generated.
No, at that time, it was tax, tax was paid, but for the dispute, khata was not issued here.
Yes.
No. I was put in possession of the property. I was in continuous possession of the property. And I filed a suit in the year 1992. Paper book I have produced at page number 141 to 143. Against Narayan Swamy, I had filed a suit because he started interfering in my possession. Therefore, I had filed an injunction suit against him. Till then, even then, I did not come to know that he has executed the rectification deed and plaintiff is claiming the suit, the subject matter
What happened to
property.
that suit?
That suit, Your Honor, I was an employee of KSRTC. I had entrusted to an advocate, but due to diligently, it was not prosecuted and that suit came to be dismissed, Your Honor. So
For
the suit
non-prosecution or on merits?
for non-prosecution.
So in 92, right from 86, I was in possession.
All right, OS number
1692 of 1992. Exhibit D,
1692/92.
92, Exhibit D7,
Exhibit
D7.
yes.
Coming to know that I am the absolute owner in possession of the subject matter property, the plaintiff wanted to interfere and create a evidence that he is in possession of the property and he is attempting to construct put a construction and foundation. In that manner, your lordship, he created, and he approached the court and filed the suit for injunction in 1990.
Mr. What's your good name? What's your good name?
Premnath.
Premnath. Directly come to the point now.
Yes, sir.
Demonstrate how this rectification is impermissible under law, or show that how it is bad in law. Because property, there is no dispute in regard to identification. There is one minor error in not mentioning subdivision of a survey number. Common vendor, he owned only one site. He has sold it to Lakshmamma. Subdivision is not reflected. Then there is a rectification.
Yes.
So demonstrate how this rectification is bad in law.
No, your lordship, when he has sold the property to me, by giving a proper description and correct schedule and correct property number, and put me in possession, in accordance to the Transfer of Property Act, I am in possession of the property. Now, if your lordship takes the sale deed of Lakshmamma, 1982, the sale deed was executed. Till 1990, there was no any correction so far her sale deed is concerned. And so far intimating her, when once he loses his rights, transferring his right in the subject matter property to me, he is precluded from executing any deed to perfect the deed of earlier sale deed.
Fine. TPX. Now, Premnath, only subdivision is not mentioned. Property is identified by boundaries. And it refers to survey number 65. Whether that sale deed, first sale deed, executed by Narayan Swami in favor of Lakshmamma, whether title stands conveyed under a properly executed registered document or not.
If your lordship takes the survey number is concerned, she will not be having a title.
Why?
No, because your lordship, rectification deed can be upheld if any interference or any changes or the property is not sold to any other person. Then the sale deed will become perfect if rectification deed is executed. Here, he has sold the property, which is perfect in so far the boundaries and concerns, so far survey numbers are concerned. Once he sells that, your lordship, according to the provisions of transfer of property, he loses his right.
Are you able to, Premnath, are you in a position to demonstrate that by way of rectification, the erstwhile owner and the first purchaser have tried to bring in a new property? Have they brought in a new property, totally different?
By
property?
mentioning survey number itself, it amounts to new property, your lordship.
Now boundaries are there.
No, let the boundaries are there.
Correct.
There is no dispute so far. We admit the boundaries are there. That is my contention, your lordship, where rectification deed, so far Transfer of Property Act, it is not been defined.
Yes.
And if your lordship peruse the provisions of Registration Act, Section 48 precludes the person who transfers his right.
Yes.
Once he transfers his right, he won't be having any legal right to meddle with that property.
Same argument will be advanced by your adversaries now.
Yes.
Because they are said it is
No.
in the earlier point of time.
No, because your lordship, the rectification deed can be recognized provided there is no transfer of property in between the sale deed and rectification deed.
Yes.
Because rectification is deed is not defined. It is only to rectify. Now, survey number 65, it is entire, it is different land. 65 but 2, where specifically it has been mentioned in my sale deed, and I was put in possession, knowing fully well that I am in possession, I have not brought to the notice so of executing the rectification deed. I am not party to the deed.
All right, show from the record that survey number 65 exists. Whether survey number 65 is in existence or was it in existence as in the date of sale deed obtained by Lakshmamma in 1982.
Your Lordship, so far that aspect is concerned, I have not produced any document. So far, say existing of 65 is concerned. Now, only if the provisions of Transfer of Property Act, Registration Act is taken into consideration, the question will arise, once the sale deed is executed with correct boundaries and correct survey number, whether the person who has executed earlier, he will have any right to deceive me or to take away my right in the property, Your Lordship. Now, that aspect is not dealt so far before the court below. No, rectification, because there is no provision so far the rectification deed is concerned. My argument is that if he wouldn't have sold the property to me and he has not put me in possession of the property, then he can execute number of rectification deeds. Once he has transferred his right in the perfecting the title in my favor, so far the subject matter property is concerned, can Your Lordship after 8 years, by executing the rectification deed, he confers the entire title so far the Lakshmamma is concerned.
Anything else?
So my
short point, that's a short point.
It's a short point. Your Lordship, so far this honorable court has held in Head Note C.
Yes, sir.
Shall I read it out? Once a sale deed is registered, the document shall operate from the time from which it would have commenced to operate if no registration thereof had been required or made in view of the clear provision of Section 47 of the Registration Act. The provisions of Section 47 of the Registration are attracted to all the successive sale deeds executed by the same vendor in respect of the same property. The question of priority has therefore to be determined only with reference to the principle embodied in Section 48 of the Transfer of Property Act. Section 48 of the Transfer of Property Act incorporates an important principles that a man cannot convey a title better than what he himself possesses. If a person effects a transfer of property in accordance with law, he cannot thereafter deal with property already transferred by him. If a person has effected a transfer of property, he cannot thereafter deal with the same property, ignoring the rights already created by the earlier transfer effected by him. Consequently, the sale deed executed first, when registered, prevails over successive subsequent sale deeds in respect of the same property. Dealt in para 13.
Yes.
Relevant para. It is true that under Section 54 of the Transfer of Property Act, sale of tangible immovable property of the value of ₹100 and upwards can be made only by a registered instrument. But once the document is registered, Section 47 of the Registration Act comes into operation, which provides that the registered document shall operate from time to time, from the time from which it would have commenced to operate. if no such registration thereof had been required or made, and not from the time of its registration, Section 48 of the Transfer of Property Act determines the priority when there are successive transfers. It provides that where a person purports to create by transfer at different times rights in or over the same immovable property, and such rights cannot all exist or be exercised to their full extent together. Each later created right shall, in the absence of a special contract or reservation binding the earlier transferees, be subject to the rights previously created. Section 49 of the Registration Act provides that until the document is registered, it shall not affect any immovable property, nor can the document be received in evidence. The right of priority in this case will have to be determined by the combined operation of provisions of Section 48 and 54 of the Transfer of Property Act and Section 47 and 49 of the Indian Registration. Once a sale deed is registered, there would be compliance of the provisions of Section 54 of Transfer of Property Act as well as Section 49 of the Indian Registration Act. Once a sale deed is registered, the document shall operate from the time from which it would have commenced to operate if no registration had been required of Section 47 of the Indian Registration. The provisions of Section 47 of the Registration Act are attracted to all the successive sale deeds executed by the same vendor in respect of the same property. The question of priority has therefore to be determined only with reference to the principle embodied in Section 48 of the Transfer of Property Act. Section 48 of Transfer of Property Act incorporate an important principle that no man can convey a title better than what he himself possesses. If a person effects a transfer of property in accordance with law, he cannot thereafter deal with the property already transferred by him. If a person has effected a transfer of property, he cannot thereafter deal with the same property, ignoring the rights already created by the earlier transfer effected by him. This principle has been laid down by the Privy Council in so and so.
Yes.
Where dealing with a case also requires registration. The Lordship of the Privy Council laid down that where the donor of immovable property had handed over the donee an instrument of gift duly executed and attested, and the gift has been accepted by the donee, the donor has no power to revoke the gift prior to the registration of the instrument. To the same effect is also the principle laid down by the Supreme Court in so that was a case of successive mortgages. The Lordship of the Supreme Court held that the agreement creating mortgage by deposit of title deeds executed on 5th July 1947 but registered on 22nd July 1948 would prevail over the subsequent mortgage deed executed in favor of third person on the 10th October 1947, on the ground that though the subsequent mortgage was registered earlier than the previous document creating mortgage, once the earlier agreement was registered, the same takes effect from the date of its execution by the application of Section 47 of the Registration Act and prevails over the subsequently executed and registered mortgage in favor of the third person. In view of the authority pronouncement of the Privy Council and the Supreme Court, it is not open to this court to follow the principles laid down by the Calcutta High Court. So and so. The view which I have taken also accords with the view taken by the High Court of Madras. For the reasons aforesaid, Your Honor, this is the decision. Innondeli? Judgment.
Yes.
Lordship. Therefore, he has, before the rectification deed, he has conferred the title in my favor. That is the defendant. So he cannot meddle with the property and to deceive my right in the property, he through the rectification deed, he cannot perfect the title of the plaintiff.
Yes.
Which is illegal, and I was not a party to the rectification deed.
Yes, sir.
On question of litigation by law. Kindly take the plaintiff OS 6648 1996, paras 4 and 5.
limitation, Ah.
Confused. Negative and fairly discuss ಮಾಡಿ ಅದನ್ನ ತಗೊಂಡು ಹೇಳ್ತೀನಿ. Para 4 and 5.
of their plate,
Of the 6640 there.
ಎಲ್ಲಿದೆ ಪೇಪರ್ ಬುಕ್ ಇದೆ. Plenty in 6640. Yes, sir.
My lord, para 4. Shall I read, my lord?
Para 4.
Yes, my lord.
Yes, sir.
This suit of the year 1996, my lord. That is why I am reading this para. That in the year 1992, the second defendant attempted to disturb the possession of the plaintiff who had put up a compound wall as in as much as one room accommodation for watch and ward in the scheduled property constrained to prevent the injunct the second defendant herein. The plaintiff filed a suit against C. Narayan Swami, that's my vendor. The second defendant herein OS number 1692 on the file of the city civil court. I don't want to go further, my lord. He was aware about the sale in my favor in the year 1992. He had already filed a suit. So the cause of action was in the year 1992, my lord.
Yes.
My lord, the next para. Para 5. Around the same time, the plaintiff received summons in suit number OS 2150 instituted by the first respondent. That is in the year 1992.
Yes.
Lordship may kindly come to the previous page, cost title here, manner. Number 6640 of 1996, instituted after a period of 4 years, a suit for declaration. So it's clearly barred by limitation, my lord, that I need not say. That is 3 years under the Limitation Act, my lord. Lordship may kindly come to the impugned judgment, my lord.
Yes.
On this issue, my lord, para 17 of the judgment, my lord, impugned judgment. On issue number 4, para 17, my lord, about 10 lines, my lord. Summons served to defendant, that is C. Venkata Swami, lordship got, my lord, appeared before court on 16/4/1992. He appears in the trial court on 16/4/1992. Engaged counsel. That means on 16, this is judgment, my lord. That means on 16/4/1992, defendant number 1, Venkata Swami, the appellant herein, came to the knowledge that H.H. Shivanna is claiming title over the suit property adverse to his interest and also claiming possession adverse to his deed. Sale deed. The title of the suit property came to be disputed by filing suit number 2150 of 1992, and the defendant C. Venkata Swami came to knowledge that his title to the property was challenged and disputed by H.S. Shivanna in the month of April 1992. But C. Shivanna filed suit OS 6640 of 1996 on 21/9/1996 after a lapse of 4 years, 5 months, when the title of the property is disputed. Shall I continue, my lord?
Yes.
The suit for declaration of title has to be filed within 3 years from the date of dispute or from the date of knowledge of the dispute. Admittedly, C. Venkataswamy not filed the suit within a period of 3 years from the date of dispute of his title of his property. So on this ground also, the suit of the defendant Venkataswamy, who filed OS 640, is also barred by time.
Yes.
That is on limitation, my lord. Now, my lord, kindly take the cross-examination of.
Sheet number 4 in
ಹೌದು ಸ್ವಾಮಿ, ಅದು that is regarding negative ಅದರಲ್ಲಿ
ಅದು affirmative
ಕಂಪ್ಲೀಟ್ ಆಗಿ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಬಟ್ ಫೈಂಡಿಂಗ್ ಇಸ್ ದೇರ್ ಮೈ ಲಾರ್ಡ್.
that is answered in affirmative.
Yes, my lord. Yes, my lord. Now, my lord, coming to the evidence, my lord. Cross-examination of DW1, my lord.
This is in regard to limitation again.
Yes, my lord. He has admitted everything, my lord.
Page.
I don't know there, my lord. It is shown as 3, but it is cross-examination dated T2/2003 of DW1, my lord.
TW1.
DW1. But plaintiff is always referred to me, my lord, because my suit was earlier. He is DW1, my lord. Lordship got it, my lord?
Just a minute. I'm looking at
3-2, my lord. About 8-10 lines, my lord. Cross of DW1 on 3/2/2003.
Correct.
My lord. About 8 to 10 lines, my lord.
Yes.
Lordship got it. Prior to filing of OS.
Yes.
Prior to filing of OS so, I did not file any suit against Shivanna from 1992 to 1996. He admits. Now I see the caveat application bearing 1153 of 1992. And also the Wakalatnama wherein my signatures are found. 1992, he files a caveat against me. He files a Wakalat in my suit. But the declaration suit is filed in 1996, my lord. My signatures on the caveat and Wakalat are at exhibit D10A and D11A. That also I have got it marked, my lord. Lordship got it, D10A and D11A. Those are the documents in the caveat, my lord. Signatures.
Yes.
2 lines thereafter, my lord. Last sentence, last words. I have seen two lines thereafter, man. I have seen the production of documents in the police station by Shivanna when I went to police station in the year 1992. How many admissions, my lord, that he had the knowledge in 1992?
Yes.
Now, my lord, next page, my lord. About 4 lines, my lord. Same. H.N. Shivanna might have got plans sanctioned in respect of survey number 65, admits possession.
Just a minute.
Afterwards, I have seen the rectification deed. Witness volunteer. Rectification deed is not relating to his site. About 15 days back, I went to my site. Photos produced, exhibit P7 series are not pertaining to my site. Then if there is a dispute that it is not his site, photos produced by me does not pertain to his scheduled property. Rectification deed does not pertain to his property. His suit doesn't survive because it pertains to totally a different property. I am in possession of that property, my lord. That is his own admission.
Yes.
His suit fails, my lord. My lord, now. Sixty-six 40, his suit for declaration plain. Prayer may kindly be seen, my lord. There are totally 4 prayers, my lord. Lordship got it. There are 4 players, my lord, A, B, C, D. First prayer, my lord, I am forced to read it, my lord. No other go. To declare the plaintiff is the absolute owner property bearing number so and so and so. Second prayer, declare rectification deed so and so and so is bad, not binding. Third prayer, permanent injunction. Fourth prayer, any other relief. Where is the relief for possession, my lord? A suit simpliciter for declaration is not maintainable as held by Supreme Court repeatedly, and your lordship must have come across that hundreds of times. It could decide. My lord, first judgment. ಮಾರ್ಕೆ ಮಾಡಿಲ್ಲ ನಮ್ಗೆ ಒಂದೊಂದೇ
ಅಲ್ಲ ಮೆಂಟನಬಿಲಿಟಿ
ಮಲೆ
ತಗೊಂಡ್ರ ನೀವು
ಮಲೆ
whether you took a defense in your written statement.
My lord, this is first appeal, maintainability of the suit on question of law and question of fact.
ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇದೀನಿ.
ಇಲ್ಲ ಅವ್ರು ತಗೊಂಡಿರ್ಲಿಲ್ಲ ಆದ್ರೂ ಕೂಡ ನಾನು ಇವಾಗ ತಗೊಂಡಿದ್ದೀನಿ ಮೇಡಮ್ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಎ ಫಸ್ಟ್ ಅಪೀಲ್ both on question of law and question. The remand by the Supreme Court, particularly in this matter, my lord, is only on that question because there is no complete reappreciation of evidence, both on questions of law and question of fact. I had appeared before the Supreme Court in this matter, and I only submitted my arguments, my lord. The Supreme Court said nothing doing, it has to be reappreciated.
Yes. All the judgments on 34, section 34.
ಇಲ್ಲ ಎರಡೇ ಜಡ್ಜ್ಮೆಂಟ್ ಎರಡೇ ಜಡ್ಜ್ಮೆಂಟ್ ಸರ್ ಇಲ್ಲ ಅದನ್ನ ಡೈರೆಕ್ಟ್ ಆಗಿದೆ ಸಣ್ಣ ಓದ್ಬಿಡ್ತೇವೆ ಸ್ವಾಮಿ ಪ್ಯಾರಾ 45 ಆಫ್ ದಿ ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ
Para 45.
ಎಸ್ ಮ್ಯಾಮ್ ಪ್ಯಾರಾ 45 ಲಾರ್ಡ್ಶಿಪ್ ಗಟ್
Yes.
Supreme Court ಮೇಲೆ in that 46 section 34 discretion as to court in that proviso, my lord, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of the title, omits to do so.
Yes.
My lord, para 49, my lord. Now, we now proceed to examine the law on that issue as submitted by the learned senior counsel for the appellant in so and so and so and so. This court, while considering section 42 of the erstwhile specific relief act to be in pari materia with section 34 of the present SPA, observed that the plaintiff not being in possession of the property in that case ought to have amended the plaint for the relief of recovery of possession in view of the bar included by the provision. This position has been followed by this court in Union of India versus Ibrahimuddin, elaborated the position of the suit. There, the extract. The section provides that courts have discretion to declare the suits of rights. However, it carves out an exception that a court shall not make any declaration of status or right where complaint, being able to seek a further relief than a mere declaration of title, omits to do so. Then, my lord, in the same para, 3-4 lines This court dealt with a similar issue where the plaintiff was not in exclusive possession of property and had filed a suit seeking declaration of title of ownership. Similar view has been reiterated, observing that the suit was not maintainable if barred by the provision to section 34 of the Specific Relief Act. In view of the above, the law becomes crystal clear that it is not permissible to claim the relief of declaration without seeking consequential relief. In the instant case, the suit for declaration of title of ownership had been filed, though respondent one plaintiff was admittedly not in possession of the suit property. Thus, the suit was barred by the provision of section 64 of the Specific Relief Act and therefore ought to have been dismissed solely on this ground. The High Court, though framed a substantial question on this point, but for unknown reasons, did not consider it proper to decide the same. Next, a few lines later, Mela, para 51. It was further expounded that a court noted that the suit was never amended, even at a later stage, to seek the consequential relief, and therefore it was held to be not maintainable. The position of law has been reiterated recently in Akkamma versus so and so and so.
You are relying on this because there is a finding of fact in your suit.
Oh, yes, my lord. Possession is also with me from the beginning because in 1992,
Vacant site,
madam,
vacant site.
vacant site. Vacant site, I had put up construction. In 1992, I had the plan. And
there was a construction.
Oh, yes, my lord. Photos are produced in the suit. Photos are produced. My lord, even then, de jure possession, de facto possession, my lord. What does the de jure possession say, my lord? The person who holds a better title always holds the possession so far as a vacant property is concerned. Possession in respect of a vacant plot or de jure possession is concerned, it is title. De facto is I have produced photographs, I have produced the sanctioned building plan. They are all marked, my lord. 1992. Therefore, admittedly had lost possession.
What are those exhibits?
P17 series, my lord. My lord, the second judgment is quoted in this judgment. This is a 2024 judgment, my lord.
Exhibits.
Exhibit P17 series, my lord.
Yes.
Second judgment is referred to in this judgment itself. This is a 2024 judgment. My second judgment is quoted in this, my lord. Now, my lord. This is on maintainability, my lord. Now, coming to the question regarding the identity of the property and his possession and what happens to the documents which was executed earlier, how it will have to be interpreted and all, my lord.
Yes.
Third judgment in my paper book, my lord. Paras 4 and 5, my lord. A small judgment. Only 2-page judgment, my lord. Third judgment, my lord. Para 4, my lord.
ಯಾವ್ದು ಪಾರ್ಟಿ ಹೆಸರು?
Party is Harishchandra.
Yes.
Lordship got it, my lord. Para 4. The learned counsel so and so opinion for submits that they are the bona fide purchase of property from the brother of the petition. The boundaries of the suitable property are the same as mentioned in the registered sale deed executed by the brother of the petitioner on 12/8/1985. However, in the registered sale deed, the property number was wrongly mentioned as survey number 67/A instead of survey number 57/A. Subsequent to the execution registered sale deed, the vendor has handed over possession of suit property to the respondent and they are in possession of the same. The petitioner placing reliance on the revenue documents cannot claim the title and ownership of the property alienated to the respondent by his brother. Considering these material aspects, the lower appellate courts allowed the appeal, reversing the order of the trial court. We do not warrant interference. My lord, next para, my lord. 100% similar case, my lord. Heard the learned, shall I go through, my lord?
Yes.
Heard the learned counsel and peruse the metropolitan record. The identity of the suit property is the focal point in these proceedings. It is imperative that the respondents have purchased the property through a registered sale deed dated 12/8/1985 from its previous owner, Sri Shantilal, son of so-and-so, who is none other than the real brother of the plaintiff. The boundaries mentioned in the sale deed are the same as that of the boundaries of the suit property. It is the case of the respondent, survey number 67/A is mentioned wrongly instead of 57/A. It is well settled law that the boundaries prevail over the measurements and the survey number. Therefore, the wrong mentioning of the measurement or the survey number would not frustrate the rights of the bona fide purchasers who have purchased for valuable consideration. It is also a well settled legal position that the revenue entries do not confer any title or right. It is not a conclusive proof. The presumptory value of the revenue entry can be repeated by adducing substantial evidence. The relevant factors which are to be examined for granting directly similar case, my lord.
No, boundaries are the leading description.
Yes, my lord. Yes, my lord. My lord.
Question is, which is the leading description?
Yes, my lord.
Extent, survey
For
number.
the time being, my lord.
Or boundary.
Yes, my lord. For the time being, my lord, we will forget that there was no survey number in my property. There was survey number in his property. Why mistake, my lord? There was no survey number at all. What happens, my lord? Can you come and say there is no survey number there? My property has a survey number. Therefore, I'm the owner. Survey number was consequential when it was an agricultural property, my lord. When the property was sold, it had the municipal number and survey number was totally inconsequential, my lord.
And site number.
Yes, my lord. Site number and boundaries. That is one aspect, my lord.
Corresponding municipal number was assigned to it. Corresponding municipal number was assigned.
Yes, my lord.
There is a reference in the same.
18. Yes, my lord. It is there. 18. 18.
Site number 18.
Site number 18.
Number was not there.
I will show it, my lord. I will show it, my lord.
It was not under CBMT jurisdiction at that point of. Also.
Lordship may kindly take the document itself, my lord. Exhibit P1. I don't want the court to be hooked into my lord. My lord, the exhibit P1 is my cell deed, my lord. Schedule may kindly be taken, my lord. Lordship got it, my lord. Schedule, my lord. Of sale deed dated 3/3/82. It's in my favor, my lord. P1.
ಪ್ರೇಮನಾಥ್ ಎಕ್ಸಿಬಿಟ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ.
ಯಾರು ಪೇಜ್ ಮಾಡಿಲ್ಲಲ್ಲ?
Page number.
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ಪೇಜ್ ಇಲ್ಲ. Yes.
92 page number.
My lord, what had happened, my lord? It had come before the lordship, Justice Shirav. Normally he would say paper book dispensed. Paper book was dispensed. It has not been served on me. No paper book is given. He has prepared it and filed it. In spite of request, never gave to me. I am not able to refer it from the paper book, my lord.
Yes.
So I had to refer it without that. Schedule, my lord. Lordship got it, my
Yes.
lord. All that piece and parcel property bearing house khata number 212/3/18 in the converted survey number 65. Without 65/2 cannot exist at all, my lord. Bar 2 has got to be a part of 65. So when 65 exists, whether it is 65 bar 2 or 3 or 4 or 5, it is a part of 65, my lord.
Yes.
My lord, in the sale deed, both the sale deed, measurement from east to west is 30 feet, north to south is 40 feet, boundaries on the east, west, north, south are all same. The executant is the same. It is not their case that the executant had more than one property. Therefore, there could be some identity crisis because whether the property is conveyed X or Y. Because she had only one property, she could not have conveyed any other property except this property. She could not have conveyed any other property, my lord. When once a property is conveyed in when once a property is conveyed, my lord, the conveyor.
Nagaraj sir, you can maintain the speed. Move to the next point. Convinced?
Yes, my lord. The fourth judgment, my lord, in the T. Narayan, small judgment, my lord. Siddhamma versus Chikkamma.
Number?
I do fourth judgment, my
Fourth
lord. Fourth judgment, my lord. Para 6, my lord.
Yes.
Last 2 lines, 3 lines, my lord. It is now well settled that even if there was misdescription of survey number, the identity of the property could be established on the basis of the boundaries. In other words, mistake in mentioning the survey number in the sale deed at the most would be treated as a misdescription and we would not affect the identity of the property. The boundaries given in unmistakable terms establishes the identity. The judgment of the Supreme Court Supra clearly supports the view. The contention of the defendants, therefore, with respect to the suit land must fail. My lord. Then, my lord, fifth judgment, my lord, it's also a 3-page judgment, my lord, small. My lord, T. Narayan versus Kanyakumari Builders. A typical, I can't say same because there can't be 2 sets same. Para 19, my lord.
Para?
19. Fifth judgment, para 19, my lord. I'm sorry, my lord, I should have serially paged also. Due to
Correct.
paucity of time, I was out of station.
Yes, sir.
Today
Para-
morning only I came. Para 19, my lord.
ಅದ್ ನಿಮ್ ಜೂನಿಯರ್ಸ್ ಮಾಡ್ಬೇಕು ನೀವಲ್ಲ. Yes, sir.
My lord, it is thus clear that if the agreement of sale, the general power of attorney and the sale deed are carefully scrutinized, the property purchased by the defendant in survey number 14/P7 and not survey number 14/P6. Boundaries mentioned in these documents clearly show that the defendant purchased 15 guntas of land in 14/P7. The agreement to sell execute the plaintiff followed by the registered sale deed clearly state that 25 guntas of land in survey number 14/P7 was owned by the plaintiff. There is a clear recital in the sale deed that 15 guntas of land in survey number 14/7 was conveyed to the defendant. The sale consideration boundaries and so on. Mere reference to the property standing is old number so and so and now 14/7 will not change the property sold, particularly when the boundaries are clear and unambiguous. Para 20, my lord. Plaintiff intends to take advantage of the mistake committed in correctly mentioning the land in survey number P14/P6 in the general power of attorney executed after the agreement of sale. Instead of mentioning the survey number as 14/P7, it has been mentioned as 14/P6. But the boundaries mentioned in the area are that of 14/P7. The same thing continues there subsequent. One more, my lord. Only 2-page judgment, my lord. 1.5
Same
page.
line now, same
What?
line.
Same line.
No, don't read it, paragraph, just let me.
Yes.
Paragraph.
Para 8, my lord.
ಆಯ್ತು.
I'll just quote the paras, my lord, so that my lord, the other one is an seven judgment is an unreported judgment, my lord. I have quoted the judge, everything. It's in paras 3, 4 and 5. It's a small judgment, my lord. Very small judgment.
Yes.
Paras 3, 4 and 5.
ಎಲ್ಲ boundary ಇದ್ರ ಮೇಲೆನಾ?
Yes, my lord.
All these
Even if there is error in mentioning the survey number, suit schedule property is identified by boundary. That's all it says, my lord. 3, 4 and 5, my lord.
ನಾವೊಂದು ಬರ್ದಿದ್ದಿಲ್ಲ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇಲ್ಲ ಅದನ್ನ ತಂದಿಲ್ಲ.
ಅದನ್ನ ಸುಜಾತ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ಸುಜಾತ ಮೇಡಮ್ಸ್ ಜೊತೆ ಅಲ್ವಾ ಸ್ವಾಮಿ ತಾವು ಬೈದ್ಬಿಡ್ತೀರಾ? ಸುಮ್ನೆ ಆಗ್ಬಿಟ್ಟೆ ಇದನ್ನೇ ಕೋಟ್ ಮಾಡ್ತಿದ್ದೀರಿ ಅಂತ ಸ್ವಾಮಿ. ಅದು ತುಂಬಾ ದಪ್ಪ ಇತ್ತು ಸ್ವಾಮಿ ಆಕ್ಚುಲಿ. ಆಲ್ ದಿಸ್ ಇಸ್ ನೆಕ್ಸ್ಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್.
There I have discussed.
ಎಸ್ ಮೈ ಲಾರ್ಡ್. ತುಂಬಾ ದೊಡ್ಡದಾಗಿದೆ ಮೇಡಮ್ ಸ್ವಾಮಿ ತಾನು ಓದ್ದೆ.
No. You have to look into what constitutes a leading description ಅಂತ.
Yes, my lord. Yes, my lord. It's a substantially big.
Some cases, you have to go by the measurements. If measurements constitute a leading description.
Yes, my lord. Yes, my lord. I read it, my lord. I wanted to bring
Boundaries constitute a leading description. Then measurement is of no consequence.
In fact, I wanted to mention it that pertains to a road formation of a road, my lord. I remember it, my lord. Remember it, my lord.
On same line, all this.
Yes, my lord. All same, my lord. I will mention only paras, my lord.
ನಾನು ನೋಡ್ತೀನಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಎಲ್ಲ ನೋಡಿ ಎವ್ರಿಥಿಂಗ್ 100% ಸೇವ್, ಮೈ ಲಾರ್ಡ್. ನೋ, ಮೈ ಲಾರ್ಡ್. To avoid if there is any confusion, my lord, I will take your lordship through the genealogy, my lord. One Srinivas was the original vendor who sold it to Mr. Narayan Swami, my lord. Narayan Swami played the mischief in executing two sale deeds, one in favor of Lakshmamma and one in favor of Venkat Swami. I purchased it from Lakshmamma, my lord, because in the sale it was mentioned as 65. I got it rectified as 65/2. And his contention is, because it is mentioned as 65, it doesn't convey title at all. Because 65/2 is different from 65. Therefore, you don't get in the right title or interest at all over the property. And it was not a sale deed at all. My sale deed is only the sale deed. That is all the crux of the sale deed, my lord. Other things all I have referred to, my lord. Suit is not maintainable on two grounds: limitation plus suit simpliciter without seeking the relief.
Even on merits.
Even on merits. Otherwise on merits.
Even otherwise.
Yes,
according
yes,
to you.
ma'am. Yes, ma'am.
ಅದು DNP ಆಗಿತ್ತಲ್ಲ ಇದು. Yes, Prema.
Lordship, so far the site he has constructed, your Lordship may kindly peruse the photographs. It was a vacant site. It is a vacant site and there is no any construction so far on the site is concerned.
Right. Photographs are produced ಅಲ್ಲ.
P17.
Illa P17. Your Lordship may kindly peruse the
Records code. Records ಎಲ್ಲಿದೆ?
only the
Even
material.
photograph as of today I can produce right now. Right now I can produce, my lord, as of today.
Only the material was dumped to deceive me so far my possession is concerned. I had put the compound wall.
3-floor construction is standing as of, if anybody could be deputed right now at my cost, my lord. And if it is false contempt can be initiated against me.
That's a 3-story building.
This 3-story building. And no, she, in the recall application, my lord, she has considered construction is going on. If need be, I will read the. She has considered while asking for recall, by filing successive application, she has stated that construction is there.
Right, when it has taken place, that is also.
Yeah, my possession is my possession. If I were not to be in possession in that, on those days, I can't be in possession now. And sanction plan is there. Those days, in 1992, so sanction plan is produced.
So far the citations referred, Lordship, nothing so regarding the facts where the rectification deed is executed and when my right is conferred.
Not required ಅಂತ.
Not required.
Nagaraj or client Nagaraj Tarani over double cautious.
Then they wouldn't have gone for rectification deed. If at all is relying on those judgments, you wouldn't have gone for rectification deed at all.
Recalling application.
My lord,
Ah.
in the judgment, my lord, last page, appendix may kindly be seen, my lord. Judgment, appendix may kindly be seen, my lord.
Yes.
Lordship got it, my lord?
Ah,
Exhibit P9, building plan. P10, sanction plan.
yes.
It is produced in the suit, my lord, not here. My lord, exhibit P17 may kindly see. So photos and negatives, 5 in number. Exhibit P17. Produced in the suit, not now. Action ಇದೆ.
Check ಮಾಡಿ.
Recall application, my lord, they have referred to even
P1.
construction.
ಎಲ್ಲಿದು serial number ಎಷ್ಟು ಪ್ರೇಮ್ನಾಥ್? Your serial number.
Serial number?
ಬರ್ಕೊಡ್ರಿ.
P9.
Though there is inordinate delay of 964 days in filing, recalling application, having regard to the fact that parties to the appeal are litigating on an immobile, over an immobile property in the interest of justice, the horse strong objections tendered by the counsel appearing for plaintiff. Cause shown is accepted. This court has also taken cognizance of the fact that cost of 5,000 is also made good on the previous date. In that view of the matter, this court deems it fit to allow the application filed in I number 5 of 24. Delay in filing recalling application is condoned. Consequently, I 4 of 24 is allowed. Appeal is restored on file. This matter was adjourned to today with an understanding that learned counsel appearing for appellant will address his arguments. Both the counsels have addressed their argument. Reserved.
Much of this.
Yes.
My lord, it was remanded only on the ground, my lord, there was no reappreciation of the evidence. That's all, my lord. If evidence has to be referred to, my lord, it's all.
ತರಿಸ್ಬಿಡಿ ರಿಜಿಸ್ಟ್ರೀಟ್ ಅಲ್ಲ ಮಾಡಿದೆ ರಿಜಿಸ್ಟ್ರಿ ಟು ಸೆಕ್ಯೂರ್ ರೆಕಾರ್ಡ್ಸ್ ಟೆಲಿಫೋನಿಕಲಿ DNP ಆದ್ಮೇಲೆ ಅದು ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ಟು ಸೆಕ್ಯೂರ್ ರೆಕಾರ್ಡ್ಸ್ ಟೆಲಿಫೋನಿಕಲಿ.
In fact, I applied for certified copies, my lord, records high court le ಇದೆ, trial court section li ಇದೆ, trial court lu ಇಲ್ಲ ಲಿಂಕ್ ಆಗಿಲ್ಲ, ಹಾಗಾಗಿ ನಾನು ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲೇ ಇದೆ. Trial court section li ಇದೆ, but it is not linked to it because your lordship has not called for it. 1 minute it will come, my lord.
ನಾಟ್ ಅದಿಲ್ಲ ಇಲ್ಲೇ ಇದೆ ಅಂತ ಚೆಕ್.
ಇಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ, ನಾನು ಚೆಕ್ ಮಾಡಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಇಟ್ ಈಸ್ ಹಿಯರ್ ಓನ್ಲಿ ಇನ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
You have done your job. Thank you. Orders.
Much.
ಯಾವ್ದು ಸೀಲ್ ನಂಬರ್ 17? ಎಲ್ಲಿದೆ? ಸಂಪತ್ ಆನಂದ್ ಶೆಟ್ಟಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರ್ಲಿಲ್ಲ. ಇಸ್ ನಾಟ್ ಇಲ್ಲ, ಬಟ್ ಅವ್ರು ಇರ್ಲಿಲ್ಲ, ಸಂಪತ್ ಇರ್ಲಿಲ್ಲ. ವರ್ಷ next time discuss ಮಾಡೋಣ. Even today, the appellants have not made arrangements to engage a counsel and to have not engaged a counsel, and there is no representation by the appellants hearing. By way of final indulgence, this matter is ordered to be relisted on so and so date. 18. Yes, Prasanna.
For respondent 1 and 2.
Filing.
This is my lord, this is suit for partition and separate possession filed by the respondent 1 and 2.
ಓ ಇದೇನು ಸೆಟಲ್ಮೆಂಟ್
ಸೆಟಲ್ಮೆಂಟ್ ಸ್ವಲ್ಪ ನಮ್ದು ಪ್ರಾಬ್ಲಮ್ಯಾಟಿಕ್ ಸೆಟಲ್ಮೆಂಟ್. ಯಾಕೆಂದ್ರೆ ಪ್ಲೈಂಟಿಫ್ ಅವರು ಸೈನ್ ಹಾಕಿದ್ದಾರೆ ಇಬ್ರು, ಅಪಿಲೆಂಟ್ ಕಡೆಯಿಂದ ಒಬ್ಬರೇ ಸೈನ್ ಹಾಕಿದ್ದಾರೆ. ಇನ್ ಬಾಕಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ಸರ್ವ್ಡ್. They are served unrepresented.
They are the LRs of
That
second
is
defendant.
only in so far as the self-acquired property of the defendant number 2. He is the appellant. In rest of the things, my lord, the suit has to be
This appeal is by whom?
appeal filed by the second
Second
defendant.
defendant.
Who claims that this property is a self-acquired property.
Some properties are self-acquired properties.
Now plaintiffs admit
That is, they are now there.
under the joint.
Yes. In rest of the things that my lord, decree has to be confirmed that.
Then no need to secure signatures of other because
Yes.
that part of decree will remain intact.
Yes,
Please.
yes. Only modified to that extent.
They are all co-defendants. They are all defendants.
Defendants, but they are not contested.
ಎಲ್ಲಿ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಅಲ್ಲಿ ಇದೆ ಪ್ರಸನ್ನ?
Pardon.
ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಅಲ್ಲಿ ಇದೆ.
Family tree,
Client ಅಲ್ಲಿ ಇದೆ. ಇದೆಯಾ?
Written statement ಅಲ್ಲಿ ಇದೆ, but may I pass on?
ಪ್ರಸನ್ನ ಒಂದು ಟೈಪ್ಡ್ ನೀಟಾಗಿ ಫ್ರೆಶ್ ಟೈಪ್ಡ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಇರಬೇಕು. ಎವ್ರಿ ಟೈಮ್ ಯು ಆರ್ಗ್ಯೂ ಯು ಶುಡ್ ಹೋಲ್ಡ್ ಅ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಇನ್ ಅ ಪಾರ್ಟಿಷನ್ ಸೂಟ್. ವಾಟ್ ಇಸ್ ದಿಸ್?
Family tree ಮಾಡಿದ್ದೇನೆ, ಅದು
ಹಾ?
written statement ಅಲ್ಲಿ ಇದೆ, family tree ಒಂದು ಮಾಡಿದ್ದೇನೆ.
ಅದೇ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಇರುತ್ತೆ ನೋಡಿ 100%. ಹ್ಯಾಂಡ್ ರಿಟನ್ ನೋಡ್ರಿ. ಏನೀಗ ವೆದರ್ ಕಾಂಪ್ರಮೈಸ್ ಕ್ಯಾನ್ ಬಿ ರೆಕಾರ್ಡೆಡ್ ವಿದೌಟ್ ಅದರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್.
Yes, yes.
That's my lord. My lord, the family tree, my lord, the Muddegowda family, my lord, that first one.
And also in the property mentioned in paragraph 42 of written statement of second defendant.
One item that was not mentioned in the plain, that is mentioned in the different written statement, that is also included for partition. That is the, in the decree in the has been ordered. My lord, here, my lord, the Muddegowda is the proprietor of the plaintiff's.
Yes.
He has 4 sons, my lord, Siddegowda, Lingegowda, Mugegowda, Chavregowda. My lord, Mugegowda's sons are the plaintiffs.
ಯಾರು ಮುಗೇಗೌಡ?
ಹೌದು. Lingana, he has went for adoption, my lord, he is not, but his LRs are impleaded as 5 to 9.
Yes.
But they have not contested the case, my lord, the finding against them. They have not filed any appeal.
ಯಾರು?
ಈ ಲಿಂಗಣ್ಣ ಅವರ ಮಕ್ಕಳು.
Adopted to ಗುಂಡೆ ಕೆಂಪಣ್ಣ.
Please. Hence, my lord, that is the finding that they have not entitled any share. That has appeal, the trial court judgment is attained finality in respect of their claim.
Now Siddegowda branch is defendant.
Chavregowda and Siddegowda.
They are the
Yes.
defendants.
ಹೌದು. ಈ ಸಿದ್ದೇಗೌಡ.
Now which branch is not contesting before this court?
Javregowda branch.
ಜವರೇಗೌಡ ಬ್ರಾಂಚ್.
ಅವ್ರು WSI contest ಮಾಡಿದ್ರಾ suit ಅಲ್ಲಿ?
Yes, they have contested.
Now the compromise is only in respect of one property which is
Only-
self-acquired.
Only,
ಸೆಲ್ಫ್ ಅಕ್ವರ್ಡ್ ಐಟಮ್.
ಯಾರ್ದು ಅವ್ರದ್ದು?
yes.
ಅದಕ್ಕೆ ಮಾತ್ರ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ.
ಅದಕ್ಕೆ-
Only to that extent because they have taken a contention in their written statement. Not the plaintiff schedule, that is they took the contention in the written statement, it is their self-acquired property. And the same has been decreed.
ಸೆಲ್ಫ್ ಗೋಲ
Self-go,
ಅವ್ರು ಆಡ್ ಮಾಡಿಬಿಟ್ಟು ಡಿಗ್ರಿ ತಗೊಂಡ್ರ.
self.
But even otherwise, for reversal of decree, or will say that this compromise will not bind the other who are not.
Definitely.
Yes.
Definitely. That's why I'm not, that's why we are saying that of the compromise that is.
Will give a closure. And they have not chosen to contest this appeal.
Yes. they are not-
Javregowda branch.
Yes.
Javaregowda has filed a
And
appeal.
Siddegowda ಅಲ್ಲಿ ಯಾರು ನೀವು second defendant ಯಾರು ನೀವು?
Javaregowda is the second defendant. He filed the appeal. This appeal has been filed by Javaregowda.
By
Second defendant only.
Javregowda.
ಹೌದು.
ಮತ್ತೆ ಆ ಬ್ರಾಂಚ್ ಇಲ್ಲ ಅಂತೀರಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ ಆ ಬ್ರಾಂಚ್ ಇರುತ್ತೆ.
ಆ branch.
ಆ ಬ್ರಾಂಚ್
ಆ branch.
ಸಿದ್ದೇಗೌಡ ಬ್ರಾಂಚ್ ನವ್ರು ಬಂದಿಲ್ಲ.
ಆ ಸಿದ್ದೇಗೌಡ ಬ್ರಾಂಚ್ ಬಂದಿಲ್ಲ.
ಸಿದ್ದೇಗೌಡ ಬ್ರಾಂಚ್ ಬಂದಿಲ್ಲ.
ಅವರು ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರ ಸೂಟು.
ಅದರಲ್ಲಿ ಸಿದ್ದೇಗೌಡ has not contested. After his death, his LR filed
sir.
They have contested.
they have filed the return statement, contended that there is no partition.
Correct.
In
They are entitled for share.
ತಂದೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ they have not challenged the judgment against which has been passed against them.
Let us see the operative portion.
Please, madam. Paper book page number.
Initially, there was no claim insofar as property held by second defendant. There was no claim.
ಇಲ್ಲ I taken that contention madam.
ಆಗಲ್ರಿ.
They took the
Claim
content.
ನಲ್ಲಿ ಶೇರ್ ಕೇಳಿರ್ಲಿಲ್ಲ ಮೊದಲು.
Plaintiff has not claimed that.
Not claim.
ಆ property ಮೇಲೆ claim ಮಾಡಿರ್ಲಿಲ್ಲ.
Why did second defendant include that property and claim to be self-acquired? What suit is partly decreed?
Partly decreed. The plaintiff.
Oh, now plaintiffs are entitled. Only plaintiff share is quantified.
Please,
And also in the property mentioned in paragraph 42C.
see. The
ಈ ಸಿದ್ದೇಗೌಡ ಬ್ರಾಂಚ್ ಇದವರು ಇದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅನ್ಸೆಷನ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಏನಾದ್ರು ಕ್ಲೇಮ್ ಇತ್ತು ಅವ್ರದ್ದು WS ಅಲ್ಲಿ.
ಅಲ್ಲಿ ಸಿದ್ದೇಗೌಡ
They claim that they are entitled
partition
for.
ಆಗ್ಲಿಲ್ಲ. Second defendant has taken.
No. They sought share in plain scheduled properties.
Please.
But whether a claim was made in,
No.
there was no claim.
No claim.
All right. ಬರ್ಕೊಡ್ರಿ. Where are the parties?
Parties.
ಎಲ್ರು ಇದಾರ? ನಾತೇಗೌಡ ಯಾರು? ಪ್ರೇಮ ಎಲ್ಲಿ? ಉಮೇಶ್, ಸಾಕಮ್ಮ.
ಅಪಿಲೆಂಟ್ ಕಡೆಯಿಂದ ಒಬ್ಬನೇ ದೇವರಾಜ್ filed.
ಯಾರು? ದೇವರಾಜ್ ಯಾರು?
Appellant
LRs
number
of
6,
that.
LR of Javregowda. Plaintiff 1 and 2 are present. Umesh and
1 and 2 ಮಾತ್ರ ಇದಾರಾ?
ಹೌದು.
ನಾತೇಗೌಡ ಮತ್ತು ಉಮೇಶ್ ಇದಾರಾ?
Umesh ಇದ್ದಾರೆ.
They are the plaintiff.
ಪ್ರೇಮ ಅಂಡ್ ಸಾಕಮ್ಮ ಆರ್ ನಾಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಇಲ್ಲ.
ಅವ್ರ ಪರವಾಗಿ ಏನ್ GP ಇದೆ? ಏನಿದೆ ಪ್ರಸನ್ನ?
Payment ಸಾಕಮ್ಮ ಇಲ್ಲಿ ಬರಲ್ಲ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಬರೋದಿಲ್ಲ. They are not the party.
No, you said, oh, who are the plaintiffs then?
Plaintiff are, that is respondent 1 and 2.
ಹಾಗೆ
ನಾತೇಗೌಡ and
ಉಮೇಶ್ ಇಬ್ರೇ ಹಾಕಿ.
ಇಬ್ರೇ.
The others didn't join. Daughters didn't join, huh?
ಇಲ್ಲ.
They're not party to the suit, huh?
Then they are not party to
They
this.
are not party to the suit. That is also one contention taken that for.
ಒಪ್ಕೊಂತೀರಾ ನೀವು? ಅದು ಅವ್ರ ಸ್ವಂತ ಆಸ್ತಿನಾ? ಅದ್ರಲ್ಲಿ ನಿಮಗೆ ನಿಸ್ಸ ಬೇಡ. ಒಪ್ಪಿಗೆ ಇದೆಯಾ ನಿಮಗೆ? And the legal heirs of Siddegowda, they are arrayed as different number?
ಸಿದ್ದೇಗೌಡ.
Siddegowda different number 1, na?
Siddegowda defendant number 1.
1A2, 1H.
Please.
ಅವರು ಏನು ಒಪ್ಕೋತಾರ? ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅವ್ರದ್ದೇನಿಲ್ಲ because
ಇಲ್ವಾ?
They are not.
ಬರ್ಕೊಡ್ರಿ. This captioned first appeal is by the legal heirs of second defendant assailing the judgment and decree of the trial court only insofar as written statement scheduled property.
Schedule referred in the written statement of D2.
Schedule referred in the written statement
Of D2. Of defendant 2.
of defendant number two. The second defendant contends that the property indicated in the schedule to the written statement is a self-acquired property. It is also gathered from the material on record that plaintiff at first instance never claimed any share in this property. It was only when second defendant included the property bearing number.
Item number.
ಅದೇನದು ರೆಫರ್ ಮಾಡಿದ್ರಲ್ಲ ಪ್ರಾಪರ್ಟಿ?
ಮಾಡಿದ್ದೀನಿ. ಪ್ಯಾರಾದಲ್ಲಿ ಹಾಕಿದ್ದೆ. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 94/15A, 94/16A, 94
ಓ ಎಷ್ಟಿದೆ ಬಾಳಿದೆ ಅಲ್ಲ
ಒಟ್ಟು 4 ಐಟಮ್ ಇದೆ.
4 item, 4 item.
ಟೋಟಲ್ 44 ಐಟಮ್ಸ್ ಇದೆ.
included 4 items in his return statement. Trial court has not only decreed and granted share to plaintiff in plain scheduled properties, but share is also granted in the properties indicated in schedule to the return statement, which second defendant claimed that they are his self-account properties. Next, today, a joint compromise petition is filed by plaintiffs and legal heirs of second defendant. The legal heirs of defendant number 1 are served and have not chosen to contest this appeal. In the light of compromise, plaintiffs acknowledge that the schedule annexed to the return properties covered under the schedule annexed to the return statement are self-account properties of second defendant. Therefore, by way of joint compromise petition, it is jointly prayed that the prelim decree drawn by the trial court shall be modified in terms of the joint memo filed by the plaintiffs and legal heirs of second defendant. ಇದು ಪ್ರಾಪರ್ ಹಾಕ್ಬೇಕು ಪ್ರಸನ್ನ, ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ ಇದು. ಆರ್ಡರ್ 23 ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿ ಎಲ್ಲ ಹಾಕ್ಬೇಕಲ್ಲ, ಯಾಕೆ ಪ್ರಸನ್ನ?
ನಾವು
ವಾಟ್ ಯು ವೇರ್ ಆನ್ ದ ರನ್ ವಾಟ್ ಯು ಹ್ಯಾಡ್ ನೋ ಟೈಮ್ ಟು ಪ್ರಿಪೇರ್ ಡ್ರಾಫ್ಟ್ ದಿಸ್. ವಾಟ್ ಇಸ್ ದಿಸ್? ವರ್ಕ್ ಔಟ್ ಇಟ್. Though having noticed that the dispute that this litigation is being fought since 1995, and the plaintiffs have voluntarily come forward to give a quietus to the dispute, acknowledging that the properties covered in the schedule to return statement are self-account properties of second defendant. This court is of the view that plaintiffs can be permitted to enter into compromise with legal heirs of second defendant in absence of legal heirs of first defendant. Be that as it may be, the compromise arrived at between plaintiffs and legal heirs of second defendant will not bind on the legal heirs of defendant, first defendant who have not chosen to contest the captioned appeal. This court has queried with plaintiffs 1 and 2 who are present before this court. On inquiry, they have made a statement that the contents of this joint memo is read over to them and explained by their counsel on record. Having understood the contents of the joint memo and its consequence, have signed the joint memo. They have also submitted that they have voluntarily, in view of amicable settlement, they have given up their claim insofar as the properties covered are under the schedule to the return statement filed by second defendant. This court is of the view that the joint compromise arrived at between plaintiff and legal heirs of second defendant is lawful. Yes, anything wrong?
ಅದರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಬೇರೆದೆಲ್ಲ ಹೇಳಿದೀವಿ ನಾವು, ಅದಕ್ಕಾಗಿ ಐಟಮ್ ನಂಬರ್ 40 to 44 ಅಂತ 3
ಮಾತ್ರ ಇಷ್ಟು 4 ಮಾತ್ರ.
ವಾಟ್ ಅದು ಆಮೇಲೆ ಡಿಕ್ರೀದಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು
ಬೇರೆ ಇದು
ಅದೇ
schedule ಅಂದ್ಬಿಟ್ಟು ಟು ದಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂದು
ಅದನ್ನ ಅವ್ರು ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ನಾವು ಪ್ಲೈಂಟ್ ಅನ್ನು ರೆಫರ್ ಮಾಡಿ ಶೆಡ್ಯೂಲ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ.
ಐಟಮ್ ನಂಬರ್ 42,
40, 41, 42, 43 4 ಐಟಮ್ಸ್.
4 items. ಐಟಮ್ ನಂಬರ್
ಹೌದು 42, 43 40ರಿಂದ 43 ವರೆಗೆ.
40ರಿಂದ 43 ವರೆಗೆ. ಏನ್ ಬಂದ್ರಿ? lawful. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಅದು ಐಟಮ್ ನಂಬರ್ 40 to 43 ಅಂತ ಬಂದು. In view of amicable settlement between plaintiffs and legal heirs of defendant number 2, the preliminary decree drawn stands modified only insofar as item number 40 to 43 of the schedule ಏನನ್ಬೇಕು? Plain schedule properties are concerned. Excluding these four items, the prelim decree drawn by the trial court stands affirmed by this court. Next, registry is directed to draw. Prelim decree na ಮತ್ತೆ FTP ಹಾಕೊಂತೀರಾ ಏನು?
FTP ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದಾರಾ? To draw a fresh prelim decree in terms of joint memo filed by appellants and respondents one and. Signature ಮಾಡಿಸ್ಬಿಡಿ, please. We'll dispose of it terms.
Presentation.
The suit between the neighbors. And what the voluminous.
Inquiry, sir.
I am this is the defendant's appeal.
You are the defendant.
Yes, I am the defendant's appeal.
Suit is for what?
Suit is not basic. Initially, the suit is filed for injunction. And thereafter, they have converted into the suit for declaration and possession in respect of a portion of the property without amending the pleading at all. Absolutely, there is no pleading, but amended. But learned judge, my lord, he has considered several documents, 70 documents are produced both the sides. But no, none of them have elicited how they have in occupation of each of the side. Even the defendant also same, plaintiff is also same. And the learned judge, after going through the records and documents, he has come to the definite conclusion, both plaintiff and defendants have not proved their title and the possession. But however, I have to see both. Who is better? Therefore, I am granting the decree.
Not decree for what? Only injunction
Decree
or?
for decree for declaration of title and possession. Initially, suit is filed for injunction. Please see, Murad, the prayer sought is also very good plaint. And the without pleading, Murad, there is no pleading at all. How the schedules have come, nothing is there. Not even in evidence. But suit has been declared. Initially, the opponent. Initially, Murad, this original plaint is for the only 3 pages, 4-page plaint. But only the dispute what he has raised in para number 3 of the plaint. That Lordship got it, man. Trial court plan, the original plaint.
Para 3 of the plaint.
Para 3 of the plaint. What he says is, Murad, he is according to them, they purchased the property in 1967.
They're all unnumbered paras.
Huh?
Paragraphs.
Unnumbered.
Number
in Hakil.
You are referring to
they
paper book,
purchased
sir?
the property measuring.
Are you referring to paper book or?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ನಲ್ಲಿ ಹಳೆ ಪ್ಲೇಂಟ್ ಹಾಕ್ಲಿಲ್ಲ ಮುಂಚೆದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ನೋಡ್ಬೋದು
ಇದೆಯಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್?
ಒರಿಜಿನಲ್. But there, shall I explain, Lord, by that time. But the plaintiff claims that he has purchased the property in the year 1967 under sale deed, the registered sale deed. Measurement is 48 into 97 feet, and the defendant is the neighbor on the eastern side, and defendant tried to interfere with his possession. And he has also given a date on 15/11/2001 at about 3:30 defendant came near the scheduled property. These are also very relevant. In page 3, in unnumbered para 2. He has based his title for injunction initially. Page 3, para 2.
Later it's amended.
Huh?
Later it was amended.
Later amended. How you have amended also, I will show to your love. The amendment is of no consequence. Please see this. Para 2 nalli, on 5/11/2001 at about 3 p.m. the defendant came near the scheduled property and tried to dig the basement pit and pit tobacco, encroaching about 6 feet vacant space of the plaintiff scheduled property. However, at the assistance of the neighbors and the plaintiff has managed to prevent their illegal encroachment. At that time, defendants have openly expressed that they will come again to put the construction across. Then that the defendants are influenced persons and locality, they may come and all these things. The police complaint, he went to police station. They said it is a civil dispute. You go to civil court. This is what his prayer. I mean his pleading, and the prayer is injunction. He says the permanent, you please see this, wherefore the prayer court may be pleased to pass judgment and decree restraining the defendant, chairman, agents, henchmen, person claiming under them, etc., permanently from putting up any construction by encroaching the scheduled property which is absolutely belongs to the plaintiff and award cost and such other reliefs. Not in this plaint, he says he is in possession of the property. Then the schedule may kindly be seen. Unamended schedule, he has given the schedule.
All right, his suit is based on what title? Title document?
Injunction is based on the title only. He filed the suit based on the title, saying that I purchased the property 48 into 97 feet is his contention.
And what about you?
Pardon?
On what ground you are contesting? this
Madam,
suit?
I have purchased, but we are also the owners. We purchased the property. Our contention is we purchased 50 feet on the southern side, 36 feet on the northern side.
Sketch idea.
Sketch there, but what happened was in this, parties have got confused. Both the parties. Documents, several title deeds they have produced. None of them have compared any of the title deeds. I will show to your lordship. Learned judge has got much more confusion. He has not understood, with great respect, he has not practically understood the case of the parties. What he has said is, learned judge, he has referred all the 6 title deeds of the plaintiff. And he has also referred, but we are tracing the title from the year 1929. He is tracing the title from the year 1950.
Through common vendor.
No, different vendors. And adjacent.
Those vendors were adjoining owners or joint owners?
Adjoining owners.
They were adjoining owners.
Adjoining owners.
So
So
two
therefore, there
properties
is a
are
boundary
different
list.
properties.
Pardon me.
Both the properties are different.
Both the properties are different. It is a boundary dispute practically.
Boundary dispute.
Boundary dispute practically. Both of them say that the defendant says on the western side is my property. That is 8 feet, not is a small extent also. Because property is in Bangalore, very prime locality. 8 feet into 97 feet. According to us, on the western side, we are in possession. According to the plaintiff, he was in possession. Now he has filed a suit for possession also. So fact remains that we are in possession. When he has filed a suit for possession, converted into a possession, but not even a single sentence in the entire plaint. When he was dispossessed, how he has described Schedule B property, nothing but the amendment was carried out in the year 2004. Suit filed in 2001. At the time of evidence, and it was pointed out, he filed an amendment application. Amendment also, last may kindly see the amended prayer also. Amended, what they have done is, he has retained a Schedule A itself. 48 into 97 Schedule A as it is. He has made one Schedule B claiming that 8 into 97. Whether it is part of Schedule A or it is the adjacent to the Schedule A, nothing is mentioned. And but no pleading. And this is how it is. Then prayer is also, please see, prayer is declare that the plaintiff is the owner of B schedule property. Muncha injunction for A schedule. Now he claims for declaration for B schedule and put the plaintiff in possession of B schedule property.
All right, you come with the synopsis, title documents, flow of title.
But I have prepared it, but if you go through the pleading, but what learned judge has said is, please see the judgment of learned judge. My respectful submission, and I don't want to waste your lordship's time, because if you go through the entire pleading and pleading, evidence and documents, nobody can make out which property, who is claiming. Now, 8 feet into 97 feet, if they are agreeable.
We'll go through the records and then take a call. You show me the sketch.
Yes.
Where is the sketch?
Sketch,
Who has placed on
sketch,
record?
Maladu, you last may kindly see, when an interim application was filed, that was rejected by the trial court, interim injunction application, against which they filed an MFA, an appointment of commission was appointed. He has produced the sketch, we inspected the spot and produced the sketch.
Now, what is the decree for?
Pardon me?
His title is declared and Schedule B property,
Yes.
you are directed to
Yes,
hand over.
hand over the possession.
All right. Now, there's a finding that you have encroached.
Pardon?
There's a finding against you that you have encroached Schedule B property.
Yes.
That finding is based on what?
That finding is based, Malad, only he says assumption and presumption. What he says is,
Extent of encroachment, how it is.
nothing has been said about it. Very, very strange, Judge. You will actually kindly come to the order of the learned judge. He says both of them have not, page 29 of the paper book, para 26 onwards, if your lordship says, nobody can understand how learned judge has come to this conclusion. So there are only two alternatives for this. My respectful, when the learned judge has come to the conclusion, both plaintiff and defendants are not in a position to establish which property, where they are in occupation. And the only available option to the learned judge was to dismiss the suit. Or else, that 8 feet, suppose if he wanted to exercise some discretion while decreeing the suit, 8 feet into 97 feet, it is very difficult to identify. He is entitled for 50% of that. That is the only two alternatives available for the learned judge. Either dismiss or 50-50, because it is unidentified, because they both of them are claiming title to the properties. But one more aspect is, original title dates, there is no measurement even in this case. Only the measurement started only from the year 1950 onwards. But as far as the defendant is concerned, from 1936, boundary is mentioned, measurement is also mentioned. And he says, I have left, according to him, 1971-73, he has put up the construction, leaving setback on the eastern side, 8 feet into 97 feet, so as to put up the compound wall. Even till today, the compound wall has not been put up. That is what the learned judge has observed. If really he has put up the this construction, wanted to put up compound, nothing prevented him from putting up the compound. But however, it has not been put up. That's what he says.
Sketch there.
Sketch the exhibit. Last may kindly take the commissioner's sketch. That is exhibit C.
Oh, commissioner sketch.
P1. Huh?
Commissioner sketch.
No, commissioner sketch.
There is the matter.
Huh?
All right, we'll examine. Where is the commissioner sketch?
Huh? C2, Malad. Exhibit C2. But the court below says, I will not believe the plaintiff's case. I will also not believe the defendant's case. C2 ಇದೆ, exhibit C2. ಪೇಪರ್ ಬುಕ್ ನಲ್ಲಿ ಸೆಕೆಂಡ್ ಬುಕ್ ಹಾಕ್ಬೇಕು ಅದು ಹಾಕಲಿಲ್ಲ. ಪೇಪರ್ ಬುಕ್ ಕ್ರಮ ಥಿಂಕ್ ದಟ್ಸ್ ವಾಟ್ ಐ ಟೋಲ್ಡ್ ಮೈ ಫ್ರೆಂಡ್. ಡಾಕ್ಯುಮೆಂಟು ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಹಾಕಿ ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಪ್ಲೀಡಿಂಗು ಸೆಕೆಂಡ್ ವಾಲ್ಯೂಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಬೇಕು, ನೆಸೆಸರಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅದೇ
We'll go through existing records and we'll decide it, Krishnamurthy sir.
ಅದೇ ಕರೆಕ್ಟ್, ಅದು ಕರೆಕ್ಟ್.
God, 2005.
ಅಲ್ಲ ಹೇಳಿದ್ರೆ ನಿಷ್ಠೂರ
We
ಆಗುತ್ತೆ.
are in 2025. What is this? All these litigations are kept pending for almost 25 years. Some admissions matters of 2011 are being listed for admission. What is this? ಯಾಕೆ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ವಾ ನಿಮ್ಗೆ ಒಂದ್ ಕಾಲದಲ್ಲಿ?
ಫಸ್ಟ್ ಅಪೀಲ್ ಎಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಮುಂಚೆ ಎಲ್ಲ ಹಾಕ್ತಾ ಇದ್ರು, ಕೆಲವು ಸಲ ಹಾಕ್ಲೇ ಇಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂದ್ರು ಬಿಟ್ಟು.
ಅಷ್ಟೇ, ಅದಕ್ಕೆ ಡೋಂಟ್ ನೀಡ್ ಅ ಲಾಯರ್ ಆಲ್ಸೋ. You have to hear a lawyer if he is pressing for interim stay of the judgment.
ಕರೆಕ್ಟ್. ಫಸ್ಟ್ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಟೋಮೆಟಿಕ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದೆ, ಅನ್ಲೆಸ್ ಇಟ್ ಇಸ್ ಮೋಸ್ಟ್ ಫ್ರಿವಲಸ್. ಎಕ್ಸಿಬಿಟ್ C2 ಎಲ್ಲ ಸ್ಕೆಚ್ ಇದೆ. Got it, Murad?
All right, tomorrow you argue on, have you cross-examined this commissioner, whether objections are tendered?
Objection ಹಾಕಿದ್ದಾರೆ, objection ಹಾಕಿದ್ದಾರೆ before this honorable court. This was marked before the trial court. This report was produced before this honorable court in an MFA proceedings.
Oh, no, this commission was at the instance of trial court order?
No, by at the instance of this honorable court.
In an appeal?
In an MFA.
CPC order 43 appeal?
Yes, Murad. Interim application, rejected by the trial court. Against that MFA was filed.
So based on sketch injunction was granted?
But no injunction was not granted.
Not granted?
Not granted.
Because you were found to be in possession?
Yes.
Now, which is the disputed portion which you are?
Last may kindly say this A2, A3, between A2, A3 up to end, C2 ಮೇಲ್ವರೆಗೆ ಇದೆಯಲ್ಲ ಅಲ್ಲಿವರೆಗೆ.
C2 ವರೆಗೆ.
But here, Lordship can see the below, he has given index. A1, A2, 41 feet.
Now, what evidence you have led in by way of rebuttal evidence to counter this commissioner's report? This is on spot in inspection.
No, what this commissioner says is, this A2 to A3, this between gap, I cannot say anything about it because both of them are claiming the ownership, it is a vacant place. ಇಬ್ರು ಎಕ್ಸ್ಟೆಂಟಿಗೂ 8 ಇದು ಕಡಿಮೆ ಇದೆ.
Now, this is the Schedule B property.
ಹೌದು.
This is referred as Schedule B.
Yes, 8 into 97.
8 into 97.
97.
ವಿಡ್ತಲ್ ಜಾಸ್ತಿ ಇಲ್ಲ.
ವಿಡ್ತಲ್ 8 ಫೀಟ್. ಅದು ಮುಂದೆ ಹೋದಂಗೆ ಕಡಿಮೆ ಆಗ್ತಾ ಹೋಗುತ್ತೆ, ತಾವು ನೋಡ್ಬೋದು.
Yes, correct.
ಅದಕ್ಕೆ ಐ ಥಿಂಕ್ ಯಾರು ಇರ್ತಾರೆ
ಯಾರು who is appearing?
ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್. ನಾನು ಹೇಳಿದ್ದೇನೆಂದ್ರೆ, ಐ ಡೋಂಟ್ ನೋ whether my friend is accepting or not. ಈ dispute ಎಷ್ಟು ವರ್ಷ, last me kindly see when this foot was paid. Instead of that, share it 4 feet, 8 feet ಇದೆ. ಇಬ್ರು ಪದ ಇದರಲ್ಲಿಲ್ಲ ಮಾಡ್ಕೊಂಡು ಹೇಳ ನೋಡಿದೆ, ಅವ್ರು ಏನೋ ನಂಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅವರು. That is the only one option.
Now,
Or else,
whether there are measurements in your title document?
yes, Murad, what happened is there are first document is in our document a larger extent is there. Their document 40 feet into 80 feet anತಾರೆ. All of a sudden it has become 97 feet. And in the initial document there is no measurement at all, only boundaries.
All right, now these boundaries are marked by the commissioner based on what?
Based on the sale deeds produced by
Sale
the
deeds,
parties
then-
in the spot, at the
then-
spot. Yes. So therefore, Murad,
All right, we'll take
if
it
this
as
is
part of-
accepted, this is accepted, suit has to be.
Let us see if there is a
Yes.
possibility of settlement, otherwise you'll argue on that.
Yes.
Now, this court is blessed with commissioner's report and that
Correct.
is dealt by the trial court.
But even,
Let us see what's the cross-examination.
and
But
apart from
did
that,
you summon the commissioner and you, have you cross-examined the commissioner, court commissioner?
commission cross-examination ಮಾಡಲಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದೆ. ಇಲ್ಲ ಮಾಡಲಿಲ್ಲ.
ಮಾಡ್ಲಿಲ್ವಾ? ಅವ್ರ ಥ್ರೂನೇ ಮಾರ್ಕ್ ಆಗಿರ್ಬೇಕಲ್ಲ ಇದು.
C1
The
C2
commissioner sketch and report is marked through commissioner, whether he is examined.
ಮಾರ್ಕ್ ಇದು ಮಾಡಿದ್ದಾರೆ, ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಇದೆಯಾ ಮತ್ತೆ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಪೇಪರ್.
He is examined, sir. He is examined.
ಅದ್ರಲ್ಲಿ ಇದೆ, ಬಟ್ ಇಲ್ಲಿ ಇಲ್ಲ. ನಂಗೆ
ಇದೆ ಮಂಜುನಾಥ್.
ಮಂಜುನಾಥ್
He is examined on 8/6/2005.
ಅದ್ರಾಗಿದೆ.
ಅದು ಅವ್ರ ಎವಿಡೆನ್ಸ್
ಇಲ್ಲ.
ಪಾಠ ನಾಳೆನೆ ಸರ್, ಟುಮಾರೋನೆ.
ಆಯ್ತು.
tomorrow. You inform your friend.
I shall definitely inform my sure. So,
ನಿಮ್ ಕನ್ವೀನಿಯನ್ಸ್ ಪ್ರಕಾರ ನೀವು ಬಂದ್ಮೇಲೆ ತಗೋತೀವಿ.
ಆಯ್ತು.
Finish off all your engagements and come to back home. ಬದ್ದಲ್ಲ.
ಆಯ್ತು. ಅಲ್ಲಿ.
ಇಬ್ರು
ಅವ್ರು
ಇದ್ದಾಗ ತಗೋತೀವಿ.
ಅಲ್ಲ ಬರ್ತಾರ ಅವ್ರು. ಬಸವರಾಜ್,
Yes.
ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್.
Let us see whether it can be settled or what. ಎಲ್ಲಿ ಯಾವ ಊರಲ್ಲಿ ಇದು?
ಇಲ್ಲ ಬೆಂಗಳೂರು.
ಆಗಲ್ಲ.
ಅಲ್ಲ ಅದು ಕ್ವಶನ್ ಇಸ್ ದಿಸ್.
ಆಗಲ್ಲ ಬಿಡ್ರಿ.
ಅಲ್ಲ ಅದೇ
ಬೆಂಗಳೂರಲ್ಲಿ ಆಗಲ್ಲ. We'll decide it.
ಬೆಂಗಳೂರು ತತ್ಕೊಂಡ್ರೆ ಎರಡು ಕಷ್ಟ.
ಆಯ್ತು ಆದ್ರೆ ಒಳ್ಳೇದು.
ಆಗ್ಬೋದೇನೋ ಅನಿಸ್ತದೆ ನಂಗೆ, ಯಾಕಂದ್ರೆ ಜಡ್ಜ್ ಅದನ್ನೇ ಬರ್ದಿದ್ದಾರೆ. ಇಬ್ರು ಇಲ್ಲ ಇಬ್ರು ಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ.
Yes. Partner, please. Orders correct. ನೀವು CLI ಬರ್ತಾ ಇದೀರಾ?
My lord, that is disabled matter, my lord, it has come last week. Somebody has taken undertaken to file wakalat last date of hearing.
We'll see the next date. We'll see whether they will file wakalat.
They said that they will file wakalat, they have undertaken to file wakalat.
All right, now he's not before the court, what to do? List it, relist it on so and so date. To enable the respondents to engage a counsel. Yes, next. 47.
ಎರಡು ಒಂದೇ.
Same. Next. 48.
In this matter today, I've taken fresh steps, my lord.
Fresh steps.
Please, my.
Counsel for appellant submit that fresh steps are taken, office to verify and issue notice. How you do? Yes, sir.
Yes. There is a giant memo I have filed earlier. I have filed revised giant memo. In the meantime, I am filing a memo to withdraw the earlier giant memo filed and continue the. File the copy on the other side.
You want to withdraw and now you want to argue in merits?
No. I want to
Modified,
withdraw
huh?
earlier memo. There is some
Document-
modification in the fresh giant.
Document produced along with earlier memo may be taken in this memo.
Revised giant memo I have filed.
ಅದು withdraw ಮಾಡಬೇಕಾ?
ಅದರಲ್ಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. That document may be continued ಅಷ್ಟೇ. Earlier giant memo ನಲ್ಲಿ. There is a.
What was the error in the earlier joint memo?
Measurement is not
Measurement,
mentioned.
only to the
ಅದು
extent.
earlier joint memo ಅಲ್ಲಿ ಇದೆ?
That is filed on 2/8, my lord. Earlier giant memo ಅಲ್ಲಿ ಒಂದು sketch ಮತ್ತೆ ಒಂದು ಇದು ಹಾಕಿದ್ದೀನಿ.
This is formation of road in the scheduled property.
The suit for injunction, suit is decreed. Against that, I have filed an appeal.
A memo is filed today by duly signed by both the councils.
Yes,
please.
yes.
Seeking leave of the court to withdraw the earlier joint memo.
Please,
Yes.
please.
On the premises, there are few errors in the earlier joint memo. Prayer is allowed. The earlier joint memo dated 29/8/2024 is dismissed.
Yes.
Yes.
Is dismissed. Is rejected. Is rejected as not pressed.
Yes.
However, the documents annexed with
Annexed.
the earlier joint memo are considered in the light of joint memo filed today. ಇವತ್ತ ಇದು
ಹೌದು, ಇವತ್ತು.
ಏನೀಗ in terms of joint memo, who is the appellant?
I am the appellant, my lord.
ಅಲ್ಲ plaintiff or defendant?
Defendant.
The joint memo filed by defendant corporation and respondent plaintiff.
Yes.
Is taken on record in terms of joint memo. What has happened?
Suit is liable to be.
The corporation has undertakes to withdraw the appeal.
Yes, yes.
Withdraw the appeal.
Without appeal, in the meantime, suit also does not.
In the joint memo, it is also indicated that plaintiff respondent has submitted a representation indicating that he has no objection for formation of road by BBMP measuring east-west 108 feet in length and not to south 25 feet feet in width, including the drainage out of the extent
Yes,
of
please.
20,442.18 square feet. In the light of joint memo, modify ಆಗಬೇಕಾ ಏನೇನಿಲ್ಲ?
ಏನಿಲ್ಲ, suit is liable to be
Dismissed
dismissed
as
as infructuous.
Order.
Yes.
The appeal is dismissed as withdrawn.
Please.
Await TCR.
Parties are present, my lord, in this case.
ಬರ್ಕೊಡ್ರಿ.
Permit me to sign the.
ಆಯ್ತು, you are the authority ಅಲ್ಲ.
Yes.
You are withdrawing it. ಬರ್ಕೊಡ್ರಿ, parties are present ಅಂತ.
Engineers are also present before
The concerned officer of the corporation and respondent plaintiff are present.
Yes. And plaintiff is
They have
also
signed the
present.
joint pen.
Yes, yes.
ಅವರು sign ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ.
Next,
Yes.
await TCR, non-filing of acknowledgement for having served the copy. Yes, who appears for appellant? None appears for appellant. List it on so and so date. 51 Loknath.
I filed the amended cost title.
Huh?
I filed it.
Amended cost title. Counsel for appellant submits amended cost title is furnished. Office to verify.
Yes.
Taken steps, Your Lordship, with respect to deceased R6.
You have taken steps.
They have filed an applications on 27th of August, my lord.
What up, idea? Issue notice
Please.
on all the interlocutory applications. Yes. Three, this is the appellant. None appears for appellant. List it, ನಾಲ್ಕು ವಾರದಲ್ಲಿ ಕೊಡ್ರಿ. ಹಾ? ಅಲ್ಲ, ಸೆಟ್ಟಿಂಗ್ ಹೆಸರು ಅಂತ ಏನೇನೋ ಇದೆಯಲ್ಲ. ಅದ ಅಲ್ಲ ಮಾಡಿಬಿಡೋಣ, ಬರ್ಕೊಡ್ರಿ. Caution is accepted. The application filed in I number 5 of 23 setting aside of abatement is allowed, and accordingly abatement is set aside. The proposed laws of disease appellant are permitted to come on record. ಅದಕ್ಕೂ ಮೇಲೆ ಬರೀರಿ ಆಗಿದೆ. The delay in filing LR application is condoned. And accordingly, I 4 of 23 is allowed. Proposed laws are permitted to come on record. Counsel for appellant to forthwith amend the cost title and file amended cost title within 2 weeks. Next. 54.
54 ಅಲ್ಲಿ
Respondent number
file
six.
amended appeal memo. Respondent number 6 was impleted subsequently. I'll have to file amended.
Amended.
Respondent
file.
number 6, my lord.
Yes, appeal is admitted.
Filed
Vacating, vacating IA.
How, when appeal is pending, how you can seek vacation of interim order? Specific performance, defendant's appeal. You can't enforce the decree pending appeal. You can't enforce the decree, madam. Huh? ಯಾವ
My
ವರ್ಷದ
name is not
2010.
showing,
Are you ready with the main matter?
so ನಮ್ಮ ಹೆಸರು ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಬಿ ರಮೇಶ್. Along with me ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. Respondent number 6 ಗೆ.
ಎಲ್ಲಿದೆ R6 ಗೆ?
Along with me
So, ವಕಾಲತ್ ಬೇಸೆ.
10/7/24 ಅಲ್ಲಿ ವಕಾಲತ್ ಹಾಕಿದ್ವಿ.
ಬರಿಬೇಕಾ? ಆಯ್ತು, ಅದು ತೋರಿಸ್ಬಿಡಿ. ವಕಾಲತ್ತಲ್ಲಿ ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ.
ಈಗ ಯಾರ ಜೊತೆಗೆ ತೋರಿಸ್ಬೇಕು ನಿಮ್ದು?
ಬಿ ರಮೇಶ್.
R6 ಬಿ ರಮೇಶ್ ಅಂತ ತೋರಿಸ್ಬಿಡಿ ಆರ್ಡರ್.
2006 10 matter my lord. Any date may be fixed.
Audit 26. Notice ಹೋಗ್ಬೇಕಾ?
Your Honor, already I've taken paper publication, Your Honor, in the last date
ಅಲ್ಲ ಪೇಪರ್
to bring alerts of respondent number 2. For respondent number 2B and 2C was served. With regard to respondent number 2A, paper publication was taken, Your Honor.
service is held sufficient on the previous note. There is no contest to application filed in I number 2 of 22, 1 of 22, wherein appellant seeks leave of the court to bring LRs of disease R2. Caution is accepted. I 1 of 22 is allowed. Appellant is permitted to bring the proposed LRs of disease R2 on record. Appellant to forthwith carry out amendment physically. 2 weeks time to file amended cost letter.
Much obliged, sir.
Previous matter, IA may be considered along with main.
Huh?
IA for vacating ಹಾಕಿದ್ರು previous matter can be considered along with final.
Lord, appear for the appellant, please. Lord, I'm filing my rejoinder statement.
Respondent
A
number
compilation
46.
of the documents that are already marked, so that my lord, I'll be able to assist
Nothing.
my lord on that.
So I don't dispute that this documents
Not
were
marked
marked.
documents.
None of the documents were served, not even the application was served on me, except for the hand
Hand
summons.
summons was
Except
taken,
for the hand summons.
impleading application had been allowed, they did not appear, date was fixed. ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ,
ಅಲ್ಲಲ್ಲ,
ಕೊಡ್ತೀನಿ, ನನ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Pleading
ನನಗೆ
application
ಹೇಳಿದ್ರೆ
ಹೇಗಲ್ಲ ಆಯ್ತು ಏನಂತ my friend has to come clear on that.
You are both from the same planet.
Please.
Same planet, Yeah, and you know Nitesh? ಈಗಲೇ ಕೇಳ್ಬೋದಾಗಿತ್ತು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಕೊಡಿದ್ರೆ
ನಾನೇ ಕೊಡ್ತೇನೆ. Without
ಇಲ್ಲ ಕೇಳಿ last time I had to sought for the copies also.
Why you want to root it out through a judge?
ಇಲ್ಲ.
You maintain the decency. You can ask him.
So I had even requested the copy on the last two occasions.
Don't be too harsh on your opponent.
Not on the Nitesh.
Nitesh, ಎರಡು ಸೆಟ್ ಕೊಡಿ.
Right now.
ಇದನ್ನು ರಿಜಾಯಿಂಡರ್ ಕೂಡ ಈಗ 5 ನಿಮಿಷ ಮುಂಚೆ.
ಇಲ್ಲ, ಏನ್ ನಾನು ಅವಾಗಿಂದ ಬಂದಿದ್ದೆ, ಸರ್ ಕಾಣಿಸ್ತಿರ್ಲಿಲ್ಲ, ಈಗ ಕೊಟ್ಟಿಲ್ಲ. That is a bona fide.
Counsel for appellant has filed a rejoinder. Why do you want to pile up further? Why are adding up of
Because
papers?
my lord, the compilation of the important documents. That's it.
Not serious. Counsel for appellant has filed rejoinder. Rejoinder to what?
My statement.
Objection which has been filed by my lord.
Statement of objection. ಏನದು statement I1 of 24 ಇದು temporary injunction.
Temporary injunction not to put up construction is what I have sought.
Is
Pendant the late purchaser of the property.
latest purchaser.
He is the latest purchaser.
And you have allowed other transferees to put up construction. You are only troubling.
No. What has happened?
Their
is,
constructions
my lord,
are
there is an
subject to-
interim order that was passed, my lord.
What's the stage of the construction now, Nitesh?
He has produced the photo.
Has he gone vertical?
ಏನ್ ಅಂತದ್ದೇನ್ ಆಗಿಲ್ಲ, ಅವ್ರು ಒಂದು
ಎಲ್ಲಿವರೆಗೆ ಏನಾಗಿದೆ construction?
ಇದು ರೂಫ್ ಸ್ಲಾಬ್ ಗೋಸ್ಕರ ಇದೆ
First slab
centering
ಅಲ್ಲಿ
ಹಾಕಿ.
ಇದ್ದಾರೆ.
First slab.
ಹೌದು, ಅದೊಂದು ಮುಗಿಸ್ಕೊಂಡ್ರೆ ನಾನು ಐ ಕ್ಯಾನ್ ವೇಟ್ ಫಾರ್ ದ ಫಸ್ಟ್ ಸ್ಲ್ಯಾಬ್ ಬಿಕಾಸ್ ದಿ ಐರನ್ಸ್ ಸ್ಟೀಲ್ಸ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್ಸ್ ಆರ್ ಎಕ್ಸ್ಪೋಸ್ ಟು ರೈನ್ ಅಂಡ್ ಸನ್. I can undertake. After the slab, I will not put the construction.
There is one interim order that was in force. I'll just show it to my lord. And if same arrangement could be done, my lord may kindly consider. That rejoinder at page number 39. This was the order that was there during the pendency of the suit. Pendency of the suit. It's a long drawn litigation. 1987 in the 2012 tanka, this was the order that held the field. 39, page 39. This is the order passed by this honorable court in a MFA. Regarding possession of the suit property, my lord, there is a status quo that was granted.
Any further construction? Fair enough.
Two, my lord, what they say is no further construction whatsoever. 3 is the construction that was already made has been made subject to the end result of the suit.
Correct.
These were the 3 conditions that were imposed. His vendors, maybe they told him or not, whatever be the thing.
Now
He
that
knew
you have
it.
filed an application.
Pardon?
Now that you have filed an application and he is
Yes.
notified.
He is
Let
notified.
him complete that slab portion and he will undertake that he will not put up any further construction. Subject to outcome of this.
That would be enough. Only to protect the state.
You have to be grateful to Nitesh.
Please from my childhood, please.
ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದ್ರಿ ನಾವು. Yes, come to your head. What is this? ಬರ್ಕೊಡ್ರಿ. ಎಲ್ಲಿದೆ photographs ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Please, I have produced along with my statement of objections, please.
And Nitesh's suit is dismissed ಅಲ್ಲ? As on today.
My lord, that dismissal, my lord, I'll prove that it is not at all correct. Everything is settled. Compromise ಆಗ್ಬಿಟ್ಟಿದೆ between their vendors. During the pendency of the suit, they keep selling. Very pitiable
ಇದು
situation.
ಬೆಂಗಳೂರಾ?
ಬೆಂಗಳೂರು.
ಬೆಂಗಳೂರಿಗೆ ನಿಮ್ಗೊಂದು ಬಿಬಿಎಂಪಿ ಆಕ್ಟ್ ತಂದ್ರಲ್ರಿ, ಹಂಗೆ ನಿಮ್ಗೊಂದು ಬೇರೆ CPC, ಬೇರೆ TP ಆಕ್ಟ್, ಬೇರೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಕ್ಟ್ ಎಲ್ಲ ಬೇರೆ ತಂದ್ಬಿಡ್ಬೇಕ್ರಿ ನಿಮ್ಗೆ.
My lord, I approached this court when, my lord, nothing was there. Of course, he has produced, my lord, my learned friend has produced some
That was
photographs.
in March.
I do not, my lord. Yes, that is where the notices were ordered and all those things happened.
No, that is now which slab? Slab, second slab or third slab?
ಇಲ್ಲ ಫಸ್ಟ್ ಸ್ಲ್ಯಾಬ್.
ಅಂದ್ರೆ ಇದು ಮೈನಸ್
ಬ್ಲೂ ಶೀಟ್ ಇದೆಲ್ಲ.
ಯಾವುದು?
Annexure R15.
ಓ ಅದು ಫಸ್ಟ್ ಸ್ಲ್ಯಾಬ್.
The next is the neighboring building is been constructed. There is no objection for that. They are allowing.
ಇಲ್ಲ ನಾನೇನ್ ಗೊತ್ತಾಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ. That we will take care of that.
In fact, the hand summons also served to me on 22nd June 2024 in police station when they were summoned me to the police station.
Nitesh, your client has to occasionally visit the site.
Yes,
What is
ma'am.
this?
Now, after
No, no,
this, my lord,
he has taken the
become bold.
photographs of my property, but he has failed to take the next adjoining property. That's
You are a pendant land purchaser.
pendant late purchase.
Where is the vacating?
I have filed objections to the application, please. This is the objections. Your lordships were seeing the photographs, which is the objections which I have.
But
filed.
one thing I must bring to my lord's notice, BBMP has issued him a notice to stop construction.
All right.
That is there.
That I have clarified, and I have filed this show cause notice. I have filed the reply, please, my lord.
You can take along with the slab if you succeed. And you will not claim any equity. Your response number 46.
46.
You purchased when after dismissal of the suit?
After dismissal of the
In the year 2019, he has.
2019, after dismissal.
After dismissal of the, and suit is for what? Declaration and?
Declaration.
Possession, and
Possession.
injunction.
And injunction.
And it was initially injunction suit. Trespassing, my lord, took place.
All
I
right.
lost possession. I amended the plaint.
Purporting. This court, while order dated so and so, there is an interim injunction now
Status quo order.
against these vendors.
No,
No,
no, please, no, against me.
against him.
Against status quo.
Expertina.
Expert.
This court, while order dated so and so,
19/7.
19/7, 2000.
19/7,
has
2000.
directed the parties to maintain status quo. Plaintiff, the present captioned regular first appeal is by the plaintiff, assailing the judgment and decree rendered by the trial court in OS number so and so. Plaintiff suit seeking relief of declaration, possession, and injunction is dismissed by the trial court, and an appeal is filed, and the same is pending consideration since 2012. The present respond number 46 is a pendant land purchaser. However, respond number 46 has purchased a portion of the property.
A site, my lord. in
A
this-
site, you have the site number, has purchased site number. Do you refer to, what is the property details?
145 and 145/1, site number 145
Number
and 145.
145 and 145/1,
One, please.
under registered sale dated
27/5/2019 and 16/8/2019.
19. These sale deeds are obtained by respondent number 46 after dismissal of the suit. Respondent number 46 has filed objections to the application and is seeking vacation of the interim order.
Please, ma'am.
Petitioner contains that he is a bona fide purchaser and that he has made huge investment, and in view of interim order granted by this court, serious prejudice is caused to respondent number 46. Learned counsel appearing for respondent number 46 demonstrating equities in favor of respondent number 46 would seek leave of the court at least to put a slab, as huge investment is made by respondent number 46 and the material are lying at the site and is not able to put a slab in view of status quo order granted by this court. Next, though initially learned counsel appearing for plaintiff vehemently contested and opposed any indulgence to and permit respondent number 46 to go ahead with the construction. However, Anbeka and Badala. However, this court has noticed that the trial court pending consideration of the suit had in fact refrained the defendants from proceeding with further construction over the social property, and any construction that was already made by the contesting defendants was made subject to outcome of the suit. Having examined the photographs furnished by both the parties, this court is of the view that if respondent number 46 is permitted to put up a slab pending consideration of the captioned appeal, no serious prejudice will be caused to plaintiff. However, it is made clear that respondent number 46 shall file an undertaking by way of an affidavit that he will only put a slab over the existing property, and he will further undertake that no further construction will be made pending consideration of the second appeal. With this observation, the order granted earlier stands modified. It is further made clear that in the undertaking that to be filed by respondent number 46, he shall acknowledge that no equities will be claimed in the event a plaintiff succeeds in the appeal.
Obliged.
Otherwise, there will be no respite for him. Client will be,
All the construction is exposed to sun and rain placement.
My lord, I know. Now, what happens is I
I'm also
bona
track-
fidely did not know, but he had filed the wakalat and it was not put up is what was told by me. Had I known, my lord, I would have certainly made a submission on it. So let him not be prejudiced. Pardon. Yes, my lord, please.
I understand, please, my lord, but the thing is, it was in my absence. I couldn't answer my this thing practice also. Please.
Great.
please, 7. RG Hegde.
Matter, I appear, my lord, for the respondent. LR applications could be allowed.
Appear for
I
the
appear for
appellant
respondent.
in 57, my lord.
Respondent, huh?
Sole respondent.
You appear for all the LRs.
All the LRs.
Work order. Sri Nitesh, who has appeared for, who undertakes to appear for all the legal years.
I have filed my wakalat. ma.
Not shown here. Who has filed wakalat for a legal proposed LRs of deceased sole respondent, has no objection to allow the application. Recording his statement, I 1 of 23 is allowed. Appellant is permitted to bring the proposed LRs of deceased respondent on record.
The
Counsel for
lordship may
appellant-
kindly,
Huh?
lordship may kindly.
Counsel for appellant shall carry out amendment physically and file amended cost title within a period of 2 weeks. Next. Erdrallu.
Same.
Next.
Appellant, my lord.
Yes, Mr. Reddy.
We have engaged the senior counsel, my lord, Subramanian Joyce, my
Ah.
lord. And any the tomorrow or Monday, my lord.
My lord, a date may be given, my lord.
14 matter.
ಕೊಟ್ಟಾಯ್ತು ಡೇಟ್ ಕೊಟ್ಟಾಗಿದೆ ಅಜಯ್ your name is not
Is a
reflected in-
partition.
I was handling it in my
My lord,
previous
a
office.
date may be
My
given
senior
next
will
week, my
appear.
lord, because I have filed an application for
My
temporary
first-
injunction.
Huh?
That is a different matter.
Think different matter, man.
Our previous matter ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದೀವಿ.
Previous matter.
Yes, Mr. Hegde, what do you want?
Lord, next week a date may be fixed because I have filed an application for temporary injunction.
put up
The
ಆಗಿಲ್ಲ. Date
respondent
ಕೊಟ್ಟಿದ್ದೀವಿ.
is informing me, my lord.
Date, all right, date ಕೊಟ್ಟಿದ್ದೀನಿ. Yes. Date ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes,
This
Yes,
yes,
sir.
my lord.
58, my lord, we have.
Lord,
engaged
because of
Subramanian
rain, I
Joyce,
could not
senior
come to
counsel.
court, my lord.
ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀವಿ ಬಿಡಲ್ಲ ಅವರು ಮೊಬೈಲ್ ಅಲ್ಲಿ. Yes, sir.
Serial number 58, my lord, we have engaged senior counsel, my lord, the Subramanian Joyce, my lord.
ಏನ್ ಪಾರ್ಟಿಷನ್ ಸೂಟ್?
Partition suit, my lord, it was dismissed, my lord.
Who are you? Sister,
I am the
daughter?
brother, my lord.
Uncle. My
Uncle means
uncle.
their father is father and the plaintiff are brothers. Brothers, sons are defendants.
Parties have already
Why it is dismissed? On what ground it is dismissed?
4 grounds, my lords. First, my lords, is that 1976 itself, he accepts 1.5 lakh rupees and he signs a document and he accepts. What happened is that he had signed 3 documents, 2 of which were unregistered. So because they were unregistered documents, the court said that they cannot be marked into evidence. So court told us ancillary evidence. So we produced receipts, etc., under which 1.5 lakhs has been paid. On the basis of that, the court held that yes, there is a partition, and based on the partition, that is one aspect. Second is, my lords, on the aspect that he claimed to be in possession under 35. He had valued the suit under 35(1), claiming to be in possession. Court found that I am in possession because I had filed a suit for injunction. So that is the second ground. Third ground, my lords, is on the ground of limitation, because the severance has happened as early as 1976. So that is the third ground.
109?
Huh?
109?
Yes, my lords, limitation. Yes, Article 1. So
ಯಾರು ಹಾಕಿದ್ದು earlier application?
I had filed, my lords. My lords, what has happened, my lords?
That's still stuck in 2004 and 5 matter.
My lords, I
Yeah.
know. I'm sorry, my lords. I don't want. My lords,
party pressure irutte. The difficulty, my lords, is so first trial I conducted once I became.
Alright,
So that is the reason I wanted to.
Alright, earlier application is allowed.
Huh.
List this matter in hearing on so date. Board collapse ಆಗಬೇಕು, ನೀವು ready ಇರ್ಬೇಕು.
Yes, sir. Now ready ಇರ್ತೀವಿ sir.
Please. Next.
Date ಏನೋ ಕೊಡ್ತಾ ಇರೋ ಸರ್? 27. ಸರಿ ಸರ್, 27.
ಆಯ್ತಾ? ಬ್ಲಾಕ್ ಪೆನ್ ಮಾಡ್ಬೋದಾ? ಪೆನ್ ಹಾಳಾಯ್ತು, ಪೇಜ್ ಬರಲ್ಲ.
My lords, if I may make a mention, my lords.
ಯಾಕೆ ಮಾಡ್ಬೋದಾ?
My lords. My lords, serial number 17, my lords. Senior was appearing through VC due to connectivity issues. He couldn't.
What happened? What have done?
My
Is
lords,
it urgent?
yes, my lords. Actually, there's a death in his family, so he's not in Bangalore, my lords. So, can we list it after 2 weeks, my lords? Time
17.
17, my lords. Yes.
You appear for respondent.
Yes, my lords.
Fine
It is
and
for 5. No, my lords. He's
ಆಯ್ತು.
stationed also
All right.
of Lashman.
ಏನ್ರಿ? ಯಾವ್ದು ನಿಮ್ದು? 27 59. ತಾವಿರಿ ಬರ್ತಾ ಇದೀನಿ, ಸ್ಲೋ ಆಗ್ತಾ ಇದೆ ಅದೇ. ರೆಡಿ ಅಲ್ವಾ? ತಾವು ರೆಡಿ ಇದ್ದೀರಾ? ನೀವು ರೆಡಿ ಇದ್ದೀರಾ? ಒಂದ್ ನಿಮಿಷ, ಅದೇನ್ ಪಾರ್ಟಿಷನ್ ಸೂಟಾ? ಅಲ್ಲ, ಆಲ್ ರೈಟ್. ಏನು ಬರೀ ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ಮೇಲೆ ಇದೆಯಾ? ಈಗ ಅಪೀಲ್ ಹಾಕಿದ್ ಏನಕ್ಕೆ ಅವರು? ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ತಪ್ಪಾಗಿದೆಯಾ? ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ಇಸ್ ರಾಂಗ್ ಅಂತ ಹಾಕಿದಾರಾ? ಇಲ್ಲ ಅವ್ರಿಗೆ ಶೇರೆ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರ?
ಆಮೇಲೆ ಒಂದು ಪರ್ಚೇಸರ್ಸ್
ಹಾಕಿದಾರ? ಪರ್ಚೇಸರ್ ಮೇಂಟೈನ್ ಆಗಲ್ಲ ಬಿಡಿ. ಓನ್ಲಿ ಆನ್ ಕ್ವಾಂಟಿಫಿಕೇಶನ್ ನಾಳೆಗೆ ಹಾಕೋತೀನಿ. ಇದೀರಾ? ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ? ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಪಾರ್ಟ್ ಥರ್ಡ್ ರೀ ಇದು. ಪಾರ್ಟ್ ಥರ್ಡ್ ಮೇಲೆ ಬರುತ್ತೆ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ನಿಮ್ದ ಪಾರ್ಟಿಷನ್. ಗೆಟ್ ರೆಡಿ ಅಂಡ್ ಯು ಹ್ಯಾವ್ ಟು ಕಮ್ ವಿತ್ ಅ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ. ಕೈಲಲ್ಲ, ಹ್ಯಾಂಡ್ ರಿಟನ್ ಅಲ್ಲ, ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ ಪ್ರಿಂಟೆಡ್ ಇರ್ಬೇಕು.
21 your lordship.
ಎಸ್ ಬನ್ನಿ.
ಅದೊಂದು 3 ಸಲ ಆಯ್ತು ಅದನ್ನು ಬರೋದು. 3 ಸಲ ಆಯ್ತು ಅದನ್ನು ಬರೋದು. My colleague is eager to argue before your lordship.
ಹೌದಾ? ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು?
Serial number 21, lordship.
ಹಳೆ ಮ್ಯಾಟ್ರ ಬಂದಿದೆ.
2006.
ಓಕೆ, ಅದು ತಗೋತೀವಿ. 26
21.
21.
ಓ, ಅವರ ಅಪಲೆಂಟಾ?
It's an adoption, lordship.
ಇದು ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ರಿ. ಇದು ಯಾಕೆ ಅಲ್ವಾ? ಆಗಲ್ಲ. ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಬಂಡಾರಿ. ಯಾವ ಕೊಟ್ಟಿದ್ದೀರಿ ಈಗ? ಫೈನ್ ಏನೇ, ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ದಿಸ್ ವಿಲ್ ಬಿ ರಿಪೀಟೆಡ್ ನಾವು.
ಇದು ಪಾಠ ಅಂತ ಮಾಡಿದ್ರೆ
ಇಲ್ಲ, ಅದು ಕೇಳಿಲ್ಲ. ಅದು ಕೇಳಿದ ಹೇಗೆ ಮಾಡ್ತೀವಿ?
ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಮೇಲೆ.
ಆಮೇಲೆ ಬಂಡಾರಿ ಹೋದ್ವಾರ last week I took one as partnered and asked both the councils that who argued and I took partnered. Both the lawyers disowned. I said, ನಾವು ಯಾರು ಮಾಡಿಲ್ಲ ಅಂತ. ಹಂಗಾಗ್ಬಾರ್ದು. Next Thursday ಹೇಳಿ.
Serial number 47, my lord.
Yes, sir.
After 2 weeks, it may be listed. After 2 weeks, it may be listed.
Longer date ನಮ್ಮ ಹತ್ರ ಕೇಳಬೇಡಿ, ಅಲ್ಲಿ ಕೊಡ್ತಾರ ಡೇಟ್.
With the permission of the honorable court, my lords, my colleague Mr. Ajay appeared in serial number
26th ಗ ಮ್ಯಾಟರ್ ತಗೊಂಬೋದು. 27th ಬದು 26th. That's only request.
26th all right.
26th. 27th 27 same my lords.
All right, 26.
Senior appears. I assisted him in the trial, so I said I will be involved. First matter I did in
All
the
right,
trial.
26.
much obliged, my lords.